ಕೊಡಿ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕಿ.
Mentioning from page number 11, 33 to 38, 39 to 44, 45 to 50, 51 to 57,
50 ಹಾ 53 2016 ಮ್ಯಾಟ್ರು. ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ? ಅದರ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ? ಮಾಡಿಲ್ಲ. ಮಾಡಿದ್ಮೇಲೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
58, 59 to 61, 239.
ಎಲ್ಲ 230 ಮ್ಯಾಟ್ರು ಸರ್.
List 1, non-compliance for first time, serial number 1, Ramesh MN.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದಿರಾ ಇಲ್ವಾ ಅಷ್ಟೇ ಹೇಳಿ. ಅಲ್ಲಿ ಕೊಡಿ ನೋಡೋಣ, ಆಫೀಸಲ್ಲಿ ಕೊಡಿ. ನೋಡಿ, ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಈಸ್ ಗೋಯಿಂಗ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ certified copy of re-grant order and endorsement issued by Special Deputy Commissioner, and hence registry is directed to verify and if complied, the office objection post the matter for admission.
2, Prashant VG.
For the respondent in this case, my lord.
ಆಯ್ತು. ಏನು ಎಷ್ಟಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್? 5. ಅದ್ರಲ್ಲಿ ಏನೋ ಮೇಜರ್ ಇದೆಯಾ?
Stated in the prospect of the appeal memo and agreed para. Respondent number, complete details to be stated in the prospect. Date of disposal to be stated in the IA. Copy of the order to be filed. IA 1 and 2 provision to be corrected.
ಸುಮಾರು ಇದೆಯಲ್ರಿ, ನಾಟ್ ಸಿಂಪಲ್. ಇವನ್ ಪ್ರೇಯರ್ ಪೋರ್ಷನ್ ಆಲ್ಸೋ.
My respectful submission. My lord. Last afternoon, they filed an application under 7 Rule 10 before the lower court, my lord. Earlier to that, only preliminary objections have been filed. They made a submission that objections would be filed. They are caveators over there, my lord. My respectful submission is, let them file their objections over there also, my lord. And what they have given to me regarding IA number 1 and 2.
Objections to which matter?
To IA number 1 and 2 before the lower court, my lord.
Before the lower court.
Please, my lord. And my respectful submission, even here, the copies that they have given me, under IA number 1 and 2 says order 39 Rule 1 and 2. They are seeking injunction for stay of proceedings before the lower court. And proper copies have not been submitted to me, have been furnished to me.
Proper in the sense?
Kottilla Swami. Now what has been filed before the court?
Copies ಕೊಟ್ಟಿಲ್ಲ ನಿಮಗೆ.
IA number 1 and 2, my lord.
ಇಲ್ಲ ಹಾಕಿರೋದು.
ಹೌದು
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ. ನೋಡಿ, interlocutory application under order 39 Rule 1 and 2. If that is the case, I need to file my objections to that, my lords.
Whether they have filed IAS here?
Please, my lord.
ಏನು ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ?
Hello, order 39 Rule 1 and 2 ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. That is the objection raised by the office, my lord.
That is IA number ಏನ್ರಿ?
IA number 1 swami. My lord, it is IA number 1. And it says order 39 Rule 1 and 2. And the office objections are that it is filed under the wrong provision. Now if they
comply ಮಾಡಿ, then we'll see at 2:30.
If I may make a
ಏನು
submission.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲ, ಕಂಪ್ಲೈ
My
ಮಾಡಿ.
respects, I need to file my objections. I will not seek any
Objections
day.
ಯಾವ್ದಕ್ಕೆ? Objections ಯಾವ್ದಕ್ಕೆ?
Main petition and IAS 1 and 2, my lord. Detailed objections needs to be filed. I seek for a day. If it is tomorrow, as it's a holiday, my lord, Friday. I'm prepared to file
Friday
objections.
also holiday.
My lord,
Friday also holiday.
then Monday, my lord. My respectful submission. Objection ಕೇಳ್ದಲೆ, I need to file detailed objections in this, my lord. It's a question of my life and death, my lord. Now what they are studying away my shares and they say that they've already transferred, it is not sold.
Let him first comply, then
Please.
we will see at 2:30.
Please, my lord.
Because once you have filed the caveat,
2:30. Please, my lord.
you also must be ready.
My lord, I am ready, but nenne madhyana serve ಮಾಡಿದ್ದಾರೆ. They have had enough time, my
No,
lord.
my lord, I'm sorry.
All I am seeking is a day's time. my lord.
ಆಯ್ತು 2:30.
Please, my lord. Much obliged.
I'll just take the file, my lord, and comply with it.
Second
Totally
time
there.
Let them be directed to furnish proper copies.
ಕಂಪ್ಲೈ ಮಾಡಿದ್ದು ಏನಿದೆಯೋ ಅದನ್ನ ಕೊಡಿ ಅವ್ರಿಗೆ.
Please. Much obliged.
Second time non-compliance, serial number 3, D. Prabhakar.
For caveat, I responded number 7 in this
Hmm.
case, my lords.
Second time. Compliance ilva? Tole. Appellant counsel is absent and hence 1 week time given to comply with office objections.
Please,
And post the
objection.
matter after the compliance.
Third time non-compliance. Serial number 4. Chaitra K.
Appellant counsel is absent. ನೀವ್ಯಾರಿಗೆ ಈ ಕಡೆಗೆ ಬನ್ನಿ.
ಈ ಕಡೆ ಬಂದು.
Council seeks 1 week time, finally 1 week time granted. Third time ಬಂದಿದೆಯಲ್ರಿ compliance ಗೆ. How many times matter has to be posted before the court for compliance?
Went for last time, Maharaj.
ಹಾ? ನಮ್ಮ ಮುಂದೆ ಫಸ್ಟ್ ಟೈಮ್ ಆಯ್ತು, ನಮ್ಮ ಮುಂದೆ ಆದ್ರೂ ಅಷ್ಟೇ ಅಲ್ಲಾದ್ರೂ ಅಷ್ಟೇ ಕಂಪ್ಲೇಂಟ್ ಸಿಗ್ತಾನೆ. ಆಯ್ತು, 1 week time granted finally and post the matter after the compliance. ಮತ್ತೆ ಪೋಸ್ಟ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಕಂಪ್ಲೈ ಮಾಡಿದ್ಮೇಲೆ ಪೋಸ್ಟ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್
Serial number 5.
5
Orders matter execution.
memo for withdrawal of appeal.
Yes, sir.
Hmm.
I have filed memo, my lord, for withdrawal.
Hmm.
In so far as MFA number 7818 of 2015, your lordship.
Hmm.
Another case, I will proceed with the.
ಒಂದು ಮಾತ್ರ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು.
ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಶುರು ಮಾಡಿದೀರಾ?
No, I haven't received any copies. my lord.
Withdrawal.
ವಿಡ್ರಾಯಲ್ ಅದೇ ಏನ್ ರೀಸನ್ ಏನು?
Reason, my lord, I have stated so, my lord, in para.
ಏನೋ ಮೆಮೊ ಬಹಳ ಒಂದು ಪೇಜ್ 2 ಪೇಜ್ ಇದ್ದಂಗೆ.
ಅದು ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ
ಸೆಟ್ಲ್
ಹೇಳ್ಬಿಟ್ಟು.
ಆಗಿದೆಯಾ?
ಹೌದು, ಅದಕ್ಕೋಸ್ಕರ.
ಆಯ್ತು ನೋಡಿ.
I haven't
ಕಾಪಿ
received copies, my lord.
ಕೊಡ್ಬೇಕಲ್ರಿ?
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ.
ಮತ್ತೆ
ವಿಡ್ರಾಲ್
ಕೊಡಿ.
ವಿಡ್ರಾಲ್ ಅಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಕೊಟ್ಟಿಲ್ಲ. I will give the.
ವಿಡ್ರಾಯಲ್ ಆದ್ರೂ ಕೊಡಿ ಒಂದು ಕಾಪಿ. ನೀವ್ ಏನ್ ಹೇಳಿದಿರಿ ಅನ್ನೋದು ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ.
I'll collect it later, my lord.
Huh?
I will file we'll just see that, and the other matter will seek some time, my lord. If
Huh.
he's pursuing with the other matter.
ಇದನ್ನ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಅಲೋ ಮಾಡ್ಬೇಕು?
Yes, my lord.
ಮಾಡ್ಬೋದಾ?
Yes, yes.
ತಗೊಳ್ಳಿ. The appellant counsel files memo seeking permission of this court to withdraw the appeal as stated in memo. And counsel for the respondent also says no objection to withdraw the appeal and hence permitted to withdraw in terms of the memo.
Gratefully.
The registry is directed to delink the other appeal and list the matter for the admission ಆಗಿಲ್ಲ ಇನ್ನು?
ಇನ್ನು
List the matter for admission on 5.1 ಇದೆಯಲ್ಲ ಅದು?
7819.
2411
Yes, sir.
ಅಲ್ಲ 2410.
Yes, sir.
2410. My lord,
2410.
after 26, my lord, I'm not there in station.
ಆಯ್ತು ಕೊಡಿ. After 26 ಅಂದ್ರೆ.
30th.
30th, ideal, my lord.
Serial number 6. Gurraj R. ಒಂದ್ಸತಿ ಹೋಗಿ insufficient address ಅಂತ ಇದೆ.
And for the applicant, my
Hmm.
lord, 1 week time may be
1
granted.
week time.
Yes.
The appellant counsel seeks 1 week time to furnish press steps,
Please.
press PF and and copies. If the same is furnished within 1 week, issue notice to R1. ಬಾಕಿಯವ್ರಿಗೆಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಲ್ಲ? R1.
7. R. Nagendra Naik.
Hearing for the petitioner, my lords,
Hmm.
there are a few office objections. We'll comply with the same.
Will comply the office objections.
We'll comply with the office objections, my lords.
Counsel ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ?
My lords, within,
ಏನ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಇದೆಯಲ್ರಿ? ಇಂಪೌಂಡ್ ಸರ್ವೆ ನಂಬರ್ ಟು ಬಿ ಫರ್ನಿಶ್ ಟು ವೆರಿಫೈ ಡೇಟ್ಸ್ ಅಲಾಂಗ್ ವಿತ್ 12% ಅಡಿಷನಲ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಅಂತೇನೋ ಇದೆ.
my lords, it's ready. We're,
ಆಯ್ತು ಬಿಡಿ, ಅವ್ರೇನೋ ಕಂಪ್ಲೈ ಮಾಡ್ತಾರಂತ. Council seeks 1 week time to comply with office objections and hence 1 week time granted as sought.
much obliged.
One copy may be served to government.
ಕಾಪಿ
Serve ಮಾಡಿ.
ಶುರು ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದ್ದಾರೆ, ಅದೆಲ್ಲ ಸಿಕ್ಕಿಲ್ಲ ಅದಕ್ಕೆ.
ಎಲ್ಲಿ ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಎಷ್ಟು ಸರಿ ಕೊಡ್ತಾರೆ?
ನಾವು ಜೆರಾಕ್ಸ್ ತಗೊಳ್ತೀವಿ.
ನೀವೆಲ್ಲ ಸರ್ವ್ ಮಾಡ್ದಂಗೆಲ್ಲ ಕಳಿತಾ ಇದ್ರೆ ಅವ್ರ್ಯಾಕ್ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕು?
23 ಮ್ಯಾಚ್ ಜೆರಾಕ್ಸ್ ತಗೊಳ್ತೇವೆ. ಒಂದ್ ಕೊಟ್ರೆ
My lords, we are already
Copy
served
ನಿಮ್ಗೆ
one
file
copy
ಮಾಡಿದ್ರೆ
last.
ಸರ್ವ್ ಮಾಡಿದಿರಾ?
ಕೊಟ್ಟಿರ್ತಾರ.
We've
ಮಾಡಿದ್ರೆ ಒಂದ್ ಕಾಪಿ ಕೊಟ್ರೆ ಸರ್, ನಾವು ಜೆರಾಕ್ಸ್ ತಗೋತೀವಿ.
ನೀವು ಫಸ್ಟ್ ಯು ಮೇಕ್ ಯುವರ್ ಅಫಿಷಿಯಲ್ಸ್ ಇನ್ ದಿ ಆಫೀಸ್ ಮಸ್ಟ್ ಬಿ ವಿಜಿಲೆಂಟ್. ಒಂದ್ಸರಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಫೈಲ್ ರೆಡಿ ಮಾಡಿ ಇಟ್ಬಿಡ್ಬೇಕು. ನಿಮಗ್ ಬಂದಾಗ ಲಿಸ್ಟ್ ಆದಾಗ ಕೊಡ್ಬೇಕು ಅವರು. ನೀವು ಪ್ರತಿ ಸರಿ ಇಲ್ಲಿ ಬಂದು ಕಾಪಿ ಕೇಳಿದ್ರೆ ಅವ್ರಿಗೆ ಎಷ್ಟು ಸರಿ ಕಾಪಿ ಕೊಡ್ತಾರ ಅಲ್ವಾ? ಸರ್ಕಾರಿ ಆಫೀಸ್ ಅಂದ್ರೆ ಹಂಗೆ ಅಂತ. ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ, ಇನ್ನೊಂದು ಏನೋ ಕಾಪಿ ಬೇಕಂತ ಕೊಡ್ರಿ.
Today, by today, I'll give it.
ಆಯ್ತು, ಓರಲ್ ಅಷ್ಟೇ.
8. Prakash MD BV.
ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ವಕಾಲತ್ ಫೈಲ್ಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಮೊದ್ಲೇ ಹಾಕಿದಾರ? ವಾಲಂಟ್ರಿ ಹಾಕಿದಾರ? ಆಯ್ತು, ವಕಾಲತ್ ಈಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ಏನಾಗಬೇಕು?
Attachment ಗೆ ಆಗಿದೆ.
ಮಾತ್ರ ಆಗಿರೋದು. 2 and 3.
ಒನ್ಗ 2 and 3 ಇದಾರೆ.
Correct.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ 2 and 3 ಗೆ.
Not,
Huh?
they are both for execution, not for attachment.
Huh?
They are both for execution.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾರ.
ಹಾಕಿದ್ದಾರೆ.
ಹಾ.
Attachment ಗೆ ಇದು stage.
Admit ಆಗಿಲ್ಲ.
ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರ್ಬೇಕು ಇದು. ನೀವು ಫಸ್ಟ್ ಟೈಮ್ ಒಕ್ಕಲ ತಕೊ ಬಂದಿದ್ರಿ, ಇವತ್ತು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದೀವಿ.
ಇಲ್ಲ, ಬೇರೆ ಎರಡ್ ಮೂರ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಇತ್ತು.
ಬೇರೆ ಇದೆಯಾ?
ಹೌದು, ನಾನು ಅದ್ರ ಒಟ್ಟಿಗೆ
ಟೋಟಲ್ ಮೂವ್ ಮಾಡಿರೋದು ಅವ್ರೇನೆ.
ಅವರೇ ಮೂವ್ ಮಾಡಿ.
ಅದೇ
2 and 3 ಯಾರು ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಅಥವಾ ನೋಟಿಸ್?
ಇಲ್ಲ, ಒಬ್ರಿಗೆ ಮಾತ್ರ.
ಒಬ್ರಿಗೇನೆ.
ಹೌದು.
ಏನ್ರಿ ಅರ್ಜೆನ್ಸಿ ಏನು?
execution move ಮಾಡಿದ್ರು ಸ್ವಾಮಿ, attachment ಗೆ. Kindly pass on.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕು.
ಪಾಸ್ ಅವ್ರು ಬೇಡ, ನೀವು ಮಂಡೆಗೆ.
ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕೋಣ ಬರ್ಲಿ. ಆಯ್ತು, ಒಂದು ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಟ್ಯೂಸ್ಡೇ
ಗ್ರೇಟ್ಫುಲ್.
ಫಾರ್ ಅಡ್ಮಿಷನ್.
9.
ಆನಂದ್ ಬೀರಣ್ಣನವರ್. Council submission ಏನೈತೆ? Value of the appeal to be mentioned exactly in the appeal as per court order dated 29/24. ಇಲ್ವಾ?
Respondent, my lord.
So appellant counsel is
Similarly-
absent and hence directed to comply with office subjection within 1 week and post the matter after the compliance.
ಇದರಲ್ಲಿ the court fees jurisdiction.
ಅದಕ್ಕೇನೆ ಕಂಪ್ಲೈನ್ಸ್ ಗೆ ಬರ್ದಿದ್ದೀನಿ, ಒಂದ್ ವಾರ ಆದ್ಮೇಲೆ ಬರುತ್ತೆ, ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ಬರುತ್ತೆ.
Serial number 10.
Not
Purushottam.
below cast title with regard to defend number 1 and her LRs.
My lord, the impugn order, my lord, defendant number 1 is the mother is expired, which has been brought to the before during the pendency of the suit. The plaintiff filed a memo brought to the notice of the honorable court, my lord. Since the legal aids are.
Note is accepted. Note below the cast title is accepted. Post the matter for admission. Urgency ಇದೆಯಾ ಏನು?
Also.
This matter
ಇದೆ.
next week. Date ಕೊಡಿ, ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ.
25.
25/10.
11.
Memo for dispensation of notice to R1.
R1 has sold the property to R2 and R3. Last time we had submitted. The file. So far as injunction is
ಆಯ್ತು,
concerned.
memo for dispensation against R1 is filed and the same is accepted at the risk of the appellant. ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
Can be taken up on Monday or on Wednesday minutes.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ,
Request.
ನೀವೇ ಹೇಳ್ಬಿಡಿ.
Monday or Wednesday.
Monday.
ಮಂಡೇ ನೋ ಸಿಟ್ಟಿಂಗ್, ನೆಕ್ಸ್ಟ್ ಹೇಳ್ರಿ.
Wednesday minutes, Tuesday
Wednesday.
tomorrow.
This matter on Wednesday, madam, 23rd,
23/10.
23/10.
Please minutes.
Serial number 12. Jayasima KP.
Furnishing of
Paper
PF
appellate,
correct
my
address.
lordship. Appear for appellant, my lordship.
PF ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
Matter is most urgent, last date of the occasion. Last occasion, my lordship, released on this day.
ಸರಿ ರೀ, PF ಕೊಡ್ಬೇಕು ಅಂತ ಇದೆ, PF ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? 9/10 ಅಲ್ಲಿ ಏನಾಯ್ತು ಆರ್ಡರ್? ಇಶ್ಯೂ ನೋಟಿಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಗಿದೆ, PF ಕೊಟ್ಟಿಲ್ವಲ್ಲ ನೀವು?
ಸ್ವಾಮಿ, released ಅಂದ್ಕೊಂಡು ತಿಳಿದೆ, ಅದು
ಈ ಲಿಸ್ಟ್ ಅಂತಿಲ್ಲ, ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ, PF ಕೊಡ್ಬೇಕು. ಕೊಡಿ ಇವತ್ತು.
ಕೊಡ್ತೀನಿ. The matter is most urgent, my lordship. The matter is most urgent.
ಅರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ರೀ, ನೋಟಿಸ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ಲ. ನೀವು PF ಕೊಟ್ಟಿರಿ, ಇಷ್ಟೊತ್ತಿಗೆ ನೋಟಿಸ್ ಹೋಗಿರೋದು. ಕೌನ್ಸಿಲ್ 6 ಇವತ್ತೇ ಕೊಡ್ತೀರಾ ಏನು?
ಇವತ್ತೇ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
The council submits that he is going to furnish the PF today itself.
Short
PF
accommodation.
furnished,
3-4
issue
days
notice against respondent
by handsome.
and also permitted to take out the hand summons against the respondent.
Respondent counsel
Respondent counsel.
in trial court.
ಕೌನ್ಸಿಲ್ ಕೆಲವು ಟೈಮ್ ಕೌನ್ಸಿಲ್ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಬರಲ್ಲ, ಅವಾಗ ಏನ್ ಮಾಡ್ತೀರಿ? ಪಾರ್ಟಿಗೆ ತಗೊಳೋದು ಬೆಟರ್ ಅಲ್ವಾ?
ಆಗ್ಬೋದು ಸರ್.
ನೋಡಿ ಅಂತ ರೆಸ್ಪಾಂಡೆಂಟ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 30/10.
Oblige, my lordship.
30. PM Sidmalappa.
My lordship. Short accommodation, my
ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್.
my lordship.
ಅಕ್ಕಲತ್ತಲ್ಲಿ
accommodation.
ನೇಮ್ ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಸರ್.
ಹಾ,
My lordship,
ಯಾವ್ದ್ರಲ್ಲಿ?
Short accommodation.
PM
Tollu.
Sidmalappa ಅವ್ರು ಹಾಕಿರೋ ವಕಾಲತ್ತಲ್ಲಿ.
ಹಿಂದಿಂದ್ರಲ್ಲಿ?
Toll, ಹೌದು sir.
ಹೌದು, 30 ಹೊತ್ತು ಕೊಟ್ಟಿದ್ದೀವಿ, ಅದೇ ಶಾರ್ಟ್.
Short.
ಇನ್ನೇನ್ ಶಾರ್ಟ್ ಬೇಕ್ರಿ?
It is most urgent.
ಆಯ್ತು, ನೀವ್ ಯಾವಾಗ ಸರ್ವ್ ಮಾಡ್ಕೊ ಬರ್ತೀರಿ ಹೇಳಿ?
ಸರ್ವ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಮಾಡ್ತೀರಿ
3-4
ಹೇಳ್ರಿ? 25th,
25th.
25/10.
Oblige.
ಇದ್ಮಲ್ಲಪ್ಪ ಹೇಳ್ರಿ, ಅಬ್ಜೆಕ್ಷನ್ಸ್.
Comply, my lord.
Huh?
Kindly grant a week time, we will comply.
ವೀಕ್ಸ್ ಟೈಮ್ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳ್ರಿ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ?
Comply, my lord.
ಯಾವ್ದು ನೀವು ಸೀರಿಯಲ್ ನಂಬರ್ 13 ನೀವೇನಾ?
30.
ಹಾ?
Non-compliance, ವಕಾಲತ್,
ಅದೇ ರೀ, ಎಷ್ಟು ದಿವಸ ಬೇಕು ಅಂತ ಕೇಳಿದೆ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ?
1 week, my lord.
ಹೊಸಬ್ರ? ಎಷ್ಟು ದಿವಸ ಆಯ್ತು?
3 months.
3 months. ಮತ್ತೆ ಇನ್ನೇನು? ಆಯ್ತು, 1 week time granted to comply with office objections.
14.
Issuance of court notice to A1, B and C with order dated 4/9/23. Ramatullah for appellants is no more. Yes, madam.
Will file Wakalat, my lords, legal service authority matter.
Wakalat for whom?
A1.
ಸರ್ ಮೊದಲು ರಹಮತುಲ್ಲಾ ಶರೀಫ್ ಅಂತ ಇದ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಇವರು ಅಂಡರ್ಟೇಕ್ ಮಾಡಿ
Ramatullah Sharif are advocate ಏನ್ರಿ? ಹಾ, ಆಯ್ತು. ಹಾ. ವಕಾಲತ್ಗೆ ಏನ್ ಮತ್ತೆ ಟೈಮ್ ಬೇಕಾ? ಯಾವಾಗ ನೀವು ಅಂಡರ್ಟೇಕ್ ಮಾಡಿರೋದು? 4/9/23 ನಾ? Non-filing of having served copy of the documents by advocate for respondent by order dated
I have
27/9/23.
given the entire, I have given entire, report. She has taken the Xerox copy, written the file, my lord.
ಹಾ.
Thereafter, she filed the NOC of that.
My lords,
Again, the
legal-
party has come out, we can't wait to give
ಎಷ್ಟು
the.
ದಿವಸ ಬೇಕು ಮೇಡಮ್?
2 weeks time.
Huh?
2 weeks time.
Counsel Satish K for appellant number 1 seeks 2 weeks time to file wakalat. ಇಲ್ಲಿ ಯಾರು ಮತ್ತೆ ಬೇರೆ ಯಾರು ಇದ್ದಾರೆ? ಅದು A1A ಅದು.
A1
C and B and C ಯಾರು ಇದಾರಲ್ಲ? ರಾಜ ಅದೇನ್ ಪಾರ್ಟೀಸ್ ನೇಮ ಮೇಡಮ್ ಇದು?
ಅದು ಪಾರ್ಟೀಸ್ ನೇಮ್ ಸರ್.
ಏನಾಯ್ತು?
ಅವ್ರಿಗೆ
ಕೋರ್ಟ್
court
ನೋಟಿಸ್
notice
ಇಶ್ಯೂ ಟು
issue ಆಗಿದೆ.
ಏನಾಗಿದೆ ಆಯ್ತು? ಅದೇನಾಗಿದೆ ಮೇಡಮ್?
ಅದೇನು ಬಂದಿಲ್ಲ ಸರ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್.
ಯಾವಾಗ ಕಳ್ಸಿರೋದು? ಇಶ್ಯೂ ಆಗಿರೋದು ಯಾವಾಗ?
ನೋಡ್ಬಿಟ್ಟು ಹೇಳ ಸರ್ ಲಾಂಗ್ ಬ್ಯಾಕ್ 23 ನಲ್ಲೇ ಆಗಿದೆ.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ನೋಡಿ ಹೇಳಿ. ಪಾಸ್ ಓವರ್ ಫಸ್ಟ್ ಕಂಪ್ಲೀಟ್ ಮಾಡೋಣ.
Much.
ನೋಟಿಸ್ ಏನಾಗಿದೆ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ರೀ ಇಶ್ಯೂ ಮಾಡ್ತೀನಿ.
Yes.
ಯುವರ್ ಪ್ರೆಸೆನ್ಸ್ ಇಸ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಇನ್ ದಿ ಆಫ್ಟರ್ನೂನ್.
Much.
15 ಏನ್ ವಿಜಯ್?
ಶನಿವಾರದ ಒಳಗಡೆ ಪ್ರಾಸೆಸ್ ಕಟ್ತೀನಿ. ಟೇಕ್ ಸ್ಟೆಪ್ ವಿತ್ ಇನ್ ದಿ ಸ್ಯಾಟರ್ಡೆ.
ಸಾಟರ್ಡೇನಾ?
ಶನಿವಾರದ ಒಳಗಡೆ ಪ್ರಾಸೆಸ್ ಕಟ್ತೀನಿ. ಅಡ್ರೆಸ್ ಅಸರ್ಟೈನ್ ಆಗಬೇಕಾಗಿತ್ತು.
The council seeks 3 days time to verify and furnish the correct address.
Please.
And if furnished, issue notice against R1 A to C.
Please.
ಹೌದಾ?
ಹೌದು.
ಅಷ್ಟೇನಾ?
16
Non-taking of steps in respect of deceased R3 with order dated 7/2/24. Third,
ಎಂಜೆ
Appellant-
ಆಳ್ವಾ?
appellant counsel is absent and steps not taken in spite of order was passed on 7/2/24 in bringing the LRs of deceased R3 and hence the appeal is abated against R3. Final hearing, post the matter for final hearing on 29/10.
17 ಸಂತೋಷ್ ಎಸ್ ಗೋಪಿ.
Memo for reporting death of R18.
I appear for respondent number 19, Swami. I appear for respondent number 19.
Regard to R18, my lord, I request for a week's time to take steps with regard to
Appellant counsel seeks weeks time to bring the LRs of R18.
R18.
ಹೌದಾ?
With regard to R10, we have already filed application, my lord.
Already filed.
Yes, my lord.
ಎಲ್ಲಿದೆ ಅದು?
ಇಲ್ಲಿದೆ ಸರ್
ಇದೇನಾ? A1/24, 2/24, 3/24 ಹೌದಾ?
ಹೌದು.
Issue notice against LRs of R10 on IA number 1/24, 2/24, 3/24. Yes.
Obliged.
18 ರಾಜೇಶ್
Malad, serial number 18, I appear for the appellant. Malad, sir, to take steps against R1. Malad, I request for 1 week's time. Malad.
Madam, 5/2/24 order ಆಗಿರೋದು. Till
Please,
date you have
Malad,
not taken steps. Sorry.
Please, Malad, she couldn't
Not take-
contact
The
the.
appellant has not taken steps against the deceased R1 in spite of void order dated 5/2/24 and hence appeal against R1 is abated in both the matters.
90
2008 matter ಒಂದೊಂದು ವರ್ಷ ಆದ್ರೂ steps ತಗೊಳಲ್ಲ.
90
Non-taking of steps in respect of deceased appellant number 2 by council with order dated 30/6/23. ಇದು ಅಷ್ಟೇ. The appellant counsel is absent and not taken steps in bringing LRs of appellant number 2 and hence appeal of the appellant number 2 is abated.
20
And post the matter for final hearing on 28th working 28/10. ಮೇಲ್ಗಡೆದಷ್ಟೇ ಮೇಡಮ್ 28/10 ಎರಡನ್ನು ಇಲ್ಲ ನಾನು ಬರೋದೇ ಇಲ್ಲ. 2008 matters. Next 20
I appear for the appellant.
Hmm.
I had filed the power for the appellant.
appellant
ಹಾ.
ಕಾಸ್ಟ್ ಯಾರು ಕಟ್ಟಬೇಕು? 500
Cast I had to pay, my lord. I had to cast has been
ಕಟ್ಟಿದ್ದೀರಾ?
cutting. Deedful has been done.
ಯಾವಾಗ?
Today, yesterday,
The council submits that he has paid the cost of rupees 500 yesterday.
And steps also be taken by,
Steps ಯಾರಿಗೆ ಇಲ್ಲಿ?
matter has been dismissed for non-prosecution.
ಅಲ್ಲ ಯಾವಾಗ ತಗೊಳ್ತೀರಿ steps?
Steps already, today I had.
ಅಲ್ಲ ಫಸ್ಟ್ recall ಆಗ್ಬೇಕಲ್ಲ ಆರ್ಡರ್.
Recall has been ordered subject to payment of cost.
ಓ ಕಾಸ್ಟ್ ಒಮ್ಮೆ ಅದ್ರ ಮೇಲೆ ಆಲೋ ಆಗಿದೆ. ಈಗ ಮತ್ತೆ PM ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
I had taken the steps to the respondent.
Already taken?
Now today morning I had taken.
And council submits that he has taken steps against, Notice already order ಆಗಿದೆ. Council submits that he has already paid the PF and hence issue emergent notice against the respondents as ordered with order dated 2/8/24.
21.
RP. Ajit A. Shetty.
My lords, R2, my lords, is already represented by learned counsel, Mr. Brijesh Patil. He has been served a copy.
ಕಾಪಿ ಸರ್ವ್
We
ಮಾಡಿದೀರಾ?
have filed. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಮೆಮೋ ಅಲ್ಲಿ we have
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಅವ್ರೇನು ವಕಾಲತ್ ಹಾಕಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ. But
ಮತ್ತೆ?
we have served a copy, my lords, on the 10th of July 2024. We have filed a memo also. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ by mistake instead of R2, we have shown him as the counsel for R1A, which was his status in the miscellaneous first appeal. So lordship may kindly hold service sufficient on R2, my lords. So far as the other respondent,
ಕೌನ್ಸಿಲಿಂಗ್ ಸಬ್ಮಿಷನ್ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಹೆಂಗ? How can the court can
I'll request him to appear on next day.
unless he appears before the court?
I'll
ನೀವು
request him.
advocate ಸರ್ವ್ ಮಾಡ್ತೀರಿ, he doesn't want to come and make submission before the court.
No, I'll ensure he,
ನೀವು ಪಾರ್ಟಿಗೆ ಸರ್ವ್ ಮಾಡಬೇಕಾಗ.
R2, so far as the other response form,
ಹಾ.
9ರಿಂದ 14,
ಹಾ.
notices were dispensed upon them even in the first appeal. Because they
First
are not.
appeal ಅಲ್ಲಿ dispense ಆಗಿದೆಯಾ?
ಆಗಿತ್ತು.
You file a memo
I'll
before.
file him.
ಹಾ.
I'll file him.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ?
ಆಯ್ತು.
ಪಾಸ್ ಓವರ್.
Great.
21 passing. Hearing on IA 22.
Petitioner, my lords.
Non filing of an affidavit by advocate.
1 week
for
time may
petition
be
of-
granted
Ah.
in my line.
ಏನ್
Meantime,
affidavit
lords,
ಇದು?
please, for the same direction and claiming of the amount, execution petition is already filed by the respondent.
The appellant counsel, the petitioner counsel seeks 1 week time to file affidavit.
Please.
ಹೌದಾ?
Please,
With order dated 15/6/24.
much.
ಅಲ್ಲ ರೀ, ಆರ್ಡರ್ ಆಗಿರೋದು ಜೂನ್ ನಲ್ಲಿ.
In fact, my colleague was in charge. Today he has not come. I had no
ಆಯ್ತು.
knowledge. Sorry.
ಆಯ್ತು. List this matter after 1 week. ಕೊಡಿ ಡೇಟ್ ಕೊಡಿ. 24/10.
23, Krishnamurthy D.
I appear for appellant, my lords.
Counsel.
In this case, my lords, in the connected appeal, my lords, service is awaiting for R6. And in the first appeal, my lords, postal track shows that he is served, my lords. That is an endorsement in the cause list, my lords.
ಫಸ್ಟ್ ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆಯಾ? against whom?
Respondent number 6, my lords. C. Pradeep.
R6 ಸರ್ವ್ಡ್ ಅಲ್ಲ, postal track.
ಹೌದು ಹೌದು ಇದರಲ್ಲಿ await service ಅಂತ ಇದೆ connected.
ತಗೊಳ್ಳಿ. In MFA 5110 up to 2024, postal track discloses that notice has been served against R6 and hence held sufficient against R6 and await service of notice of R6 in connected matter. List this matter on. ಅದ್ರಲ್ಲಿ await ಇದರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಂತ.
ಹೌದು.
Postal track ಬಂದಿಲ್ಲಲ್ಲ. Await service of notice of R6. ಮೇಲ್ಗಡೆ ಅದ್ರಲ್ಲಿ ಆಗಿದೆ ಮೇಡಮ್, ಹೆಲ್ಡ್ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಮಾಡಿದೆ. ಸೇಮ್ ಇರ್ಬೋದು, ಬಟ್ ಇದ್ರಲ್ಲಿ ಒಂದೊಂದು ಹೋಗಿರೋದು ಅವೈಟ್ ಅಂತಿದೆಯಲ್ಲ, ಅದಕ್ಕೆ ಅವೈಟ್ ಅಂತ ಮಾಡಿದ್ದೀನಿ. ಅವೈಟ್
Date may be fixed, my lords.
30/10.
Please,
ಅಷ್ಟೊಳಗೆ ಬರುತ್ತೆ ನೋಡೋಣ.
please.
24,
24.
Ajit A. Shetty.
Lords, the application may not survive for the reason, my lords, that I had sought dispensation of production of a
ಆಲ್ರೆಡಿ
certified.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
ಅಲ್ಲ, so ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, that is an order passed on an application filed under order 26 rule 9 and 10. So where, my lords, I had sought liberty to file a separate writ petition because an appeal may not be maintainable on that order.
ಈಗ ಆಲ್ರೆಡಿ ಅದಾಗಿದೆಯಾ?
Writ ಹಾಕ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ಈ ವಾರದಲ್ಲಿ ಹಾಕ್ತಾ
ಹಾಕ್ತಾ
ಇದೆ,
ಇದೀರಿ.
ಇನ್ನು ಹಾಕ್ಬೇಕು. Now, so far as this appeal is concerned, my lords, it is filed, my lords, questioning the orders passed on two applications, both, my lords, filed under order 39 rules 1 and 2. One by the plaintiff, which has been allowed, and the other application by the defendants, which has been rejected. So a common appeal is filed against a common order. So the matter, my lords, he has to be heard on admission.
When do you want? Admission.
Common appeal, of course, left to my learned friend, common appeal may not be maintainable. IA 1 was by the plaintiff for
ಕಾಮನ್ ಅಪೀಲ್
injunction.
ಕಾಮನ್ ಅಪೀಲ್ ಇಲ್ಲ, ಈಗ ಒಂದೇ ಬಂದಿರೋದು.
ಇಲ್ಲ, IA number 2, common order na challenge ಮಾಡ್ತಾ ಇದ್ದಾರೆ. IA number 2 was an application filed by the defendant seeking injunction. Therefore, he may,
that was
that has been rejected.
Hmm.
Therefore, he may have to prefer another appeal.
Hmm.
Of course, it is left to him.
Common order, my lord, so anyway, I'll make my submissions, my lord, so Tuesday, if my lords were subject to a lordship.
I post the matter on 23rd
Grateful.
25,
at the request of the appellant ಅಂತ ಹಾಕ್ಬಿಡಿ.
Appellant ಮೇಲೆ.
25, Anand V.
Permission to prosecute ಹೇಳ್ರಿ ಏನು?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವಿ ಆರ್ ನಾಟ್ ದಿ ಪಾರ್ಟೀಸ್. ದಿ ರೆಸ್ಪಾಂಡ್ fraudulently without making party. He filed a P&SC and get the probate order. By showing that the testator has no issues because the appellants are the children of testator.
ಆಯ್ತು, ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ ನೋಡೋಣ ಈಗ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ.
ಅಲ್ಲ until because he already applied for transfer of khata with an intention to sell the property. Without making us as a parties before the trial court, he getting the just like
ನೀವ್ ಇಶ್ಯೂಸ್ ಇದ್ದಾರ?
issues either. 3 wives, Venkatagiriyappa has 3 wives. Appellants are the
3 wives, how many children?
4 children. 4 children. I produced the document that is page number 40 and 41. Vamsharuksha Padi, 41. Page number 41. 41 rule 27 I produce production.
Page number ಹೇಳ್ರಿ 41 page ಅಲ್ಲಿ ನೋಡ್ರಿ ಇರೋದೇ 26 ಪೇಜ್ ಅಲ್ಲ ಪಿಟಿಷನ್ ಅಲ್ಲಿ.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಐ ಹಾಕಿದೆ ಸಪರೇಟ್ ಐ ಫೈಲ್ 41 rule 27
ಸಪರೇಟ್ ಹಾಕಿದೀರಾ?
ಸಪರೇಟ್ ಆಗಿ
38 ಏನು ಅಫಿಡವಿಟ್ ಹಾಕಿದೀರಾ?
41 page number. Venkatagiriyappa, first wife has no issues. Second wife having 2 children and third wife have 2 children. These are the appellants hearing. Kindly turn the judgment, Your Honor. Judgment at page number, trial court judgment, page number 12. The respondent is the brother son of Venkatagiriyappa. Page number 12 only. During his lifetime,
Heard the appellant counsel on IA number
second 3 and
2 of 24, wherein prayed this court to stay the impugned order passed in P&SC number 66 of 24, dated 7/8/24, and counsel would submit that the respondent suppressing the true fact obtained the order stating that there are no issues. The counsel also brought to notice of this court the affidavit and also genealogy of Venkatagiriyappa, who had 3 wives, and through the second wife and third wife having issues, and they are the appellants hearing. And also making an attempt to transfer the property based on the order passed by the trial court and for the reasons stated in the accompanying application and affidavit. Stay is granted till the next date of hearing. Issue notice against the respondents on main as well as IAS. On IAS. PF ಕೊಡಿ immediate. PF ಕೊಡ್ಲಿಲ್ಲ next time vacate ಆಗುತ್ತೆ ಆರ್ಡರ್. Tomorrow ರಜಾ, ಇವತ್ತೇ ಕೊಡಿ. Paper publication.
I appear for the appellant in this matter. I have filed IA number 1/24 to take notice in respect of unserved respondents number 1A, C and D.
ಯಾವ್ದು ಪೇಪರ್ ಯಾವ್ದು?
ಕನ್ನಡ ಪ್ರಭಾ.
ಮೊದಲೆಲ್ಲ ಹೋಗಿ ಬಂದಿದ್ಯಾ?
ಮೊದಲು 2 ಸಲ ನೋಟಿಸ್ RPID ಇವಾಗ ಅನ್ಸರ್ಡ್ ಬಂದಿದೆ.
ಆಯ್ತು, heard on IA number 1 of 24 wherein prayer is sought to issue paper publication in respect of R1A, C and D. And for the reasons stated in the accompanying application and affidavit, IA is allowed and permitted to take out the notice against them in Kannada Prabha.
ಹೌದು ಸರ್.
Kannada Prabha,
ಬೆಂಗಳೂರು edition.
Bangalore edition on or before
4/11.
4/11. And date is fixed for the appearance on 5/12.
In connected matters, ಅದ್ರ ಇನ್ನೊಂದು connected matter ಇದೆ.
ಅದ್ರಲ್ಲೇನು?
In respect of respondents number 2B and
R2, B and C ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್. ಅದು
Same
ಸೇಮ್
date.
ಅಲೌಡ್, ಸೇಮ್ ಪೇಪರ್,
ಹೌದು ಸರ್.
ಎಲ್ಲ ಸೇಮ್ ಪೇಪರ್.
Same date.
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಮಾತ್ರ ಚೇಂಜ್ ಆಗ್ತಾರೆ. ನೆಕ್ಸ್ಟ್
27, M. Rudraya.
bringing LRs of deceased R9 on record as R9 A to D.
A to D ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಇದೆ.
R A B C D ತೊಗೊಳ್ಳಿ. ಹೇಳ್ರಿ ಏನು? ಏನಾಗ್ಬೇಕು ಹೇಳ್ರಿ?
IA may be allowed, my lords.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. Heard on IA number 3 of 24 and this court has issued notice against the LRs of deceased R9 on record. That is R9 A to D, and in spite of service of notice, they did not choose to appear in person or engage the counsel, and hence the IAs are allowed to bring the LRs on record, and appellant counsel is permitted to amend the cast title and file amended cast title within 1 week from today. 2007 matter. ಮತ್ತೆ non-compliance of office objections ವಕಾಲತ್ filed by B. Rangaswamy
Responding.
R2B ಅಂತ ಇದೆಯಲ್ಲ. The counsel for R2B is directed to comply with office objection within 1 week from today. ಅಷ್ಟೇ ಅಲ್ಲ? ಮತ್ತೇನ್ 3 ಏನಿದೆ? Allowed but notice not ordered ಅಂತ ಇದೆ ಇಲ್ಲಿ. R3 ಆಲ್ರೆಡಿ ಅಲೋ ಆಗಿದೆಯಾ?
ಎಲ್ಲರ್ಸ್ ಆಫ್ ದಿ R3 ಅಲೋ ಆಗಿದೆ. ಅದರ ನೋಟಿಸ್ ಆಗ್ದಿರಾ ಅಲೋ ಆಗಿದೆ.
ಮೋಸ್ಟ್ಲಿ ನೋಟಿಸ್ ಆಗಿ ಅಲೋ ಆಗಿರ್ಬೇಕು. ಮೇನ್ ಮೇಲೆ ಏನೋ ಆರ್ಡರ್ ಇರ್ಬೇಕೇನ ನೋಡಿ. ನೋಡಿ ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್
Serial number 27, I appear for LRs of respondent number 9, my lord.
9.
9.
ಹಾ
Yesterday we have
ಅಲೋ ಮಾಡಿದೀವಿ ಅಯ್ಯೇ.
yesterday we have filed wakalat, my lord.
ಹಾ
That has not been.
ತಕರಾರ ಏನಿಲ್ಲಲ್ಲ ನಿಮ್ದು. ತಗೊಳ್ಳಿ. ಇದು ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಮೇಲ್ಗಡೆ ಫಸ್ಟ್ ಹಾಕ್ಬಿಡಿ.
Jacob, my colleague.
Jacob submits that he has already filed wakalat for LRs of R9 on record ಅಂತ ಹಾಕೋಬಿಡಿ ಮೇಡಮ್. And counsel also not disputes the relationship between the parties and hence allowed ಅಂತ ಮಾಡಿ. ಅಲ್ಲಿ they did not choose to appear ಅಂತ ಇದೆಯಲ್ಲ ತೆಗೆದ್ಬಿಡಿ. ಆಯ್ತು, ಅಮೆಂಡ್ ಮಾಡ್ಲಿ ಅವ್ರು. ಅದಂಗ್ರಿ ಅಲ್ಲ ಯಾರು ಇವ್ರು ಜಡ್ಜ್? ಯಾವ ವಯಸ್ಸನ? ಹಾ ಹಾ ಮೊದ್ಲಾರು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದೇನ್ರಿ IAS ಮೊದ್ಲೇನೋ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಆಮೇಲೆ ಮತ್ತೆ ಅಲೋ ಆಗಿದೆ R3 ಸಂಬಂಧಪಟ್ಟಂತೆ. ಅರ್ಲಿಯರ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ? ರಿಕಾಲ್ ಮಾಡವ್ರ? ರಿಕಾಲ್ ಮಾಡಿ ಅಲೋ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ನೋಟಿಸ್ ಇಲ್ಲ, ನೋಟಿಸೇ ಮಾಡಿಲ್ಲ, ನೋಟಿಸೇ ಹೋಗಿಲ್ಲ ಅವ್ರಿಗೆ ಎಲ್ಲಾರ್ಸ್ಗೆ. ರಿಕಾಲ್ ದಿ ಆರ್ಡರ್ ಆಯ್ತು, ಅವಾಗ ಅಲೋ ಮಾಡೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. ರಿಕಾಲ್ ಮಾಡಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಬೇಕಿತ್ತು. In fact, such an application should have been filed by the appellant, and the legal representatives of the deceased respondent number 3 have themselves taken responsibility to get themselves ಸರಿ ಇದೆ ಮೇಡಮ್, implemented as legal representative of deceased respondent number 3 on record. Accordingly, counsel for the appellant is directed to ಅವರೇ ಬಂದಿರೋದು ಮೇಡಮ್ ವಾಲಂಟ್ರಿ ಆಗಿ. ಇಲ್ಲೇನಾಗ್ಬೇಕು ಇಲ್ಲಿ? ಇಲ್ಲ ಹಾಕ್ಬೇಕು. LRs deceased R3 allowed but notice not ordered ಅಂತ ಯಾಕ್ರಿ ಮಾಡಿದಾರೆ ಇಲ್ಲಿ? ಆಫೀಸ್ನವ್ರು ನೋಟ್ ಮಾಡಿರೋದೇ ತಪ್ಪು. The office note regarding notice not ordered not necessary since the LRs came on record voluntarily. ಆಯ್ತು. Post the matter for final hearing on 28/10.
28.
Vardhaman Gunjal. Including proposed
second
A3.
respondent died.
Who died?
The second respondent, who is my father, the applicant's father, my lord. And he is the only son. He is being implemented as the appellant, my lord. It's a suit for partition. And this honorable court was pleased to pass it on 4/1/24. The appellant has filed an application by impeding his director to serve copy, I served the copy. Then, my lord, it is seen in the record, son of the deceased respondent now wants to come on record as appellant number 3. And if any objection will be filed by the respondent, they are not filed, my lord.
ಏನ್ರಿ ಏನ್ ತಕರಾರು ಇದೆಯೇನ್ರಿ ಐಗೆ? ಇಲ್ಲ. ತಗೊಳ್ಳಿ. Heard on IA number 2 for 23. ಟ್ರಾನ್ಸ್ಪೋಸಿಷನ್ ಕೇಳ್ಬೇಕು, ಇಂಪ್ಲೀಡ್ ಹೆಂಗ್ ಕೇಳ್ತಾರೆ?
No, the second respondent died. In his place, he is coming as straight away impleading, my lords.
Directly as appellant.
Yes, my lord, it's permissible.
Sorry, heard on IA number 2/23. And the impleading proposed A3 are the LRs of respond number 2. They wants to come on record as appellants. And counsel for respondent also not filed any objections to IA. And for the reasons stated in the accompanying application of affidavit, IA 2/23 is allowed and permitted to come on record as appellant number 3. Since the suit is filed for the relief of partition. Hence, appellant counsel is directed to amend the cast title within 2 weeks from today.
Amend that cost title today itself.
The counsel for the appellant submits that he is going to amend the cast title today itself. And hence 1 week time granted to file cast notice, the cast title within 1 week and list the matter for final hearing on 29/10. 29/10.
29. P. Sheshgiri Rao.
Sole appellant ಸತ್ತೋಗಿದಾರಾ?
ಅವ್ರಿಗೆ
ತಗೊಳ್ಳಿ. Heard on IA number 1/23, 2/23 and 3/23 and those IAs are filed for condonation of delay and setting aside the abatement and bringing the LRs of sole appellant on record. And for the reasons stated in the accompanying application and affidavit, IAs are allowed and delay is condoned, abatement is set aside and permitted to come on record. Appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks from today. Then a non-filing of acknowledgement for having served entire case papers along with paper book. Respondent state by counsel for appellant antena ಇದೆ. Respondent state.
ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿತ್ತು ಸರ್, ಅವಾಗ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಪೇಪರ್ ಬುಕ್ ಅದು ಕಾಪೀಸ್ ಕೊಡಿ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ ಅದು.
ಪೇಪರ್ ಬುಕ್ ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು? ನಿಮಗೆ ಸ್ಟೇಟಿಗೆ ಕೊಡ್ಬೇಕೇನಾ? Appellant counsel is directed to furnish the paper book to the state council forthwith, since the matter is of the year 2008. And list this matter for final hearing on 4/11. Connected ಅಲ್ಲಿ ಇದೆ, ಅದು ಸೇಮ್ ಆರ್ಡರ್. ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿ ಮೇಡಮ್. IS ಎಲ್ಲ ಸೇಮ್, IA ನಂಬರ್ ಎಲ್ಲ ಸೇಮ್.
30.
My lord, appearance for the appellant. LR applications.
ಯಾರು ಇದ್ರಲ್ಲ?
Respondent is dead, my lord.
A to C. Objections ಏನಾರು ಹಾಕಿದಾರಾ?
ಇಲ್ಲ sir.
ಇಲ್ಲ. Heard on IA number 1/16. Where there is a delay of 1050 days in filing the application. And IA number 3/16 for setting aside abatement and IA 4/16 for bringing LRs of deceased sole respondent. And this court has issued notice against the respondents and they have also LRs of respondent and they filed the wakala through an advocate but not filed any statement of objections to the IAs and hence the IAs are allowed for the reasons stated in the accompanying application and affidavit. Appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks from today and list this matter on 4/11.
Much job.
31. Parted in admission.
Part heard.
Shastri.
ಏನಾಯ್ತು? ಎಷ್ಟು ಮಾಡಿದ್ರಿ ಪೇಮೆಂಟ್?
My lords, on such short notice, we couldn't make our payment, my lords. But, my lords, I just want to bring one aspect into play, my lords, then my lordships may, pass any order, what my lordships may deem fit, my lords. My lords, now, even if the bank, even if they go to the DRT, their only intention is to recover the entire amount, which I myself and I'm admitting to do, which I myself am admitting to come forward, sell the sites with their help and do it. Because I have some purchases, my lord, I have some bona fide purchasers. If they issue NOCs for those particular apartment and for those particular sites, the entire issue will be closed, my lords. My lords, why I am making such a request is, my lords, because I myself also have put some money into building this project, building these sites and building these apartments. Now, my lords, if they go ahead and unilaterally sell all these sites and apartments, it will cause great hardship to me. I know, my lords, I am absolutely wrong in approaching the civil court in getting such an order. I admit to that fact, my lord. But today, the only intention they have is to recover their money, which I am saying I don't have an issue with that.
You have
The
not
method-
shown any bona fides for
My lords,
making
my
payment
lords,
also.
my
At
lords,
least would have made some part payment.
My lords, even today, my lords, we are willing to sell we have about.
Sorry, you are willing to sell the property and clear the same, but how can you take the injunction before the trial court by approaching
Lords,
the civil court?
Some fraud was alleged, my lords, which I understand, my lordships, it was
Lord,
wrong.
Heard enough, Tole. I've heard the appellant counsel and also the counsel appearing for the respondent. The present miscellaneous first appeal is filed against the order passed by the trial court on IA number 1 and 2, which have been allowed in part, restraining the defendant number 1, that is the appellant herein, from interfering or alienating the suit scheduled properties, that is A to C scheduled properties. However, the plaintiffs and the guarantors are hereby directed to sell the suit A to C scheduled properties with the active participation of the defendant number 1 bank at each and every stage, and sale consideration shall be appropriated to the loan account of plaintiffs forthwith. If any excess amount is remained with the defendant number 1 bank, the same shall be returned to the plaintiff guarantors in accordance with law. The counsel appearing for the appellant would vehemently contend that when the proceedings was initiated against the respondents herein under the Surface Act, the trial court ought not to have invoked the jurisdiction of granting such an order. And counsel appearing for the appellant also brought to notice of this court the observation made by the trial court in coming to the conclusion that plaintiffs have not made out any prima facie case. However, granted the relief by allowing those IAs in part, and such an order should not have been passed by the trial court. The counsel appearing for the respondent would submit that they are having intention to sell the property and clear the loan of the appellant. And this court, when heard the matter in the 2 days back and directed to make part payment with the appellant to show their bona fides with regard to their submission that they are going to clear the loan amount. But the counsel expresses his inability to make such payment in spite of time was taken to deposit the part amount. Having heard the petitioner counsel, appellant counsel, and also the counsel appearing for the respondent, and having taken note of the material on record, admittedly the proceedings has been initiated under the Surface Act by the appellant herein. And when the proceedings has been initiated under section 13 of the Surface Act, and so also under section 14 of the Surface Act, the trial court ought not to have exercised its jurisdiction. There is a clear bar under section 34 of Surface Act in entertaining the suit. And in spite of an observation is made out that the plaintiff / respondent have not made out any case to grant the relief of temporary injunction, but committed an error in passing such an order by allowing the application, restraining the bank in proceeding against the respondent, and the said order is without the jurisdiction and ought not to have passed such an order, and hence the order impugned passed by the trial court is liable to be set aside, and accordingly the order passed by the trial court is set aside, and consequently IA number 1 and 2 are dismissed by allowing this appeal.
32.
Obligation.
Sachin B.
This matter pertains to declaration for change of name, my lords. Where
Change of name earlier,
yes, my lords, where I sought to change my name from Nazia to Pooja Bai. Wherein, my lords, there are citations which say that, my lords, the change of name is a fundamental right of a person under 19(1)(c). He has to be allowed to change the name, my lords. Based on the same, my lords, I sought to change the name, my lords. I also have certain documents, my lords, which
You only wanted to change the name, that's all.
That's all.
No change of any documentary evidence earlier. Prayer is only to change the name.
Only to change my name to Pooja Bai and my father's name to Annappa Nayak. That's it, man.
Father name change madak baralla ಈಗ.
Well, it's now, my lords.
ನಿಮ್ಮ ಹೆಸರು ಚೇಂಜ್ ಮಾಡ್ಕೋಬಹುದು ಅಷ್ಟೇ.
Well, it's pardon me. ಇಲ್ಲಿ
ನಿಮ್ಮ ಪ್ರೇಯರ್ ಏನ್ರಿ ನಿಮ್ಮ ಹೆಸರು ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಂತ. ಫಾದರ್ ನೇಮ್ ಚೇಂಜ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದಿರಾ?
ಇಲ್ಲ.
ಪ್ರೇಯರ್ ನಿಮ್ಮ ಸೂಟ್ ಅಲ್ಲಿ?
My prayer in my suit is, my lords, that ನನ್ನ ಹೆಸರು ಪೂಜಾ ಬಾಯಿ ಅಂತ ಚೇಂಜ್ ಮಾಡಕ್ಕೆ.
ಫಾದರ್ ನೇಮ್ ಚೇಂಜ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದಿರಾ?
And instead of Annappa Nayakam and not Khalil, ಎರಡು ಕೇಳಿದೀವಿ. And my lords, ಈಗ ನಮ್ಮ ಹತ್ರ ಬೆಳಗ್ಗೆ ಇವತ್ತು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲೆಕ್ಷನ್ ವೋಟರ್ ID ಮತ್ತೆ ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ ಫಾದರ್ದು ಅನ್ನಪ್ಪ ನಾಯಕ ಅಂತ ಇರೋದು. I sorted to file.
ಈಗ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಹೇಳು ಏನ್ರಿ Wanted to change the name, that's all. ನಾನೇ ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ನಲ್ಲ, ಎಲ್ಲಿದೆ ಅದು ಕೊಡಿ.
Yes,
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಅವ್ರಿಗೆ ಯಾರಿಗೋ ಹೇಳಿದ್ವಿ ನೋಡಿ ಅಲ್ಲ.
I have it here.
ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಬಗ್ಗೆ ಆರ್ಡರ್ ಇದು 19 ಆರ್ಟಿಕಲ್ 19
Article
1A can seek for the relief of change of name.
Yes, my lord.
ಎಲಾಬರೇಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ ಅದು.
My lords, Jigna Yadav versus CBSE.
ಕೊಡಿ ಕೊಡಿ. ನಾನೇ ನಿಮ್ಮಿಬ್ಬರಿಗೆ ಓದ್ಕೊಬನ್ನಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದೆ. ಯಾವ್ದು ರೆಲೆವೆಂಟ್ ಪ್ಯಾರಾ ಯಾವ್ದು?
My lords, para number 171.
As regard request for change of particulars in the certificate issued by the CBSE, it presupposes that the particulars intended to be recorded in the CBSE are not consistent with the school records. Such a request could be made in two different situations. The first is on the basis of public documents like birth certificate, Aadhaar card, election card, etc. And to incorporate change in the CBSE certificate consistent therewith. The second
171.
possibility is when the request for change is due to the acquired name by choice at a later point of time. That change need not be backed by public documents pertaining to the candidate.
171B, my lords. Only, however, in the later situation where the changes are to be effected on the basis of new acquired name without any supporting school record or public document, the request may be entertained upon insisting of prior permission by the court of law in that regard.
ಈಗ ಬರೀ ನೀವು ನಿಮ್ಮ ಹೆಸರು ಮಾತ್ರ ಚೇಂಜ್ ಕೇಳಿದ್ರಿ.
ನಮ್ಮ ಹೆಸರು ಮಾತ್ರ change.
ಪ್ರೇಯರ್.
Yes, ma'am. Based on my Aadhaar card, exhibit P8, ma'am.
Yes, counsel, what do you say?
Father name cannot, sir. Father name cannot be changed. In her name.
That is the original name, Ray. Subsequently, she converted to the Muslim. And now she wanted to come back as a Hindu only. And insisting for
change of name.
Change of the name, which was earlier, it was in existence, that's all.
But we are not seeking for change of caste or anything, my lords. Even my father's, my lords, we only insist for change of name.
Third. Heard the appellant counsel and also the counsel appearing for the respondent state. ಇದು ಅಡ್ಮಿಷನ್ ಆಗಿದೆಯಾ ಅಥವಾ ಏನಾಗಿದೆ?
Admission
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
Third. This second appeal is filed against the concurrent finding of trial court in dismissing the suit OS number 105 of 2019, wherein prayer is sought to change the name of the minor petitioner who filed the suit through her father, /next friend, seeking the relief of declaration that her correct name is Pooja Bai A and her father's correct name is Annappa Naika M, and rectify the same in her school records. School records ಇದೆಯಲ್ರಿ?
Yes, ma'am.
ಪ್ರೇಯರ್ಲಿ.
School records ಅಲ್ಲಿ it is still in the name of Nazia, but Aadhaar card ಅಲ್ಲಿ it is in the name of Pooja Bai.
ಈಗ ನಿಮ್ಗೆ ಚೇಂಜ್ ಎಲ್ಲ ಆಗ್ಬೇಕು, ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಆಗ್ಬೇಕು.
School records ಅಲ್ಲಿ ಆಗಬೇಕು.
ಹೌದಾ?
Yes, ma'am.
While seeking such a relief, it is contended that the plaintiff has been in care and custody of her father. And name of the mother of the plaintiff is Srimati Geeta Bai alias Hasina alias Asha. The plaintiff is a Hindu by birth and has been brought up as a Hindu. Her parents are Hindus. She belongs to Lambani scheduled caste community and caste. The correct name of the plaintiff's father, Annappa Naika M, is also supported by concerned documents such as voter card, Aadhaar card, ration card, etc. He is a original resident of Dodda Bukka Sagara, Padur Taluk, Chikmagalur district. He married the aforesaid Srimati Geeta Bai alias Hasina alias Asha, who was originally a Muslim. She after the marriage, the wife after the marriage embraced Hinduism and assumed a Hindu name Geeta Bai and has been living with the plaintiff's father as his wife and as a Hindu and has been living as a Hindu. And she begot two children who are born Hindus and have been brought up as Hindus. The plaintiff was born on 31/7/2006 and brought up as a Hindu and has been living as a Hindu. At the time of her birth, the plaintiff's father and his wife were residing in the house of wife's parents in Kaduru. During the absence of the plaintiff's father, the plaintiff was admitted to the defendant's number 3 school by her grandmother, Srimati Kushida B. The said Srimati Kushida B was not an educated person. She used to informally and affectionately call the plaintiff's father as Khalil instead of Annappa Naik and plaintiff as Najia instead of Pooja. Under the circumstances, the said Srimati Kushida B gave the name as Khalil and Najia at the time of admission of the plaintiff in the defendant number 3 school by bona fide inadvertent mistake, forgetting that the plaintiff is a Hindu and her father is also a Hindu bearing Hindu names. And hence, the said entries are made in the school records. And plaintiff's father is not an educated or knowledgeable person. And now having realized the same, taken steps for correction of her names. Moreover, the birth certificate and the Aadhaar card of the plaintiff bears the name correctly as Pooja Bai, daughter of Annappa Naika, and accordingly approached the school for the purpose of correction. And also made oral request, but they refused to oblige, citing the rules. And hence, plaintiff was constrained to issue notice to the defendants and filed the suit for the relief of correction of name and name in the school records. The defendant number 2, after service of notice, appeared through assistant government pleader on behalf of the defendants number 1 to 4 and filed their written statement denying the plea taken in the plaint and contended that according to notification number ED/100/DTB/2014 dated 26/10/2015 issued by the government, since the plaintiff completed her high school education, her name and her father's name cannot be rectified in the school records, and hence read the court to dismiss the same. The defendant number 5 also filed the written statement stating that unaware of the matters addressed in the plaint, and there was no record because of registered in Kuduru municipal office. Kaduralla madam, Kaduralla, Kuduru municipal office, and court has no jurisdiction. The trial court, taking into note of the pleadings of the parties, framed the following issues. Paragraph number 5 is there. The plaintiff, in order to prove the case, examined herself as PW1 and got marked exhibit P1 to P10. On the other hand, Deputy Director of Public Instructions Udupi by name Sri Nagaraja got examined himself as DW1 and got marked exhibit D1 to 5. The trial court, taking into note of both oral and documentary evidence, dismissed the suit, and being agreed by the dismissal of the suit, an appeal is filed in RA number 5 of 22. And appellate court, also having reassessed the material available on record, confirmed the judgment of the trial court. Being agreed by the concurrent finding, the present second appeal is filed before this court. And main contention urged before this court, framing the substantive question of law by the appellant that whether the courts below are justified in dismissing the suit of the plaintiff in consideration of irrelevant material and in non-consideration of evidence and relevant materials. This court heard the matter in part earlier. And today also heard the appellant counsel and also counsel for the respondent. Instead of admitting the second appeal, since the question involved before the court is very narrow, that is with regard to the change of name in the school records. The reason assigned before the trial court that the father of the plaintiff is a Hindu by birth and he married a Muslim woman and her name is also changed as Geeta Bai, alwa subsequent to the marriage. And the plaintiff was taken care of by the grandmother, one Kushida B. And while admitting the plaintiff to the school, her name was given as Najia and father name as Khalid. And only based on that information given by the grandmother, the name was entered in the school records as Najia. The plaintiff, in order to prove the case, produced the documents of Exhibit P 1 to 10. That is office copy of the notice issued to the defendants and postal acknowledgements, endorsement given by the second defendant and letter given by the fourth defendant and application submitted to the BEO are only with regard to the correspondence with regard to the change of name. But Aadhaar card Exhibit P8 is pertaining to the plaintiff and birth certificate is Exhibit P9 and study certificate is Exhibit P10. And no doubt defendants have also produced the documents of transfer certificate as Exhibit D1 and admission registry extract maintained by the fourth defendant and copy of the transfer certificate issued by the fourth defendant and admission register of 2017-18 and 2019-2020 as Exhibit D1 to 5. Having perused the material available on record, Exhibit P8 is the Aadhaar card of plaintiff which stands in the name of
Pooja
Bai and not stands in the name of Nazia. And this court also would like to rely upon the judgment of the apex court reported in 2020-21. Seven SEC 535. Jigya Yadav, within bracket minor, through guardian, Father Hari Singh versus CBSE, within bracket Central Board of Secondary Education and others respondents. Wherein also the apex court discussed in detail regarding change of name is concerned in particularly in paragraph number 171. As regards to request for change of particulars in the certificate issued by the CBSE. It presupposes that the particulars intended to be recorded in the CBSE certificate are not consistent with the school records. Such a request could be made in two different situations. The first is on the basis of public documents like birth certificate, Aadhaar card, election card, etc. and to incorporate change in the CBSE certificate consistent therewith. The second possibility is when the request for change is due to the acquired name by choice at a later point of time. That change need not be backed by public documents pertaining to the candidate. In paragraph number 171A, reverting to the first category is concerned, a detailed discussion was made. In paragraph number 171B, with regard to the latter situation where the change is to be effected on the basis of new acquired name without any supporting school records. And in paragraph number 172 comes to the conclusion that in exercise of our plenary jurisdiction, we direct the CBSE to process the application for correction of change as the case may be in the certificate issued by it in the respective cases under consideration. Even other pending applications and future applications for such request be processed on the same lines. And in particular, the conclusion and correct directions recorded hitherto in paragraph number 170 and 171, comma, as may be applicable, comma, until amendment of relevant bylaws. Additionally, comma, the CBSE shall take immediate steps to amend its relevant bylaws so as to incorporate the stated mechanism for recording, correction or change as the case may be in the certificates already issued or to be issued by it. Having considered the principles laid down in the judgment of the apex court, and in the present case on hand also, it is specifically pleaded by the plaintiff before the trial court that by inadvertently, the grandmother has given the names while admitting to the school. And apart from that, exhibit P8 is the Aadhaar card, which stands in the name of the Puja Bai, and father name is also mentioned as Annappa Naik. And when suching the case, and when the explanation is also given by the plaintiff before the trial court, and trial court ought to have taken note of particularly exhibit P8. ಈ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಾಜಿಯಾ ಅಂತ ಹೆಸರು.
ಆಧಾರ್ ಕಾರ್ಡ್ ಹೆಂಗಾಯ್ತು ಮತ್ತೆ?
They say that ಅದು ಈಗ ಕೇಸ್ ಮಾಡ್ಬೇಕಂತ ಇವರು ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡಿದಾರಂತ. But we never sought for change of caste or religion. We only sought for change of name.
ಏನಾಯ್ತು ಮೇಡಮ್? Exhibit P8 and also the fact that father is a Hindu by birth, and also material discloses that he married a Hindu woman, and she also changed her name as Geeta Bai. And the fact that the plaintiff is also represented through father in the suit and ought to have been considered the same by the trial court. And also the apex court discussed in detail with regard to the Article 19 of Constitution that ಎಲ್ಲ ಆರ್ಟಿಕಲ್ 19 ಎಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರಲ್ರಿ, ನಾನೇ ನಿಮ್ಗೆ ಹೇಳಿದ್ದದು ಯಾವಾಗದು ಯಾವ ಇದ್ರಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್
ಮೆಲೋಚ್ ಆನಂದ್ ಸಿಂಗ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ UP ಮೆಲೋಚ್, ಅದು ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಇದ್ರಲ್ಲೂ ಡಿಸ್ಕಸ್ ಮಾಡಿದಾರ್ರಿ ಆರ್ಟಿಕಲ್ 19.
ಆರ್ಟಿಕಲ್ 19(1)(a) ಮೆಲೋಚ್.
ಅದೇ 19(1)(a). ಹಾ, and the apex court in detail discussed that it is the choice of the person to change the name, or otherwise it infringes the right guaranteed in Article 19(1)(g), right to freely express one's identity as per Article 19(1)(a), and right to dignity in Article 21 of the Constitution. And in the case on hand also, the plaintiff intend to change the name. And wherein also a discussion was made with regard to the Article 19(1)(a) of the Constitution, and identity of the person is protected under Article 19(1)(a) as envisaged in the Constitution. And when such detailed discussion was made, if prayer is declined, and the same also in violation of Article 19(1)(a) of the Constitution, and such discussion was also made in the judgment, and also taking into note of the factual aspects of the case, both the trial court as well as the appellate court committed an error in not considering the matter in a proper perspective, and ought to have considered the documentary evidence and also the circumstances under which name of the plaintiff was entered in the school records. And hence, The judgment and decree of the trial court as well as the confirmation order passed by the appellate court is liable to be set aside. In view of the discussions made above, I pass the following order. The appeal, second appeal is allowed. And judgment passed in OS number
105.
105 of 2019 and also judgment and decree passed in RA number 5 of 2022 are set aside. Consequently, the suit is allowed and judgment and decree is granted as prayed in OS number 105 of 2019.
Petition matter 33, Raja Subramanya Bhatt.
My lord, appearing for the respondent, ready to address arguments, my lord, kindly pass over, my lords. I'm ready to address arguments, my lord, kindly pass over.
How many times, counsel? Last 2 days back also you sought for pass over and this court has passed over the matter.
My lords, I'm ready, my lords, kindly short pass over, my lords.
Pass over.
I'm grateful, my lords.
34,
I appear for the appellants in this. The appeal is challenging the miscellaneous order. If I may request my lords to have this matter on Tuesday or Wednesday.
Why, counsel?
ಸ್ವಲ್ಪ instructions ಕೇಳಿದೀನಿ in party.
Dismiss with cost of rupees 10,000.
Yes, my lords. There, what will happen is, my lords, we'll file a
Other side are idare entry ready idira?
Ready, my lordship.
ಮತ್ತೆ
Tuesday or Wednesday ಹಾಕೋಬಹುದು sir.
ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ ಅಸಿಸ್ಟ್ ಮಾಡ್ರಿ ರೀ
Yes,
ಕೋರ್ಟ್ಗೆ.
my lord. What happens is,
How
my
many
lords,
times court has to read the papers?
appellant will file a suit for declaration and injunction. That suit came to be dismissed.
ಹೌದು.
Agreed by that, I will prefer an appeal before this honorable court. The suit will be remanded back to the trial court for fresh consideration. After remand back, my lords, the notice will not be served to the appellant, my lords. Hence, the suit will be dismissed for non-prosecution. Agreed by that order, my lords, I will file a miscellaneous petition to set aside the non-prosecution order and allow me to contest the petition. Miscellaneous petition, my lords, it came to be dismissed on the ground that the appellant is very well aware that the suit was remanded back from the High Court to the.
Total remand ಮಾಡುವಾಗ ಇದ್ರ ಇಲ್ಲಿ?
ಇದ್ವಿ ಸ್ವಾಮಿ.
ಮತ್ತೆ?
Yes, my lord.
You had the knowledge.
ಇತ್ತು, but ಏನಾಗಿದೆ, we had shifted the house.
Why once again court has to give notice to you? Where is the order passed by this court in remanding the matter?
That order is not produced.
ಮತ್ತೆ ಬೇಕಲ್ಲ ಹೋಗ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ದವ್ರು ಬರಲ್ಲ, ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಕೊಡಿ ನೋಡೋಣ. Once you have approached this court.
Yes, ma'am.
And got the order of remand.
I agree.
Is it not your duty to go and contest the take up the matter and assist?
ಆ ಟೈಮ್ ಅಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂತಂದ್ರೆ, the appellant, my lord, she was carrying. Pregnant ಇದ್ರು ಆ ಟೈಮ್ ಅಲ್ಲಿ notice.
Carrying ಆಯ್ತ್ರಿ, ಲಾಯರ್ ಏನಾಗಿತ್ತು ಹೇಳಿ?
Yes, my lord. There is a mistake from the part of the
ಏನ್
appellant.
ಮಾಡ್ಬೇಕು ಹೇಳಿ?
How many suits have they filed, my lordship? Even they filed the appeal, my lordship, in the KT, before the KT, they filed the appeal, my lordship. That it was dismissed. Again, they challenged that before this court, writ petition is dismissed, writ appeal is dismissed, my lordship. The same fact of the
That
case,
was
my
for a
lordship,
different notice, my lord.
included that, my lordship. This honorable court also held that there is a
ಅದೇನ್ ಬೇಡ, ಮೊದ್ಲು ರಿಮೈಂಡ್ ಆಗಿದ್ದ ಆರ್ಡರ್ ಕೊಡಿ ನನಗೆ, ದಟ್ ಈಸ್ ರೆಲೆವೆಂಟ್. ರಿಮೈಂಡ್ ಮಾಡುವ ರಿಮೈಂಡ್ ಆರ್ಡರ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಅವ್ರ ಪ್ರಕಾರ ರಿಮೈಂಡ್ ಆಗಿತ್ತು ಅಂತ ಮ್ಯಾಟರ್, ಹೌದಾ?
Yes, my lordship, that is RFA is remanded back to the consideration, press consideration. my
ಅಲ್ಲ,
lordship.
pleadings ಅಲ್ಲಿ RFA number ಹೇಳಿದ್ದೀನಿ. My lords may permit me.
Approach from the KT, it was dismissed. Again, they challenged before this court. The writ petition, that is also dismissed. Again, they have prepared the writ appeal, that is also dismissed. These are the fact, only illegal building, my lordship. Only drag and the proceeding, that's all, that's what. After.
ರಿಮೈಂಡ್ ಆರ್ಡರ್ ಆಗಿದೆ ಯಾವಾಗ್ರಿ?
Remand order is on in the 2013, my lords.
2013.
Yes, my lords.
ಡಿಸ್ಮಿಸಲ್ ಯಾವಾಗ?
Dismissal is on 28/9/2016, my lords.
ಮತ್ತೆ 3 ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇತ್ತು ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ.
Yes, my lords. Remand.
Why you have not pursued the matter? No grounds. ಅದಕ್ಕೆ ಕಾಸ್ಟ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಯಾರ, 10,000 ಹಾಕಿದಾರೆ, ಕಡಿಮೆ ಹಾಕಿದಾರೆ.
ಏನಿಲ್ಲ, I will take an opportunity. I will contest the matter.
ಆಪರ್ಚುನಿಟಿ ರೀ?
OSL contest
ನೀವು
ಮಾಡಿ.
ಬಂದಂಗೆಲ್ಲ ಆಪರ್ಚುನಿಟಿ ಕೊಡಕ್ಕಾಗಲ್ಲ. ತೊಗೊಳ್ಳಿ. Heard the appellant counsel and also the counsel appearing for the respondent.
Appellant ಗೆ remedy ಯಾವುದು ಇರಲ್ಲ, my lords, my lords. A time bound manner may be fixed on 3 months.
First appeal is filed. against the rejection of the petition filed under Order 9 Rule 13 before the trial court in miscellaneous number 25131 of 2016. The factual aspect of the case is that the appellant filed a petition in miscellaneous number 25131 of 2016 seeking restoration of OS number 27189 of 2007 by recalling the order of the dismissal passed on 24/9/2016. The appellant had filed a suit in OS number 27189 of 2007 against the respondent for the relief of declaration and injunction on the ground that appellant is the owner of immovable property bearing municipal number 25, old number 9, Kyarpuram, Bangalore, as he has acquired the same through a gift deed dated 22/12/2003. The appellant has constructed 2-floor building after obtaining necessary plan from the respondent. Though plan is obtained, the respondent issued notice that the appellant has constructed building by violating the plan. Hence, the appellant has filed the suit. And the trial court also framed the issues, and issue number 3 was considered as a preliminary issue, and the suit came to be dismissed by its order dated 10/11/2011. Agreed by the same, the appellant preferred an appeal before this court in RFA number 1944 of 2011. And this court was pleased to remand the matter for fresh trial by order dated 27/3/2013. On 28/9/2016, the respondent came near the property and tried to demolish the property. And the appellant registered the same. And when approached the trial court, she came to know that the trial court, based on a chara of the court process, server stating that she is not residing in the said address, the suit was dismissed for non-prosecution on 24/9/2016. The appellant contend that she never received any court summons and she has not denied any court summons, and hence prayed for restoration of the original suit. The respondent appeared and filed a statement of objections, contending that the appellant, having the knowledge of remand, and also contend that without looking into the provisions of KMC Act, and even prior to the filing of the suit, she had filed an appeal in appeal number 870 of 2006 before the Karnataka Appellate Tribunal to set aside the confirmation order dated 7/9/2006. And the appellant did not succeed in the said appeal. She withdrew the same as not pressed and filed the suit. It is also contended that appellant had filed one more suit in OS number 88525 of 2006 on 23/9/2006. And the said suit was also withdrawn by filing a memo on 22/12/2007. The respondent also stated that the appellant had submitted an application for Suvarna Paravanagi, that is automatic sanction plan. And at that time, the appellant has given a declaration by undertaking that she will not object for the revocation of the plan. And in view of the same, the miscellaneous petition is not maintainable. The said sanction plan has been revoked. And within 3 days from the filing of the miscellaneous petition, the appellant has filed another appeal, number 872 of 2016 before the Karnataka Appellate Tribunal, challenging the confirmation order. And hence the appellant has not approached the court with clean hands and prayed the trial court to dismiss the case, and trial court also, having taken all this material, comes to the conclusion that not approach the court with clean hand, and no grounds are made out to restore the original suit. Being agreed by the dismissal of the miscellaneous application, the present appeal is filed before this court. The counsel appearing for the appellant would vehemently contend that without service of notice, the suit was dismissed And the fact that matter was remanded back to the trial court is only with an intention to for fresh consideration, and instead of considering the matter afresh, dismiss the same, and appellant has a good case and merits. In order to construct one more floor, the appellant obtained one more plan from the respondent. And though the appellant obtained one more plan, the respondent issued notice on the basis of the old plan and proceeded to demolish the property. The counsel also vehemently contend that the trial court failed to consider the prayer sought, as well as the fact that no notice was served on the appellant, and hence the same may be set aside and original suit may be restored, and an opportunity has to be given to the appellant. Percata, the counsel appearing with respondent would vehemently contend that the trial court passed the order in detail, having taken note of the factual aspects of the case, and nothing is placed on record before the trial court also, except producing certified copy of the order sheet in OS number 27189 of 2007, and copy of the invoice and postal cover, notarized copy of memo. On the other hand, respondent also examined one witness and produced the documents R1 to R7. That is a certified copy of the order sheet, written statement, and I have filed under Order 39 Rule 1 and 2 of CPC, and also affidavit in OS number 8528 of 2006, and certified copy of the memorandum of appeal under section 443A, order sheet and notice issued under KMC Act, and a certified copy of another appeal in 872 of 2016, and certified copy of the plaint and court notice in OS number 27189 of 2007, and certified copy of the judgment passed in RFA, remanding the matter, and also certified copy of writ appeal filed against the dismissal order passed by the KAT, that is the order copy of WP number 40751 of 2018, and the appellant was unsuccessful before this court and appellate court as well as KAT, and so also even after remand also, the appellant did not pursue the matter before the trial court, and hence question of setting aside the order of impugned doesn't arise. Having heard the appellant counsel and also the counsel appearing for the respondent, and also considering the material available on record, and it is not in dispute that earlier suit was filed and the same was dismissed, and thereafter an appeal was filed before this court, and also the fact that matter was remanded for fresh consideration is also not in dispute. It is also not in dispute that the very appellant had approached this court by filing an appeal in RFA number 1944 of 2011, and the same was allowed in 2013, and the matter was remanded, and the suit was dismissed in 2016, even after remanding of the order in 2013, and even after 3 years also, the appellant did not pursue the matter in spite of matter was remanded at the instance of the appellant before this court, and also not pursued the matter before the trial court. And when such being the material on record, and also the rightly pointed out by the respondent counsel that all remedies are exhausted by the appellant also being accrued by the confirmation order passed by the respondent, that he had approached the KAT and unsuccessful before the KAT, and also filed writ petition and also writ appeal. In all the matters are also unsuccessful, and even in spite of remand made by this court also, not pursued the matter. When such being the case, unless the appellant makes out a sufficient ground for non-appearance before the trial court for dismissal of the suit, question of once again considering the grounds which have been urged doesn't arise, and no satisfactory reasons are also not assigned for non-appearance before the trial court in spite of matter was remanded in 2013, and also records reveals that The suit was dismissed in 2016 after remanding the matter, that too after 3 years of the remand order. And when the appellant did not pursue the matter diligently, the question of setting aside the order of the trial court doesn't arise, and trial court also in detail discussed with regard to the negligence on the part of the appellant in not pursuing the matter in spite of remand order passed by the court, and particularly in paragraph number 28, 29 and 30, taken note of all this aspect apart from considering the material placed before the court, and particularly in paragraph number 30, made an observation that even after the matter has been remanded by the Honorable High Court for 3 years, the appellant did not come forward before the court. Only after dismissal of the suit only filed the petition. And also rightly comes to the conclusion that there are neither any bona fides nor any sufficient grounds for restoration of OS number 27189 of 2007. And when such reasoning is given by the trial court, I do not find any ground to set aside the order passed by the trial court. In view of the discussions made up, I pass the following order. Appeal is dismissed. Pleasure.
35, Neeraj Shastri.
Petition for succession certificate.
Hmm.
Dismissed on the ground
Hmm.
that there's a discrepancy in one of the letters in the name of the deceased and the share certificate in which of respect of which I sought succession certificate,
Hmm.
and that the share certificate not is dated after the death of the deceased.
Hmm.
I have produced some new documents, my lord, which I could not produce before the trial.
Additional documents.
Please.
Hmm.
Which would, my lord, to some extent explain the reasoning given by the trial court. I may be permitted to produce them in the trial court at least, my lord, and need some evidence to clarify the court in the.
What are those documents?
Essentially, my lord, at page 44 and 45, to show that, my lord, the shares were subdivided in the year 2006, pursuant to which, my lord, the share certificate was sent to the last known address of the deceased and received by the appellant number 1. The second document at page number 45 is the clarification, my lord, issued by the stockbroker to say that, my lord, the shares have been transferred to the IEPF and the company also, my lord, the United Breweries Limited has been liquidated. They cannot change the name at their end, and we will have to, my lord, follow some procedure to declare that, my lord, essentially, my lord, it is B.V. Padmanabhaya. The share certificate shows B.P. Padmanabhaya. Due to that, my lord, the trial court has dismissed the petition.
Only 2 documents you are relying upon. As additional documents, you are relying upon only 2 documents.
Please not, plus not, we have already begun the process of declaration that B.P. Padmanabhaya is none other than the B.V. Padmanabhaya. Some other document, not if we procure, we produce it in the trial court.
Unless you produce those documents, you have to make out a ground for remanding by setting aside the order. And only you are relying upon only 2 documents before this court.
Page 44, not the document.
44 only.
It shows that the shares were subdivided. Pursuant to that, not the share certificate at page 27 was issued to the address
44.
of 44, not subdivision of existing equity shares. This is dated not 2nd June 2006. Pursuant to this, my lord, the share certificate at page 27 was issued to the last known address of the deceased and therefore, my lord, received by the appellant number 1. The deceased, my lord, he passed away in 1999. 2006, the share certificate is issued to the last known address received by appellant number 1. I have only sought out the succession certificate in respect of this and nothing else.
Where is the reasoning given by the trial court?
That is at page 19.
Exhibit P3 is the death certificate of late Manjunath, who is the brother of PW2 and son of petition number 1. And the deceased which shows that Manjunath died on 3/1/2009.
But Manjunath is one of the sons who passed away, my lord, prior to filing the petition without
Upon
any.
perusal of death certificate exhibit P1, it is found that the date of death of Padmanabhai is on 9. While exhibit P2 share certificate is issued 2006, that is only a subdivision.
Only a subdivision pursuant to which, my lord, the shares are sent to the address, physical shares.
Exhibit P2 ಯಾವಾಗ issue ಮಾಡಿರೋದು?
Exhibit P2 2006, my lord, that is issued pursuant to the additional document which I have sought to produce. The subdivision was notified to me on
Based on
based on
based on-
subdivision. It is issued to me in 2006.
Good. This matter is listed for admission and I heard the counsel appearing for the appellant on main appeal as well as the IA filed under Order 41 Rule 27, seeking permission of this court to produce the additional documents. This appeal is filed against the dismissal of P&SC number 586 of 23. Particularly in paragraph number 12, the trial court made an observation that the BV, ಹೆಸರು correct BV Padmanabhayana?
BV Padmanabh.
BV Padmanabhaya died on 10/9/1999 and his son by name Manjunath.
Son by
Manjunath
name-
ಯಾರು ಮತ್ತೆ?
The wife and son, my lord, by name Cheluvamma and Murali
ಈ
Krishna.
ಮಂಜುನಾಥ್ ಯಾರ್ರಿ?
Manjunath, my lord, is the predeceased, my lord, he is a son,
He is also a son of Padmanabhaya.
son of Padman, who passed away in 2000.
ಅದೇನೆ. Son Manjunath died on 3/1/2009 prior to the death of the father. ಹೌದಲ್ಲ?
Father passed away in 99, he passed away in.
99,
Ah.
2009. Son also died on, son Manjunath died on 3/1/2009. And also taking into note of evidence of PW1 and PW2 and documents produced by the petitioner, comes to the conclusion that the petitioners are the only legal heirs of deceased BV Padmanabhaya. But having taken note of death of BV Padmanabhaya on 10/9/2099 and also exhibit P2 share certificate is issued dated 17/6/2006. Comes to the conclusion that the exhibit P2 is issued subsequent to the death of Padmanabhaya. And also found the discrepancy in mentioning the name of BV Padmanabhaya as Padmanabhaya BP. ಹೌದಾ?
ಹೌದು.
And both of them are one and the same person except the self-serving statement of petitioners. Nothing is placed on record. And hence dismiss the same. Being agreed by the said order, the present appeal is filed. The main contention of the petitioner before this court is that the trial court committed an error in passing such an order only on the technicality. And counsel also would contend that in order to clarify that there was no error on the part of the petitioners, additional documents are produced along with the application filed under Order 41 Rule 27. And counsel also brought to notice of this court the additional documents which have been produced before this court. That is document number 15 ಅಲ್ಲ?
15, page 40.
15. Dated 2nd June 2006. Wherein subdivision of equity shares of United Breweries Limited is mentioned and consequent upon the same. The exhibit P2 was issued in 2006, correct?
2nd June, 17th June is exhibit P2. Pursuant to
17?
June, 17/6/2006.
That is 17/6/2006.
6.
Consequent upon the document of document number 15,
Please.
dated 2nd June 2006. And these documents are necessary to establish the case of the appellant, to clarify the doubts which have been expressed by the trial court in dismissing the petition. And apart from that, counsel also relied upon the document number 16, which is filed along with the application, wherein ಇದೇನು ಸಂಬಂಧಪಟ್ಟಂತೆ
And seeking clarification on the discrepancy in name.
and this document is also with regard to the clarifying the name of Padmanabhaya BV, and by mistake it was mentioned as Padmanabhaya BP. And if these two documents are considered, the decision of the trial court would be different. Having considered the submission of the appellant counsel and also the documents which have been produced before this court, and also considering the reasons assigned by the trial court, particularly in paragraph number 19, paragraph number 12, that is consideration of document exhibit P2, and when the appellant clarifies the same that the exhibit P2 was issued consequent upon the additional document, and also with regard to the clarification of mentioning of the name as BV Padmanabhaya and Padmanabhaya BP, and sole reasons given by the trial court with regard to the discrepancy of mentioning of the name, and when such being the case, it is appropriate to set aside the judgment and decree of the trial court passed in P&SC number 586 of 2023, and to remand the matter for fresh consideration in view of the observations made by this court. And the appellant is given liberty to produce those two original documents before the trial court to clarify the same. And trial court is also given, trial court also given direction to consider the application if it is filed before the court as additional documents and pass appropriate order in accordance with law.
But any additional evidence also, if.
The petitioner also given liberty to place any additional evidence before the trial court for consideration of the matter for afresh.
Great.
Disposed of it.
36.
My lords, I appear for appellant, my lords. My lords, I have filed the memo along with acknowledgement for having served the hand summons on the counsel for respondent, my lords. Yesterday.
File Wakalat for respondent number 123, my lord.
ಏನು ಹೆಸರೇನು?
MS Vardarajan.
Counsel MS
Vardarajan.
Vardarajan undertakes to file ವಕಾಲತ್ for respond number
123, my lord.
123 ನಾ?
Please.
ಇಲ್ಲಿ ಯಾರು KV8R ಇದಾರಲ್ರಿ ಇಲ್ಲಿ?
My lords, he is for respondent number.
127 ಇದಾರಲ್ಲ?
And summons ಕೊಟ್ಟ ಮೇಲೆ ಇವತ್ತು ವಕಾಲತ್ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಬೆಳಗ್ಗೆ.
For H.A. Manjunath for R6 ಮಾತ್ರನಾ?
R6 ಮಾತ್ರ.
It is only for R6, my lord.
Counsel?
My lords, my H.A. Manjunath is appearing for R6, my lords.
R6 ಮಾತ್ರ?
Yes, my lords.
127?
127 ಗೆ PF
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಬಟ್ ಅವ್ರು ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
Yes, my lords. Only hand summons was ordered, my lord, but mistakenly I have paid PF also.
Hand summons. Non-filing of acknowledgement. 123. What about others?
ತರ್ಸ್ಕಿಲ್ಲ 123 ಮಾತ್ರ ಬೆಳಗ್ಗೆ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Next week, my lord, I will.
4, 5 and
As
7.
per my instructions, my lord, respondent number 7 is dead, my lord. He died on 27/7/2024, my lord.
So R7 is no more.
R7 no more.
R7 ಏನೋ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ನೋಡ್ರಿ ಜುಲೈ ಅಲ್ಲಿ.
My lords, I will bring him. I will bring the LR. LRs are already on record, my lords.
ಯಾರಿದಾರೆ ನೋಡಿ ಅದ್ ನೋಡ್ಕೊಂಡು ಮೆಮೋ ಹಾಕಿ.
Yes, my lords. My lords, Anjanappa, the others are the children of Anjanappa, my lord. My lords, other parties are children of. I will file necessary application.
Wakalat is filed, registry is directed to show the name of the counsel MS Vardarajan for R123. The counsel MS Vardarajan submits that R7 is also no more. The counsel appearing for the petitioner would submit that he is going to bring the LRs and also he will verify whether already LRs on record or not. ಈಗ ನೀವು 4 and 5 ಗುನು ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ ನೋಟಿಸ್?
My lords, I have served hand summons, my lords, but I was asked to serve only on the plaintiff, my lords.
Only on the parties or on the ಯಾರಿಗೆ ಹಾಕಿದ್ ಮಾಡಿದಿರಿ?
ನಾವು ಪ್ಲೇಂಟಿಫ್ ಗೆ ಮಾಡಕ್ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ, ಪ್ಲೇಂಟಿಫ್ ಗೆ ಮಾಡಿದೀವಿ.
ಅಲ್ಲ ಸರಿ, ಈಗ R4
My lord, this is
R5
the-
ಸರ್ವ್ ಆಗಿದಾರಾ?
Yes, my lords, R1 to R3 are the plaintiffs before the trial court,
R1
my
to
lords.
3 ಆಯ್ತ್ರಿ, ಅವ್ರು ಬಂದಿದ್ದಾರೆ. ಬಾಕಿಯವ್ರಿಗೆ 4 and 5 ಗೆ
My lords, they may be dispensed with, my lords.
ಮೆಮೊ ಹಾಕ್ಬೇಕು ನೀವು.
I will file a necessary memo for that.
The counsel for the appellant would submit that he is going to file dispensation of notice against R4 and 5. And hence list this matter on ಎಷ್ಟು ಸಬೇಕ್ರಿ, ಯಾವಾಗ ನೀವು?
Week after next, madam.
Huh?
Week after next.
And list this matter on 29/10.
Please.
Much obliged.
29/10.
PN Nanja Reddy, Bipin Hegde.
Prepare for this. Suit for injunction was filed, my lord.
That was dismissed.
That was dismissed. Initially, injunction was granted. Lord, thereafter,
ಬೇರೆಯವ್ರು ಇದಾರ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ರಲ್ಲಿ ಅಥವಾ ಒಬ್ರೇನಾ?
ಇಬ್ಬರಿದ್ದಾರೆ.
ಒಬ್ರೇನಾ?
ಇಬ್ಬರಿಗೂ ಐ ಥಿಂಕ್
ರಿಲೀಫ್ ಯಾರ ಪರವಾಗಿ ಕೇಳಿರೋದು?
ಇಬ್ಬರಿಗೂ ಅವರೇ ಅಪೇರ್ ಆಗ್ತಾರೆ ಅನ್ಸುತ್ತೆ.
ಇಬ್ಬರಿಗೂ ಅವರೇ ಹಾಕಿದಾರೆ? ಇಲ್ಲಲ್ಲ, ಫಾರ್ R1 ಮಾತ್ರ ಇದಾರೆ.
ಅದು ಇದ್ದಾರೆ, ಬಟ್
ಏನ್ರಿ ಕೌನ್ಸಿಲ್?
I undertake to appear for the other.
R2 also. The counsel Bipin Hegde also undertakes to file wakalat for R2. ಏನ್ ಹಿಯರ್ ಮಾಡ್ಬೋದಾ ಏನು? ಮಾಡ್ಬೋದಾ?
Yes. Let the appellant plaintiff purchase the property 30 guntas, my lord.
How much?
30 guntas.
30 guntas.
Server number 33. From his vendor. My lord, thereafter, my lord, when the, my lord, the defendants, my lord, try to interfere on the ground that they have an agreement of sale with the original owner. My lord, I filed a suit for injunction. The trial court, my lord, initially granted an order of temporary injunction. My lord, on
ex parte
on 1/8/2023. Thereafter, it was being.
So you go to the reasoning of the trial court in rejecting your application.
Yes.
You have purchased the property on 22/7/2016.
Yes, my lord. From my vendor, my lord, converted, the land was converted. Converted land only I have purchased. 30 guntas. Lord, I will show this sketch also. Last week, I think. What up, sir, madam? Rashma, kindly this, see the sketch, my lord. The sketch prepared at the time of conversion also. My lord, this shows, my lord, 30 guntas.
Conversion ಆಯ್ತ್ರಿ, ಅವ್ರ ಡಿಫೆನ್ಸ್ ಏನಂತಂದ್ರೆ there was an agreement.
Yes, agreement ಇದೆ.
Of sale 27/9/1989.
89, it was a created.
2012/1991.
ಹೌದು, ಅದು created agreement that, my lord, thereafter, my lord, they filed a suit. The suit was pending and, my lord, that was decreed.
It was
Decreed last month.
ಯಾರ ಪರವಾಗಿ?
ಅವ್ರ ಪರವಾಗಿ ಆಯ್ತು.
ಆಯ್ತು.
I filed an appeal, RFA.
ಆಯ್ತು.
RFA, my lord, admitted. And stay was about to grant, but they took time, my lord, to file objections. Yesterday also it was listed. Again, they took time to file objections. Now that is not the issue, my lord. You lost my case, the 19. But when I filed an application for impleading, said suit also, my lord, that application was rejected by the trial court. Against which I challenged, my lord, before the honorable court. Lost my kinds.
ಏನಾಯ್ತದ ಆರ್ಡರ್?
Adally, without affecting any rights of the parties in both the suits, that I was not permitted to implead, as the agreement is only between the original owner and the millionaire.
ನೀವ್ ಯಾಕೆ ಪಾರ್ಟಿ ಆಗ್ಬೇಕು ಅದ್ರಲ್ಲಿ?
ಅದಕ್ಕೆ because ಅವರು ಅಲ್ಲ, they have taken a defense in this suit. The agreement ಇದೆ ಅಂತ, therefore we wanted to implead the ourselves. Last, of course, it was dismissed last paragraph.
Binding upon the petitioner, nor would affect his legal rights on
In both the
any
suits, sir.
subject matter of the suit, and nor would be same affect the rights and contention of the petitioner so and so. ಆಯ್ತು.
ಆ suit that was decreed. That I have filed, madam, that the original owners have filed the appeal, RF. Yesterday it was, this, they took time, it is posted to 23rd. Then, therefore, unless this sale deed is set aside, when I have been in possession from the date of purchase, subsequently the suit was decreed. That property does nothing to do with this, my lord.
You have purchased the property in the year 2016.
16,
The suit filed by the agreement holder in which year?
96,
96 suit.
96.
ಮತ್ತೆ?
Correct, ಬೇರೆ ಇದೆ, 2 acres 3 guntas ಇದೆ. Out of which this is only 30 guntas.
Total extent ಏನು?
2 acres 3 guntas.
2 acres 30 guntas ಅಲ್ದಲೇನೆ 30
ಹೌದು,
guntas?
ಹೌದು.
Out of that?
No.
Total area they are on agreement. ಹೌದಲ್ಲ?
Total area ಅಲ್ಲ. 1 acre 1 acre agreement ಇರೋದು. That suit,
agreement ಇರೋದು 1 acre.
1 acre that is decreed.
1 acre?
1 acre suit was decreed.
ಹಾ.
1 acre ಮತ್ತೆ ಒಂದು 16 ಗುಂಟೆಗೆ, though the milad the more than the excess land, milad they obtained decree. A road no private, even Karab land also milad obtained decree.
What is the total extent, council?
2 acres 3 guntas.
2 acres 3.
2 acres 12 guntas is there. Out of which 9 guntas is Karab.
ಆಯ್ತು.
Only 2 acres 3 guntas they are entitled.
Entitled ಆಯ್ತು.
ಆಗ ಅವರು 2 acres 16 guntas ನಮ್ದೇ ಅಂತಾರೆ ಅವರು.
ಯಾವುದು 16 guntas?
ಅಲ್ಲ, that's what the suit filed in the other suit.
Apart from this, my lord, the specific performance suit ನಾನು ಫೈಲ್ ಮಾಡಿದ್ದು 1 acre 3 guntas ಬಿಟ್ಟು, in respect of the remaining extent of another 1
ನೀವು
acre,
suit for specific only for 1 acre 3
1 acre 3 guntas.
ಆಯ್ತು.
ಇನ್ನೊಂದು 1 acre 3 guntas ಗೆ already a sale deed is executed in my favor. That my learned friend is not disclosing. And that is not challenged by the original owner at all.
Earlier sale deed.
ಹೌದು. And ಅವ್ರಿಗಿನ ಮುಂಚೆ sale deed ನಂದು. My sale deed is of the year 2005 in respect of that another 1 extent of 1 acre 3 guntas of land. So there is no land at all.
ಈ agreement 89.
ಹೌದು.
Suit for specific performance is agreement of the year 1989. 89. Subsequently remaining 1 acre also you have purchased in 2005.
So therefore there was no land remaining at all for the vendor of the plaintiff to sell. ಈ 30 ಗುಂಟೆ ಮಾರೋದಕ್ಕೆ ಇವ್ರ ವೆಂಡರ್ ವೆಂಕಟೇಶ್ ಅವ್ರಿಗೆ ಇರ್ಲಿಲ್ಲ ರೈಟ್.
That is under ಅಲ್ಲ 2.5 ಎಕರೆ according to them.
Suit pending ಇದ್ದಾಗ ನೀವು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ, ಹೌದಾ?
ಅಗ್ರಿಮೆಂಟ್ ಇಲ್ಲ, ಸೇಲ್ ಡೀಡ್.
ಅಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ. So there was a suit pending.
Correct.
ಮತ್ತೆ?
Now milad you lost my kindness the suit for injunction, bare injunction.
Whatever it may be, counsel.
It was continued. You lost my dispose of the.
ಆಯ್ತು, ಅವ್ರ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಇದೆಯಾ ಇಲ್ಲ?
ಇಲ್ಲ ಇನ್ನೂ ಜಾಸ್ತಿ ಇದೆ. Possession. Now we are in possession.
ಅದನ್ನೇ ರೀ
ಎಕ್ಸ್ಟೆಂಟ್ ಇರೋದೇ 2 ಎಕರೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಲಾಸ್ಟ್
ಆ 2 ಎಕರೆ 12 ಗುಂಟೆನಲ್ಲಿ
2 ಎಕರೆ 30 ಗುಂಟೆ ಮಿಲಾಡ್
1 ಎಕರೆ 3 ಗುಂಟೆಗೆ ನನಗೆ ಆಲ್ರೆಡಿ ಸೇಲ್ ಡೀಡ್ ಇದೆ. ದಟ್ ಇಸ್ ನಾಟ್ ಚಾಲೆಂಜ್ಡ್. In respect of 1 acre 3 guntas of land, there is an agreement of sale which has been.
1 acre 3 guntas ಅಲ್ಲ. 1 acre.
Where is the land for you?
ಅಲ್ಲ,
ಅದು suit also decreed in their favor.
ಹೌದು, that is also under challenge.
Challenge ಇರ್ಲಿ ಬಿಡಿ.
ಮಂಗಳವಾರ ಇದು, ಬುಧವಾರಕ್ಕೆ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ.
ಇದೇನ್ ಟೆಂಪರರಿ ಇಂಜೆಕ್ಷನ್?
ಟೆಂಪರರಿ ಇಂಜೆಕ್ಷನ್ ಅಷ್ಟೇ. That may be continued till the milad is only for.
Let the trial court decide on merits, that's all.
Yes, milad. Till such time milad the injunction may be granted. Till such time injunction may be granted.
What injunction?
Because only otherwise I will be disposed.
Injunction ಕೊಡ್ತಾರೆ.
I
have purchased the property when the suit was pending.
ಹೌದು.
How your right will be protected?
ಅಲ್ಲ, ಅದಕ್ಕೆ
it's not your duty to verify before purchasing.
ಅಲ್ಲ, ಅದು ಜಾಸ್ತಿ ಇದೆ. Extent 2 acres 30 guntas both put together. ಅದೇ ಅದಕ್ಕೋಸ್ಕರ it was about to be stayed. You lost my kindly say.
In fact, ಇವ್ರ ವೆಂಡಾರೆ ಇವ್ರ ಮೇಲೆ ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ನಾನು ಸೇಲೇ ಮಾಡಿಲ್ಲ. It is a fabricated.
ಆ ಸೇಲ್ ಡೀಡ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ?
ಇವ್ರ ವೆಂಡಾರೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತ್ರಿ, ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ನ ಅವರೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಅದೇನಾಯ್ತು ಸೂಟ್?
ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅದರಲ್ಲಿ ನನ್ನನ್ನು ಪಾರ್ಟಿ ಮಾಡಲ್ಲ. And your lordship may kindly see another in this suit.
ಅದೇನು ಆ ಮ್ಯಾಟರ್ ಯಾವಾಗಿದೆ ರೀ?
23rd ಇದೆ. 23rd ಇದೆ ಸ್ವಾಮಿ.
23rd.
ಹೌದು.
ಆಯ್ತು, ನೋಡೋಣ ಅದೇನ್ ಡಿಸೈಡ್ ಆಗುತ್ತೆ ಆಮೇಲೆ.
ಅಲ್ಲ, that matter has nothing.
ಅಲ್ಲ, ಅದರಲ್ಲಿ they are taking time. You lost my kindly say. ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ
ಅದರಲ್ಲಿ ಇವಾಗ
4ನೇ ಕ್ಲಾಸ್ ಇದೆ, ಅದರೊಳಗೆ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು.
23rd I will go ahead with that case.
Yes.
Even if a stay is granted against that judgment and decree, it has nothing to do with this case.
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಅದ್ರ you lost my kindly ಇದೆ ಆರ್ಡರ್ ಶೀಟ್. ಅದೇ ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್ ತಗೊಂಡು ಟೈಮ್ ತಗೊಂಡು
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಸಂಬಂಧ
ಲಾಸ್ಟ್
ಇಲ್ಲ.
ಕೈಂಡ್ಲಿ ಇದೆ ಆರ್ಡರ್ ಶೀಟ್.
ಇವ್ರಿಗೆ ರೈಟೇ ಇಲ್ಲ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ.
ನೆಕ್ಸ್ಟ್ ಡೇ ಬಂದಾಗ ಅಷ್ಟೇ.
RFA is coming up before the 15-10 ಅಂತ.
ಅದರಿಂದ
ಆಯ್ತು, list this matter on 24.
With this,
23rd ಇದೆಯಾ?
23rd ಇದೆ.
24th ಆಯ್ತು.
ಅಲ್ಲ 28th
28 ಆಯ್ತು 28-10.
Not well.
28-10.
Okay.
38.
Allowed not to alienate.
Not to alienate.
Hmm.
Lord, defendant is the absolute owner of the scheduled property. The scheduled property originally belonged to my father. Thereafter, subsequent to his death, the family members enters into a partition deed. As per the recitals of partition deed, if the share of the Madhava Upadhyaya, if he died without marriage, then the property would go into the share of the plaintiff. But the next recital, I'll show the partition deed, my lord. Kindly come to Annexure B at page number 44. The partition deed is a C scheduled property. ನಮ್ಮ ಪೈಕಿ 3ನೇ ಭಾಗದ 5ನೇ ಮಾಧವ ಉಪಾಧ್ಯಾಯನು ಅನಾರೋಗ್ಯದಿಂದ ನರಳುತ್ತಿದ್ದು ಸದ್ರಿ ಅವನ ಹಿಷೆಗೆ ವಿಂಗಡಿಸಿದ ಸಿ ಶೆಡ್ಯೂಲ್ ಸ್ಥಿರಾಸ್ತಿ ಹಾಗೂ ಅದರಲ್ಲಿರುವ ಕಟ್ಟಡವನ್ನು ಸದ್ರಿ ಕೆ ಮಾಧವ ಉಪಾಧ್ಯಾಯನು ತನ್ನ ಜೀವಿತ ಕಾಲದವರೆಗೆ ಅನುಭವಿಸಿಕೊಂಡು ಬರುವರೆ ಮಾತ್ರ ಹಕ್ಕುಳ್ಳನಾವನಾಗಿದ್ದು ಸದ್ರಿ ಅವನು ಅವೈವಾಹನಾಥಾಗಿ ಮರಣಪಟ್ಟದ್ದಲ್ಲಿ ಸದ್ರಿ ಸಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯನ್ನು ನಮ್ಮ ಪೈಕಿ 2ನೇ ಭಾಗದ 2ನೇ ಶ್ರೀಧರ್ ಉಪಾಧ್ಯಾಯ ತನ್ನ ಹಿಷೆಯೊಂದಿಗೆ ಅನುಭವಿಸಿಕೊಂಡು ಬರುವರೆ ಈ ಮುಖ ಹಕ್ಕುಳ್ಳುವನಾಗಿರುತ್ತಾರೆ. ಒಂದು ವೇಳೆ ಸದ್ರಿ ಕೆ ಮಾಧವ ಉಪಾಧ್ಯಾಯ ವಿವಾಹಿತನಾದನಲ್ಲಿ ಸದ್ರಿ ಅವನ ಹಿಷೆಗೆ ವಿಂಗಡಿಸಿದ ಸದ್ರಿ ಸಿ ಶೆಡ್ಯೂಲ್ನ ಆಸ್ತಿಯ ಮೇಲೆ ಮೇಲ್ಕಾಣಿಸಿದಂತೆ ನಮ್ಮ ಪೈಕಿ 2ನೇ ಶ್ರೀಧರ್ ಉಪಾಧ್ಯಾಯನಿಗೆ ಯಾವುದೇ ರೀತಿಯ ಎಷ್ಟನ್ನಾದರೂ ಹಕ್ಕು ಸಂಬಂಧಗಳಿರುವುದಿಲ್ಲ. ಒಂದು ವೇಳೆ ಕೆ ಮಾಧವ ಉಪಾಧ್ಯಾಯನು ತನ್ನ ಹಕ್ಕಿನ ಕೆಳ ವಿವರಿಸಿದ ಸ್ಥಿರಾಸ್ತಿಯನ್ನು ಪರಬರೆ ಮಾಡಲು ಇಚ್ಛಿಸಿದಲ್ಲಿ ನಮ್ಮ ಪೈಕಿ 2ನೇ ಶ್ರೀಧರ್ ಉಪಾಧ್ಯಾಯ ಹಾಗೂ 3ನೇ ಅನಂತಕೃಷ್ಣ ಉಪಾಧ್ಯಾಯರವರಿಗೆ ವಿನಃ ಇತರ ಇನ್ಯಾರಿಗೂ ಪರಬರೆ ಮಾಡಲು ಹಕ್ಕಿರುವುದಿಲ್ಲ. During the lifetime of Madhava Upadhyaya, he intended to sell the suitable property in favor of the defendant. Therefore, he sold the property in the year 2012, my lord. After passing of 12 years, in the year 2024, the plaintiff has filed the present suit stating that the sale deed in my favor is null and void.
He already sold the property in favor of you.
In favor of me. In the year 2012, I have been in the possession. All the revenue documents are in my name. I have created mortgages and borrowed loan. I am in the possession of the property, my lord. Thereafter, after 12 years, he has filed. The suit is ex facie barred by limitation, my lord. The trial court also failed to appreciate this recitals. He has suppressed this fact. This recitals has been suppressed in his plaint also. He has not talked about this. He has just stated that the Madhava Upadhyaya has died unmarried. Therefore, the suit scheduled property has to go in favor of the plaintiff. But this aspect of the partition deed has been kept silent. Therefore, my lord, the
Counsel, whether you are a party to the partition deed or not.
I am a party to the partition.
But there is a recital in the partition deed that he can sell the property.
Interpretation, my lord. Life interest has been given. But for a kindly for a moment, my lord, in page 44, once again I am permitted to read. ನಮ್ಮ ಪೈಕಿ 3ನೇ ಭಾಗದ ಮಾಧವ ಉಪಾಧ್ಯಾಯನು, there are 3 brothers. 3 brothers, Ananta Upadhyaya, Sridhar Upadhyaya and Madhava Upadhyaya. He is Ananta Upadhyaya, I am Sridhar Upadhyaya. Madhava Upadhyaya is another brother who is totally unwell throughout months.
ಅಂದ್ರೆ ಇಲ್ಲಿ ಇದು ಈಗ ನಿಮ್ಮ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಕ್ಲಾಸ್ ನಾಟ್ ಕರೆಕ್ಟ್. ಮತ್ತೇನಂತಿದೆ ನೋಡಿ, ಸಿ ಶೆಡ್ಯೂಲ್ ಸ್ಥಿರಾಸ್ತಿ ಹಾಗೂ ಅದರಲ್ಲಿರೋ ಕಟ್ಟಡವನ್ನು ಸದ್ರಿ ಕೆ ಮಾಧವ ಉಪಾಧ್ಯಾಯ ಜೀವಿತ ಕಾಲದವರೆಗೆ ಅನುಭವಿಸಿಕೊಂಡು ಬರುವರೆ ಮಾತ್ರ ಹಕ್ಕುಳ್ಳವನಾಗಿದ್ದು.
But the next line, my lord.
ಏನ್ ಮಾಡಿದೆ, 2 ಕಾಂಟ್ರಡಿಕ್ಷನ್ಸ್ ಇದೆಯಲ್ಲ. ಲೈಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಯಾರಿಗೆ? ಮಾಧವ ಉಪಾಧ್ಯಾಯನಿಗೆ. ಅವನೇನಾದ್ರು ಮದುವೆ ಆದ್ರೆ ಬೇರೆ ಯಾರು ಕ್ಲೈಮ್ ಮಾಡಂಗಿಲ್ಲ. ಮದುವೆ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ಶುಡ್ ಗೋ ಟು ದಿ 2ನೇ ಶ್ರೀಧರ ಉಪಾಧ್ಯಾಯ ತನ್ನ ಹಿಷೆಯೊಂದಿಗೆ ಅನುಭವಿಸಿಕೊಂಡು ಬರುವರೆ ಈ ಮೂಲಕ ಹಕ್ಕುಳ್ಳವರಾಗಿರುತ್ತಾರೆ. ಅವನಿಗೂ ಕೂಡ ಅನುಭವಿಸಕ್ ಮಾತ್ರ. ಮತ್ತೆ ಮುಂದೆ ಓದ್ಕೊಂಡು ಹೋದಾಗ ಸಂಬಂಧಗಳಿರುವುದಿಲ್ಲ. ಒಂದು ವೇಳೆ ಸದ್ರಿ ಕೆ ಮಾಧವರ ಉಪಾಧ್ಯಾಯನು ತನ್ನ ಹಕ್ಕಿನ ಕೆಳಗೆ ವಿವರಿಸಿದ ಸ್ಥಿರಾಸ್ತಿಯನ್ನು ಪರಬಾರೆ ಮಾಡಲು ಇಚ್ಛಿಸಿದಲ್ಲಿ ನಮ್ಮ ಪೈಕಿ 2ನೇ ಕೆ ಶ್ರೀಧರ ಉಪಾಧ್ಯಾಯ ಹಾಗೂ 3ನೇ ಕೆ ಅನಂತಕೃಷ್ಣ ಉಪಾಧ್ಯಾಯರವರಿಗೆ ವಿನಃ ಇತರ ಇನ್ಯಾರಿಗೂ ಪರಬಾರೆ ಮಾಡಲು ಹಕ್ಕಿರುವುದಿಲ್ಲ.
As per this recital only, he has executed GPA in my favor and has sold the property in my favor, my lord.
But earlier ಏನಿದೆ?
In 2012 itself, the sale deed was done.
Only life interest ಅಂತ ಇದೆಯಲ್ಲ?
That portion has been not challenged. He has
ಆಯ್ತು,
challenged
ಈಗ-
only my sale deed.
ಆಯ್ತು, ಸೂಟ್ ಡಿಸ್ಪೋಸಲ್ ಆಗೋವರೆಗೆ ಲೆಟ್ ಇಟ್ ಬಿ ನಾಟ್ ಟು ಏಲಿನೇಟ್ ಅಷ್ಟೇ.
That's what the learned trial judge has said. It
ಟ್ರಯಲ್
requires
ಕೋರ್ಟ್ ಡಿಸೈಡ್, ದಟ್ಸ್ ಆಲ್. The relief is also granted not to alienate, that's all.
not with reference to possession, only with reference to alienation.
Not to alienate only. So, heard
Let
the
there be a
petition.
direction for early disposal, my lord.
ಆಯ್ತು, heard the appellant counsel and also you are suit ಹಾಕಿರೋದೇ 24 ಅಲ್ರಿ?
24.
ಯಾವ ಊರ್ಲಿ?
ಕುಂದಾಪುರ.
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 ಎಷ್ಟು ಕೇಸಸ್ ಇದೆ ಅಲ್ಲಿ? ಏನ್ ಐಡಿಯಾ ಇದೆಯಾ?
But I am instructed that there are less number of cases.
ಲೆಸ್ ನಂಬರ್ ಆರ್ ಒನ್ ಇಯರ್ ಕೊಡೋಣ, ಡೈರೆಕ್ಷನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಿ.
ಆಗ್ಬೋದು.
Sorry. Heard the appellant counsel and also the counsel appearing for the respondent. The present miscellaneous appeal is filed challenging the allowing of the application filed under Order 13 Rule 1 and 2, wherein defendant is restrained from alienating the suit A scheduled property land in any manner till disposal of the main suit. The main contention of the appellant counsel referring annexure B that there is a recital in the partition deed to sell the property in favor of the appellant and so also in favor of K. Sridhara Upadhyaya, and during the lifetime only the said K. Madhava Upadhyaya sold the property and the same was sold in the year
2012.
2012.
By way of
But,
GPA.
I would also like to rely on.
We have GPA.
GPA ಇವರಿಗೆ GPA ಇವರದೇ ಸೇಲ್.
GPA ಇವರಿಗೆ ಕೊಟ್ಟಿರೋದು ಇವರೇ ಮತ್ತೆ ಸೇಲ್
ಅದು
ಮಾಡ್ಕೊಳ್ಳೋದು.
ಅವರಿಗೆ ಅವ್ರು ಸೇಲ್ ಮಾಡ್ಕೊಂಡಿರೋದು. I have alleged fraud also.
ಆಯ್ತು, ಏನಾಯ್ತು ಹೇಳಿ ಮೇಡಮ್? By executing the GPA in favor of the appellant and appellant in turn on the strength of the power of attorney got the sale deed in his favor. And both the parties not disputes the document of annexure B is the registered partition deed. Howdalla?
Registered.
The main interpretation involves with regard to the page number 6 of the registered partition deed.
6 and 7.
6
And 7.
and 7, wherein there was a reference with regard to the life interest is created in favor of the said K. Madhava Upadhyaya.
Sridhar Upadhyaya.
First Madhav Upadhyaya, then Sridhar.
Madhava Upadhyaya.
Suppose if he dies
And
unmarried.
and if he dies, then again, the right of enjoyment is given to one Sridhara Upadhyaya. Howda?
Respondent hearing.
And also there are recitals with regard to if he is intended to sell the property during his lifetime and the same ought to have been sold in favor of K. Sridhar Upadhyaya and the present appellant Ananta Krishna. Having taken note of the said recital in paragraph number 6 and 7, and suit is also filed for the relief of declaration. And the prayer is also sought for only not to alienate.
In the application.
When that recitals are found in the registered document and also both the parties are parties to the said partition deed, and trial court has to decide the matter regarding declaration as sought. And having taken note of paragraph number 6 and 7, it is appropriate to give direction to the trial court to dispose of the suit. And during the pendency of the suit, the relief granted by the trial court shall be enforced. Hence, the trial court is directed to dispose of the suit within 1 year from today, and both the appellants and also the respondents and their respective counsels are directed to assist the trial court in disposal of the suit within the time-bound period of 1 year.
Hmm. 39, Ajit PP.
Sam for the appellant in this case. Challenging, a rejection of the application filed under Order 39 Rule 1 and 2. By the impugned order, my lord, the Honorable Trial Court has rejected the application filed by the plaintiff. Lord, suit is for declaration of title
and recovery of possession of the suit schedule property,
Hmm.
and for declaration that the gift deed executed by defendant number one in favor of defendant number two is null and void. The facts of the case, defendant number one was the owner of the property. Suit schedule property is a site bearing number 590 situated at Chalagatta village. He purchased in 2009, the first defendant. He has offered to sell the suit schedule property in favor of the plaintiff in the year 2015. He has executed an agreement to sell, and on the same day has executed a registered general power of attorney in favor of the plaintiff. I may be permitted to pass on the document. These documents were produced before the trial. Lordship, may kindly come to the documents. Now, document at page number 2 is the sale deed. in
Belief
favor-
is not to put up any constructions or change the nature of the property.
There are two IAS, my lords. I have filed one IA for restraining them from alienating or creating third party rights.
But now the relief
ಅಲ್ಲಿ ಎರಡು MFA ಹಾಕಿದ್ದೀನಿ.
ಎರಡು ಹಾಕಿದೆ.
ಎರಡು
both
ಹಾಕಿದ್ದೀನಿ.
are,
ಒಂದು ಕಾಮನ್ ಆರ್ಡರ್ ಎರಡು ಹಾಕಿದೆ.
one is not to alienate, another is not to
Not to
put up.
put up construction. Lordship, may kindly come to the agreement.
You
of
are
sale.
challenging the sale deed.
No, my lords.
In
I
the
am
suit, in the suit, declaration.
in the suit declaration that I am the owner of the property.
To declare that you are the owner
I'm
of
the
the
owner of the
property in
property.
view of the sale deed may executed in favor of you in 2015 by defendant number two.
Defendant number one.
One.
No, what happened? Defendant number one has executed an agreement of sale and the registered
And
GPA.
registered sale agreement. Registered sale
Registered
agreement.
GPM.
GPA.
Kindly come to page number 19. This is the general power of attorney executed by the first defendant in my favor. Kindly come to page number 21. my lords. He has delivered possession. ತ ಮೇಲ್ಗಡೆ ಕ್ಲಾಸ್ ಎಲ್ಲ ಇದೆ ಕೆಳಕಂಡ ಕೆಲಸ ಕಾರ್ಯಗಳನ್ನು
ಸ್ವಾಧೀನವನ್ನು ಬಿಟ್ಟು ಕೊಟ್ಟಿರುತ್ತೇನೆ.
ಸ್ವಾಧೀನವನ್ನು ಬಿಟ್ಟು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಅಂಡ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಕ್ಲಾಸ್ ನಂಬರ್ 4. ಶೆಡ್ಯೂಲ್ ಸೊತ್ತನ್ನು ನೀವು ಯಾರಿಗೆ ಬೇಕಾದರೂ ಕ್ರಯ ಆಧಾರ ಭೋಗ್ಯ ವಗೈರೆ ಪರಭಾರೆ ಮಾಡುವುದಕ್ಕೂ ಪರಭಾರೆ ಮಾಡುವುದರಿಂದ ಬರತಕ್ಕ ಮೊಬಲಗನ್ನು ನನ್ನ ಪರವಾಗಿ ಪಡೆಯುವುದಕ್ಕೂ ನೀವೇ ನಿಮ್ಮ ಹೆಸರಿನಲ್ಲಿ ಕ್ರಯ ಪತ್ರವನ್ನು GPA ಹೋಲ್ಡರ್ ಆಗಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸಿಕೊಳ್ಳುವುದಕ್ಕೂ ದಿಸ್ ದ ಅಥಾರಿಟಿ. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 25 minutes. And there is a specific recitals about receipt of the entire consideration, page number 25. Schedule ಸೊತ್ತಿನ ಈಗಿನ ಮಾರುಕಟ್ಟೆ ಬೆಲೆ ಸದರಿ ಕ್ರಯದ ಮೊಬಲಗನ್ನು ನಾನು ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. No, therefore this GPA is coupled with interest. He has delivered possession to me with an authority to get the sale deed in my favor. On the basis of this GPA, I got the sale deed. Kindly come to page number 26. On 30th/10/2021 in my favor. And in the meantime, I also got the khata and license for putting up construction over the suit schedule property. But because of some financial constraints, I could not commence the construction. What has happened, in the month of June 2024, the first defendant and his son, second defendant, have encroached the property. After I came to know that, I visited the property and tried to question them. At that point of time, they have handed over a gift deed, which is at page number 42. After selling the land, after
D1 in favor of D2.
D2 is son. They have created this gift deed. On the basis of this gift deed, they have encroached the property. Therefore, I filed suit seeking declaration of my title and recovery of possession, and also sought declaration that this gift deed is null and void. My humble and respectful submission, having received the entire consideration, having executed the registered GPA in my favor, first defendant did not have any manner of right over the suit schedule property.
Give the property in favor of
Favor of
D2.
his son. Therefore, I filed application. The trial court's finding notes, kindly come to page number findings, paragraph number 7 says, GPA holder cannot get the sale deed executed in his own favor. That is the finding by the trial court. Kindly come to page number 25, paragraph number 7. Can I read? The plaintiff herein is claiming prima facie right by virtue of sale deed dated so and so, which on perusal reflect that sale deed is executed by the plaintiff in favor of himself. It is pertinent to note that both the vendors and purchaser in the sale deed dated are one and the same. It is relevant to note that GPA holder has himself executed the sale deed in his favor, which is not permissible under law. Transfer of Property Act specifically states that transfer of any property should be between two living persons. But in the instant case, plaintiff has executed in his own favor, which is not permissible under law. The GPA holder cannot execute the sale deed in his own favor, and thereby such transaction does not convey any right, title, and interest or possession of the property to the GPA holder. For the GPA only reflect that defendant number one is the principal and plaintiff is the agent. Under these circumstances, the plaintiff being an agent of defendant number one has to act on behalf of defendant number one. Plaintiff herein has acted contrary and has executed the sale deed is in his own favor, which is not permissible under the law. The trial court has completely misunderstood the position of law. Lords, GPA holder can I pass on the decision of the Honorable Apex Court?
Yes.
The relevant paragraph is page number, para 36.
Whether you dispute this execution of general power of attorney, madam?
Initially, power of attorney is given for the construction of the house, Lordship.
Not for construction. You see the title. Recital.
Yes, Lordship.
Recital, even selling also you have given authority.
Lordship, when we.
Clause number 4.
Clause number.
ಕ್ರಯಪತ್ರವನ್ನು ನನ್ನ GPA ಹೋಲ್ಡರ್ ಆಗಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಕೊಡುವುದಕ್ಕೂ ಸದರಿ ಮಾಡಿಕೊಳ್ಳುವುದಕ್ಕೂ
Lordship, when we read the entire document as a whole, general power of attorney, initially it's given for the construction of the property. And the Son 15ನೇ ಇಸವಿ ಫೆಬ್ರವರಿ 9 ಬೆಂಗಳೂರು ಕಾಟನ್ಪೇಟೆ 15 ರಸ್ತೆ ನಂಬರ್ ಮನೆಯೊಳು ವಾಸವಾಗಿರುವ ಲೇಟ್ ಬಸವಲಿಂಗಪ್ಪನವರ ಮಗನಾದ ಸುಮಾರು 50 ವಯಸ್ಸುಳ್ಳ ಉಮಾಶಂಕರ್ ಆದ ನಿಮಗೆ.
Anyhow, the relief is sought, madam, not to put up any construction and not to change the nature of the property, not to alienate. Anyhow, now there is a document of registered document of power of attorney executed by you after having received the sale consideration of ₹10,80,000.
ಅದ್ರನ್ನೆಲ್ಲ ಚಾಲೆಂಜ್ ಮಾಡಿ ಸ್ವಾಮಿ.
ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ ಸರಿ, ಈಗ it has to be decided ಅಲ್ಲ. Let there be an order of not to alienate and not to put up the building. That's all.
ನಾವು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದೀವಿ ಸ್ವಾಮಿ.
ಆಯ್ತು ಮೇಡಮ್, ನೀವು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ನೀವಿರಿ, ನಿಮ್ ಪ್ರಕಾರ ನೀವು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೀರಿ, ಹೌದಲ್ಲ?
ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದೀವಿ
ಅಲ್ವಾ? Not to alienate, not to put up ಅಷ್ಟೇ.
ಇದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ 95% ಆಗಿದೆ. ಇನ್ನು ಪೇಂಟಿಂಗ್ ಆದ್ರೆ ಮಾತ್ರ ಆಯ್ತು.
ಏನ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದೀರಾ?
ಆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿ ಈಗ ಪೇಂಟಿಂಗ್ ಒಂದು ಬಾಕಿ ಇದೆ. ನಾವು
ಮಾಡಿದಿರಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್
ಅಲ್ಲಿ ಈಗ ರೆಸಿಡೆನ್ಶಿಯಲ್ ಹೌಸ್ ಇದೆ ಸ್ವಾಮಿ. ನಾವು ಈಗ ಕೆಂಗೇರಿನ
ಈ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ರೆ ಅವ್ರೇನ್ ಕೇಳಿಲ್ಲಲ್ಲ ಅವ್ರು.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಆಗಿ ಈಗ ರೆಡಿ ಆಗಿ ಈಗ.
ಸರಿ ಮೇಡಮ್, ಅವ್ರೇನ್ ಮಾಟು ಪುಟಪ್ ಏನ್ ಬಂದ್ ಕೇಳಿಲ್ಲ. ಪುಟಪ್ ಆಲ್ರೆಡಿ ನಿಮ್ ಪ್ರಕಾರ ಆಗಿದೆ ಅಂತ.
Because as in the date of filing of the suit, it was in the basement stage. Therefore, I sought for recovery.
ಈಗೇನಾಗಿದೆ ಹೇಳಿ?
But ಈ construction, ground floor construction ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ಫೋಟೋಸ್ ಕೊಡಿ ನೋಡಿ.
ನಮ್ದೆಲ್ಲ ಇದು ರೆಡಿ ಆಗಿ ಪೇಂಟಿಂಗ್ ಒಂದು ಇಷ್ಟು ಸಮಯ
ನಿಮ್ದು ರೆಡಿ ಆಗಿರೋದು ನೀವು ಕೊಡಿ, ಅವ್ರಿಗೆ ಏನ್
one submission.
ಎರಡು ಫೋಟೋ ಕೊಡಿ, then we will see. ಇದು discretionary relief. ಕೋರ್ಟ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಕೋರ್ಟ್ has to see the stage of construction.
May make one submission.
ಹೇಳಿ.
Since I have sought for recovery of possession, whatever the construction they have put up, that may be subject to the outcome of the suit.
Seek any equity.
Yes, they should not seek any equity. With that observation and restraining them from alienating or creating third party rights over the property, this appeal may be disposed.
ಮಾಡಬಹುದು ಅಷ್ಟೇ.
Please, with the direction to the trial court to expeditiously dispose of the main suit.
ಯಾವ ಇಯರ್ ಸೂಟ್?
24 suit.
24.
24.
ಯಾವ ಊರಿನಲ್ಲಿ?
ಬೆಂಗಳೂರು ರೂರಲ್.
ಬೆಂಗಳೂರು ರೂರಲ್. ರೂರಲ್ ಸಿಕ್ಕಾಪಟ್ಟೆ ಸೂಟ್ಸ್ ಇರುತ್ತೆ.
ಅಲ್ಲ, ರೂರಲ್ ಅಂದ್ರೆ 10 ವರ್ಷ ಆದ್ರೂ ಆಗೋದಿಲ್ಲ. ಅದಕ್ಕೇನೆ 10-15 ವರ್ಷ ಆದ್ರೂ.
ನೀವೇ ಇಬ್ರು ಅಸಿಸ್ಟ್ ಮಾಡಿ ಟ್ರಯಲ್.
ಅಲ್ಲ, will assist the trial.
ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಮಾಡ್ಬೋದು ಹೇಳಿ?
1 ವರ್ಷ 1.5
1 ವರ್ಷದಲ್ಲೆಲ್ಲ ಆಗಲ್ಲ. ನಿಮ್ ಸೂಟೇ ತಗೋಬೇಕಾದ್, ಬೇರೆ ಸೂಟ್ ಬಿಟ್ಟು.
ಅಲ್ಲ, 1.5 ವರ್ಷ.
ನಮ್ಮ ಹೈಕೋರ್ಟ್ ನವ್ರು ಮತ್ತೆ ಹಳೆ ಸೂಟ್ಗೆಲ್ಲ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿರ್ತಾರ ಅವ್ರಿಗೆ, ಬೆಂಗಳೂರು ರೂರಲ್ ಕೋರ್ಟ್ಗೆ.
1.5
ನೋಡ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, 1.5 ವರ್ಷದಲ್ಲಿ
ನೋಡಿ. Heard the appellant counsel and also the counsel appearing for the respondent. And these two appeals for 3940, madam, are taken up together with the consent of both the counsels, since the trial court disposed of both the IAS by passing common order. Common order. The appellant counsel would submit that the suit is filed for the relief of declaration based on the sale deed, as well as sought for the relief of to declare the gift deed executed by defendant number 1 in favor of defendant number 2 as null and void. Correct?
Correct.
Null and void. And suit is also filed for the relief of
recovery of
possession. The respondents also not disputes the relief sought in the suit. The counsel appearing for the appellant would contend that 2 IAS are filed. One is not to put up and change the nature of the property, and another suit is filed for, another application is filed for the relief of not to alienate the same. and both the IAs are rejected. The counsel appearing by the respondent would contend that already they have put up the construction and the same is in a final stage. The counsel appearing by the appellant also would submit that even if any such construction is made, they shall not claim any equity. And in view of the documents executed by defendant number 1, the counsel appearing to the respondent also now disputes the very execution of power of attorney. And also counsel contend that the power of attorney holder himself got transferred the property in his favor. And trial court also given the reasoning. In view of the submission made by the appellant as well as counsel for the respondent, it is appropriate to direct the respondent not to claim any equity in case if the appellant succeeds in the suit. And also it is appropriate to direct the respondent also not to alienate the property during the pendency of the suit. Since there is a dispute with regard to the very title between the parties, since the plaintiff claims that already defendant number 1 executed power of attorney as well as registered power of attorney as well as the sale agreement, and counsel for the respondent submits that no such power of attorney was executed and the same is obtained by fraudulently. And whether all this and these are the issues has to be considered by the trial court while considering the matter on merits, whether they have executed general power of attorney or not, and whether entire sale consideration has been received or not, and whether the interest has been transferred by receiving the entire sale consideration and power of attorney is coupled with interest. And these are the issues have to be considered by the trial court. And in view of the construction made by the respondent, and the respondent cannot claim any equity. And also the respondent is directed not to alienate
or create third party rights.
Alienate or create any third party right during the pendency of the suit. With this direction, both the appeals are disposed of. The trial court is also directed to dispose of the matter within a time bound period of 18 months since the suit is of the year 2024. And both the appellants as well as respondents and their respective counsels have to assist the trial court in disposal of the suit within a time bound period of 18 months from the date of receipt of copy of this order. The respective counsels are also directed to furnish the copy of this order to the counsel forthwith, to the trial court forthwith.
Grateful.
Actually, one submission.
ಹೇಳಿ.
Acceptance of ವಕಾಲತ್ ನಾನು ವಕಾಲತ್ ಹಾಕಿದ್ದೇನೆ ಇನ್ನು accept ಆಗಿಲ್ಲ ಅದು.
ಯಾರ ಇದಾರಲ್ಲ ಅಜೈಟಿ R1 and R2 ಅಂತ ಇದೆಯಲ್ಲ.
ಅಜೈಟಿ and ಅದ್ರ ದಿನ accept ಆಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ಲ ಮೇಡಮ್ ಅದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ?
Objection ಇದೆ.
ಅಂದ್ರೆ ಬಿಫೋರ್ ನೋಟಿಸ್
Before notice
ತಗೋಬಿಡಿ ನೋಟಿಸ್
we have filed.
ತಗೊಳ್ಳಿ ಅಕ್ಸೆಪ್ಟ್ ವಕಾಲತ್ ಫೈಲ್ಡ್ ಬೈ ದಿ R1 and R2 counsel is accepted.
caveat ಹಾಕಿದ್ವಿ ಅದಕ್ಕೆ in advance.
ಎರಡರಲ್ಲೂ.
ಮಚ್ಚೋದು.
41. Hadira Rami Reddy.
I appear for the R3 minutes. Minutes. I have not received the copies. Minutes. I have not received the copies. Minutes.
Lordship, this copy receive ಮಾಡಿಲ್ವಾ?
In FTP, they had filed a memo that case is pending in the High Court. Minutes. That's why I filed a wakalat.
Non taking hand summons.
Lordship, this
ಯಾರ್
court
ತಗೊಂಡಿಲ್ಲ
was placed
ಹೇಳ್ರಿ?
to grant me this court was placed to grant me a stay on 17 September. Within 3 days, I have paid the court fees and paid the process with regard to R1, R2 and R3. I have paid the process fees also, the court fees.
ನೀವ್ ಯಾರು ಅಪೇರ್ ಆಗೋದು?
R3 minutes.
R3 ಈಗ?
Yes, minutes. I have filed wakalat.
ವಕಾಲತ್ ಕೆವಿ ಫಾರ್ R3. R3 ಸರ್ವ್ ಆಗಿಲ್ವಲ್ರಿ? ಕಾಪೀಸ್ ಕೊಟ್ಬಿಡಿ ಒಂದು.
ಕೊಡ್ತೀನಿ ಸರ್.
The appellant counsel is directed to serve the copy of this appeal memo on the counsel for R3 forthwith. List this matter. ಯಾವ ಕೊಡ್ತೀರಿ?
2 weeks.
List this matter on 30th? 3010.
And the interim order of stay may be extended.
Interim order ಇದೆಯಾ? Interim order granted earlier is extended till next date of hearing.
42.
ಇಲ್ವಾ? Appellant counsel is absent. List this matter on ಯಾವ ಮೇಡಮ್? ಫಸ್ಟ್ ವೀಕ್ ಕೊಡಿ ನವೆಂಬರ್
4/11.
4/11.
43.
For the appellant is
Parisha.
the probate has
Fist.
the probate has been rejected solely on the ground that the executor name is not found in the will.
Executor name.
Name was not found in the will, and the execution of the work is not mentioned in the will. That is the findings before the trial court. Apart from that, the will has been proved. The issue number 1 has been framed and it is affirmed. In page number 15. And subsequently, when consideration of para number 2 is rejected for grant of probate.
ವಿಲ್ಲನ್ ಏನಿಲ್ವಾ ಆ ರೀತಿ?
Please, ma'am.
ವಿಲ್ಲನ್ ಏನ್ ಇಲ್ವಾ ಅಂದೆ?
ಇದೆ ಇದೆ.
ಎಕ್ಸಿಕ್ಯೂಟರ್ ನೇಮ್ ಇದೆಯಾ ಇಲ್ಲ?
Executor name is it is there.
ಇದ್ರ ಮತ್ತೆ ಇಲ್ಲ ಅಂತ ಹೇಗೆ ಬರೀತಾರೆ?
Kindly see the will it is there.
ಕಾಪಿ ಹಾಕಿದೀರಾ?
The certificate copy of records is not coming.
ವಿಲ್ ಕಾಪಿ ಹಾಕಿದೀರಾ ಅಂದೆ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
ಹಾಕ್ಬೇಕಲ್ಲ.
It is there, your lordship kindly see, the certificate copy is there.
ನಿಮ್ಮ ಹತ್ರ ಇದೆ, ಕೋರ್ಟ್ ಮುಂದೆ ಇರ್ಬೇಕಲ್ರಿ? ಹಾಕಿಲ್ಲ ನೀವು, ಕೊಡಿ. ಮಾರ್ಕ್ ಮಾಡಿದೀರಾ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Yes, ಆಗಿದೆ.
ಮತ್ತೆ ಹಾಕ್ಬೋದಿತ್ತಲ್ಲ ನಿಮ್ಮ ಅಪೀಲ್ ಜೊತೆನೆ. ಎಲ್ಲಿದೆ ಹೆಸರು?
Your lordship kindly para number
ನೇಮ್. ಎಕ್ಸಿಕ್ಯೂಟರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ವಾಟ್ ಆರ್ ದಿ ಡ್ಯೂಟೀಸ್ ಆರ್ entrusted to the executor?
he put up a construction, he is enjoying the property.
ಎಲ್ಲಿದೆ ಅದ್ರಲ್ಲಿ ಇದೆಯಾ ವಿಲ್ಲಲ್ಲಿ?
Para number 2, second page, your lordship kindly go there. ನನ್ನ 2 ಮಕ್ಕಳು ಪ್ಲೀಸ್. ನನ್ನ 2 ಗಂಡು ಮಕ್ಕಳು ಅವರೊಬ್ಬರು ಕಾರ್ಯನಿಮಿತ್ತವಾಗಿ ಅನ್ಯ ಸ್ಥಳಗಳಲ್ಲಿ ಅಂದರೆ ಎಸ್ ತುಳಸಿದಾಸ ಅವರು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಮತ್ತು ಎನ್ ಲಕ್ಷ್ಮೀಪ್ರಸಾದ್.
ಯಾವ ಪೇಜ್ ಓದ್ತಾ ಇದ್ದೀರಿ?
ಸೆಕೆಂಡ್ ಪೇಜ್ ಮಾಡು. ಸೆಕೆಂಡ್ ಪೇಜ್.
ಇಬ್ಬರು ಗಂಡು ಮಕ್ಕಳು
ಪ್ಲೀಸ್
ಅವರವರ ಕಾರ್ಯನಿಮಿತ್ತವಾಗಿ ಅದಾ
ಅನ್ಯ ಸ್ಥಳಗಳಲ್ಲಿ ಅಂದರೆ
ಆಯ್ತು.
ಎಸ್ ಎನ್ ತುಳಸಿಕಾಂತ್ ಅವರು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಹಾಗೂ ಎನ್ ಲಕ್ಷ್ಮೀಕಾಂತ್ ಅವರು ತುರುವೇಕೆರೆಯಲ್ಲಿ ವಾಸವಾಗಿರ್ತಾರೆ. ಹಾಲಿ ನನ್ನ ಹಿರಿಯ ಮಗ ಎನ್ ತುಳಸಿಕಾಂತ್ ಅವರು ನಿಯಮಿತವಾಗಿ ಮಣ್ಣೆ ಗ್ರಾಮ ಅಂದ್ರೆ ವಿಲೇಜ್ ಮಣ್ಣೆ ಗ್ರಾಮಕ್ಕೆ ಬಂದು ನನ್ನ ಅನ್ಯಗತ್ಯಗಳನ್ನು ಸರಿಯಾಗಿ ಸ್ಪಂದಿಸಿ ನನ್ನ ಪಾಲನೆಯ ಪೋಷಣೆಗೆ ಎಲ್ಲಾ ಜವಾಬ್ದಾರಿಗಳನ್ನು ನಿರ್ವಹಿಸುತ್ತಾರೆ. ಹೀಗಿರುವಲ್ಲಿ ನನ್ನ ಸ್ವಂತ ಊರಾದ ಮಣ್ಣೆ ಗ್ರಾಮದಲ್ಲಿ ಹಾಲಿ ಮತ್ತು ನಾನು ವಾಸವಾಗಿರುವ ಮನೆ, ಅದಕ್ಕೆ ತಗಲಾಯಿತು ಪಾಳು ನಿವೇಶನ ಹಾಗೂ ಮಣ್ಣೆ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ನನ್ನ ಬಾಪ್ತು ಜಮೀನು ನನ್ನ ಸ್ವಯಂಚಾಲಿತವಾಗಿ ಬಂದದ್ದು. ಸದರಿ ಸತ್ವಿನ ವಿವರಗಳನ್ನು ಮುಂದೆ ನನ್ನ ಮಕ್ಕಳಲ್ಲಿ ಭಿನ್ನಾಭಿಪ್ರಾಯಗಳು ಬರಬಾರದೆಂದು ಸುದ್ದೇಶದಿಂದ ಮತ್ತು ವಯಸ್ಸಾದ ನನ್ನ ಪಾಲನೆ ಪೋಷಣೆಯನ್ನು ನಿರ್ವಹಿಸುತ್ತಿರುವ ನನ್ನ ಹೆಂಡತಿಯ ಪಾಲನೆ ಪೋಷಣೆಗಾಗಿ ಅಪಾರ ಹಣವನ್ನು ವೆಚ್ಚ ಮಾಡಿದ ನನ್ನ ಹಿರಿಯ ಮಗನಾದ ಎನ್ ತುಳಸಿಕಾಂತ್ ಅವರು ನನ್ನ ಸ್ವಂತ ಊರಾದ ಮಣ್ಣೆ ಗ್ರಾಮದಲ್ಲಿ ಮನೆಯನ್ನು ಕಟ್ಟಿಕೊಂಡು ವಾಸ ಮಾಡಿಕೊಂಡು ವಂಶ ಗೌರವವನ್ನು ಕಾಪಾಡಲಿ ಎಂದು ಸ್ವದೇಶದಿಂದ ಸಹ ನಾನು ಈ ದಿವಸ ಈ ಮರಣ ಶಾಸನ ಬರೆದಿರುತ್ತೇನೆ. ದಿಸ್ ಇಸ್ ಅನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್. The next page.
It is a reason for
will. Next page, next para. The second para. ನನ್ನ ಮರಣ ನಂತರ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿರುವ ನಮೂದುಗಳನ್ನು ನನ್ನ ಹಿರಿಯ ಮಗನಾದ ಎನ್ ತುಳಸಿಕಾಂತ್ ಅವರಿಗೆ ಮಾತ್ರ ಸೇರತಕ್ಕದ್ದು. ವಿನಃ ಇದರಲ್ಲಿ ನನ್ನ ಇನ್ಯಾವ ವಾರಸುದಾರಾಗಲಿ ಅಥವಾ ವಿವಿಧ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳನ್ನು ಇರುವುದಾಗಲಿ ಎಂಬುದು ನನ್ನ
ಅವನಿಗೆ ಸೇರುತ್ತೆ ಅಂತ.
ಪ್ಲೀಸ್ ಮಾಡಿ.
ಆಮೇಲೆ
The name has been clearly mentioned. The beneficiary name has been clearly mentioned in the will.
Beneficiary name, but executor name ಇಲ್ಲ ಅಂತ ನೀವು ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಅಂತ ಅಂದ್ರಲ್ಲ ಈಗ.
The reasoning is given by para number 16 in the impugn order. Lordships kindly go. It is covered by issue of lordship's own judgments in MFA number.
Issue probate and succession certificate in his favor on the death of late so-and-so in the interest of justice and equity.
The para number 16 is the forthcoming reason. My lord, lordships kindly see page number 19 in my appeal memo. But it's pertinent to note that this petition was filed seeking for issuance of probate petition certificate under section 276 of the Indian Succession Act. Under section 3.
ಯಾವ para ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Lordships para number 16 page number 19.
16.
Please more. Indian Succession Act. The under section 222 of the Indian Succession Act says that the probate can be granted only on the execution appointed by the will. The said appointment may be expressed by necessary implication. I have perused the averments in the will filed by the petitioner, wherein the said N. Narsimaya was executed a will in favor of the petitioner, but the said will is silent with respect to execution of work and etc. Act. Unless and until there is some execution of under the will, probate cannot be issued. Then, in order to issue a probate certificate, there must be an appointment of executor of the will. So, when no executor is appointed, or when no execution is stated under the will, the issuance of probate certificate does not arise at all. This is the reasoning entirely.
ಆಯ್ತ್ರಿ, ಇಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟರ್ ಇಲ್ವಲ್ಲ.
The executor is
petition is filed by the beneficiary. No work is entrusted to the executor.
He is then
what he has to do ಅಂತ
ಬರಿದ್ದಾರೆ, ಮನೆ ಕಟ್ಕೊಂಡು ಇರ್ಲಿಕ್ಕೆ ಅಂತ ಬರಿದ್ದಾರೆ.
ಮನೆ ಕಟ್ಕೊಂಡು ಅವ್ರು ಇರ್ಲಿ ಅಂತ.
ಯಾರು
No work was entrusted to the executor. No executor at all. You are the beneficiary only. That is the reason only given in paragraph number 16.
my will is mentioned that for all those.
Will ಅಲ್ಲಿ ನೀವು ಎಂಜಾಯ್ ಮಾಡಿ ಅಂತ ಇದೆ ಅಷ್ಟೇನೆ.
But benefits in them, your lordships is judgments, my lord, it is covered under all the things.
ಏನು ಕವರ್ ಕೊಡಿ ನೋಡೋಣ. ಇಲ್ಲ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಎಕ್ಸಿಕ್ಯೂಟರ್ ಇಲ್ವೇ ಅಲ್ವಲ್ಲ?
In para number 10th, it's commence more page number 7. Para number 10, it's commence more page number 7 in the judgment. And your lordship says observed that more. And the learned counsel for the appellant has brought to the notice of this court in very provisions of under section 217, 218, 220, 222, 223, 224, 227, 229, 321, 322, 234, and 276 of the Act. And also read up the judgment of the Honorable Delhi High Court in Indra Chandra so and so, reported in 1977, Delhi in 94. The judgment of the Appeals Court Sunil Gupta and Kiran so and so, reported which has been referred by the trial court. The counsel referred to these two judgments, Delhi High Court and Apex Court contended. The two judgments are out place with regard to factual aspects of the case on hand. Your lordships kindly see. Having regard to concern, heard the counsel of the appellant also consider the materials on record. The point would be consideration. The trial court committed an error in dismissing the petition in coming into the conclusion that without naming the execution of the will, or a probate cannot be granted, whether it requires to be interfered by this court. The findings has been arrived on page number 13. Having perused the judgments of the apex courts as the principal laid down by the laid down in the said judgment, it is regard to the probate proceedings. And if the probate is initiated, the transferee would be deemed to have been noticed thereof. The same is not issued involved in between the parties. With regard to the appointment of executor, no doubt the Delhi High Court come to a conclusion that the probate cannot be granted in any unless or until his name in the execution of the will. The judgment of the year 1977 in a very similar issue was consideration MFA number 3238 of 2019 dated so and so by this court for a point of consideration name framed by this court, having considered the factual aspects and case directly touch upon the issue involved in the case on hand. The point for consideration framed by this court is whether the beneficiary could be a file in petition under section 276 of the Act when there is no execution of the appointee, whether court can grant a probate of a will on the petition filed by the beneficiary. Then you will also be having regard to the point for consideration, also very provisions under section 222 subclass 2 and 231 and 243 of the Act. It details discussion with regard to a factual aspect of the said case. I come to conclusion that no doubt section 234 of the Act state that when there is no executor, there a person or a person who would be entitled for administration of the estate of the deceased, if he has died, estate or any other legatee having a beneficial of interest or creditor may be admitted to prove the will. Later of administration may be granted to him or them accordingly. Thus, from conjoint reading of section 202 subclass 2 and 234 of the Act, it is clear that it is not only executor named in the will can be seek for a probate, but depending upon the circumstance, whether the other person could also seek and probate. Then having regard to consideration of the principle laid down by the judgments of this court and also consider the factual aspects of the case in hand, non-claimed interest of the respect subject matter of the will, it is important to note that the notice is also issued in Hosa Diganta and Indian Express newspapers, so and so different dates, and none appeared and claimed to any interest. It is important to note that the will was executed in favor of the beneficiary. Admittedly, no executor has been appointed. Mere non-appointment of an executor cannot be ground to reject the grant of probate. This court is already decided the similar matter in the appeal referred supra. The request of the wife was turned down. The claim right based on the will and present appellant have also approached the concerned department for transfer of kata has also rejected. Under the such circumstance, sought for a relief of probate and succession certificate. When such a claim is made in instance case as well as the appellant have been proved the will by execution of two witnesses, PW2 and PW3 are attested. The trial courts ought to have been rejected the same. In come to a conclusion, probate cannot be granted if the no executor name has been the will. The very approach of the trial court is erroneous and failed to take note of the factual aspects of the case and failed to consider the facts and registered will he is executed in favor of the appellant, and same has been proved by the compiling under section 63 and 60 of the Indian Evidence Act as a will as well as the Indian Succession Act 1925. And such being a case, the trial court ought to have been come to a conclusion that a very approach of the trial court is erroneous and requires to interpret by this court.
What is the prayer you have sought before the trial court?
Sought for
Was there any pleading that transfer of records has been refused?
yes, I sought for that more.
Was there any
I sought for that.
such pleading?
Sir, pleading is there. I have approached before the revenue authorities based
What
on
was the need of seeking the relief of probate?
Well, I approached before the revenue authorities for change of revenue revenue documents in my favor. In the month of 2020, in the month of June 2023, when they have declined to transfer my name, therefore I approached before the court. The para number 5 of the my petition is there.
The order is earlier. This court has referred the order in MFA.
The division bench order, my lord.
3238 of 2019 dated 7/11/2019. Idya ನಿಮ್ಮ ಹತ್ರ? Wherein the same point for consideration was framed.
My lordship, MFA number?
3238 of 2019 dated to 7/11/2019.
It is not there, my lord.
This court referred the earlier order passed by this courts while allowing the petition.
It is not there, my lord.
ನೋಡಿ ತಗೊಂಡ್ ಬನ್ನಿ ಅದು ಕಾಪಿ ನೋಡಿ. ನೋಡಿ heard in part. The counsel for the petitioner appellant is directed to produce the copy of the order passed by this copy of the order passed in MFA number 3238 of 2019 dated 7/11.
It is there, my lord. Please. I'm sorry, please. Only one copy is there, man. I'm sorry to read it.
Division bench judgment.
ಒಂದೇ ಕಾಪಿ ಇದೆ.
Third. Heard the appellant counsel. The present appeal is filed, praying this court to set aside the impugned order dated 15/6/24, passed in P&SC number 59 of 23, passed by the 9th Additional District and Session Judge, Bangalore Rural District, Bangalore, and consequently allow the appeal and grant the probate and grant such other relief as deems fit in the circumstance of the case. The counsel appearing to the appellant would contend that trial court committed an error in dismissing the petition in coming to the conclusion that in the will, the executor has not been appointed and no work is also entrusted to the executor. And counsel brought to notice of this court to reasoning assigned in paragraph number 16 and 17. wherein trial court comes to the conclusion that probate can only be granted when there is an appointment of executor under the will. The council contend that the said finding is erroneous, and hence it requires interference. The council also, in support of his argument, relied upon the order passed by this court in MFA number 4399 of 2023, wherein also discussed with regard to the issue involved, and council submits that similar issue has been considered by this court by framing a point for consideration whether the trial court committed an error in dismissing the petition, in coming to the conclusion that without naming the executor in the will, probate cannot be granted, and whether it requires interference of this court. The council also brought a notice of this court. This court in detail discussed the issue involved, and also even referred the order passed by this court in division bench in MFA number 3238 of 2019, dated 7/11/2019. And the same is also placed before this court. This court in detail passed an order, even discussing whether the beneficiary could file a petition under section 276 of the act when there is no executor appointed, and whether the court can grant probate of a will on a petition filed by a beneficiary. And also taken note of conjoint reading of section 222 within bracket 2 and section 234 of the act, and comes to the conclusion that it is clear that it is not only the executor named in the will can seek for a probate, but depending on the circumstances, whether other person could also seek such probate. And allowed the appeal. The division bench of this court also, the MFA number 3238 of 2019, particularly in paragraph number 8, having considered the factual aspect in the said case, in paragraph number 8.16, made an observation that appellant is the wife and heir of the deceased testator, as also she has been named as a legatee in the last will and testament of the testator. On both these grounds, when no executor is named, she would be eligible to seek for probate and or letters of administration, and hence allowed the appeal invoking section 276 of the act, in coming to the conclusion that the same is proper and valid, and not permitting the legatee to seek for probate of a will would render the will ineffective and thereby negate the last wishes of the testator. There ought to be a meaningful reading, meaning and interpretation given to the provisions of the act, so as to permit the legatee to be an executor in the event of no executor being named in the will. Having considered the discussion made by this court in miscellaneous first appeal number 4399 of 23, as well as division bench of this court in MFA number 3238 of 2019, and reason given by the trial court in paragraph number 12, plus 16 and 17 is not correct. And the conclusion of the trial court that probate can be granted only to the executor if he has been appointed as executor and work was entrusted, and the reason that the said will is silent with respect to execution of any work, and unless and until there is some execution under the will, the probate cannot be issued, cannot be sustainable in the eye of law, and hence the trial court has committed an error in rejecting the petition filed for grant of probate and succession certificate. Next para. The reason is also assigned in the application before the trial court while seeking the probate and succession certificate. Is very clear that the testator has executed the will and kept the same in the trunk, and recently in the month of June 2023, when the petitioner was searching for some documents, found the will and immediately applied for transfer of kata before the revenue authorities, but they have instructed him to obtain probate and succession certificate from the court and hence approach the court for the grant of the probate and succession certificate. And when such reasons has been assigned while seeking the relief, the trial court ought to have taken note of the grounds which have been urged in the petition. And hence, the order impugned is liable to be set aside. In view of the discussions made above, I pass the following order. Appeal is allowed. The impugned order is set aside. And the relief sought in the petition is granted as sought before the trial court by granting the probate and succession certificate in favor of the petitioner.
Grateful.
44, G.S. Venkata Subbarao, Vamshi Krishna.
I appeal for
grant.
respondent number 1 and 3.
22 or 23 minutes. In authorization, madam. We'll take up on 23 minutes.
Apparent counsel seeks time on the ground that senior counsel is out of station. Out of station.
23 or 24.
And counsel for respondent is present. List this matter on 29th. 29/10.
45, Srihari A.V.
For the appellant, my lord. Suit for partition and separate position along with the main profit filed by the one of the daughters. That is the respondent number 1, my lords. The appellant and appellant is the mother. The respondent number 2 and 3 are the sister and.
ಯಾರು ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
Nanne direction.
The appeal is not maintainable since the appellant is already relinquishes her right in respect of A and C scheduled properties. When she is not having a right on the.
ಆಯ್ತು, ಈಗ ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀರಿ.
ಯಾವಾಗ?
ಇವತ್ತ.
Counsel Sri
ಆದಿನಾರಾಯಣ್.
Adi Narayan submits that he has filed wakalat for respond number
1.
ಒಬ್ರೇನಾ? ಒಬ್ರೇ ಇರೋದಾ?
ಅಲ್ಲ first respondent.
First respondent.
First respondent.
ಬೇರೆಯವರು ಇದಾರಾ?
ಇದಾರೆ ಅವ್ರಿಗೆ dispense, I will file a memo, my lords.
ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ ನೀವು? ಇಲ್ಲ
ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ಲ. The counsel files memo to dispense the notice against respond number
2 and 3.
2 and 3.
Please, ma'am.
And hence notice against R2 and R3 is dispensed at the risk of the appellant.
Please.
This matter on ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
ಇಲ್ಲ, ಇದೇನಾಗಿದೆ ಅಂದ್ರೆ receiver is appointed. Kindly see-
only collecting the rent.
ಹೌದು.
Collection of rent.
Deposit.
ಅಲ್ಲ, along with the suit, 2 applications are filed. One is for 39 rule 1 and 2, another one is for appointment.
ಎರಡು allowed in part.
ಅಲ್ಲ, they are allowed. Both the applications are allowed.
Allowed in part.
Please, kindly see the application filed by the respondent number 1, madam.
ಅವ್ರಿಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ, ಅದೇನಾಗಿದೆ real court ಅಲ್ಲಿ.
On merits, may kindly see the ink page 25.
25. ರೆಡಿ ಇದ್ರ ಹಿಯರ್ ಮಾಡ್ಬೋದಾ?
ಹೌದು.
ಆಯ್ತು ಹೇಳಿ.
This has been evidence from the fact that the dependent number 1 and 2 have.
Page 25 ಅಲ್ಲ?
Ink page 25. Para 14.
Para 14 ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ ಹೇಳ್ಬೇಕು ನನಗೆ.
ಇದು ink page 25 ಅಲ್ಲಿ middle of the.
ಮಿಡ್ಲ್ ಅದನ್ನ ಹೇಳ್ಬೇಕು ಎಲ್ಲಿ ಅಂತ. This has been evidence from the fact that defendant number 1 and 2 have relinquished their rights
in respect of A and C scheduled properties through release deed. The 6/12/21 in favor of dependent number 3. The appellant right had been already transferred. The appellant right in respect of A and C scheduled property, he had been already transferred in favor of dependent number 3. When she is not having a right on the in respect of A and C scheduled property, challenging of the order doesn't arise.
May I make a submission? Kindly.
Whether you have relinquished your right or not.
I have relinquished in favor of my son, my lords, but I am staying with my son.
we are a family, we have a family understanding. In respect of the respondent number 1, a property was gifted by my husband. Other properties are given to the share of.
This is in respect of A and C schedule.
A and C schedule ಪ್ರಾಪರ್ಟಿನ
ಹೌದು
ನೀವು ರೈಟ್ ನ ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ?
ಹೌದು ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡಿದ್ವಿ.
ಮಾಡಿದ್ಮೇಲೆ ನೀವು ಮತ್ತೆ ಹೆಂಗೆ ರಿಲೀಫ್
ಅಲ್ಲ, out of the rents received, my son is taking care of me and he is giving monthly rentals to me. He is taking care of the property. Therefore, collecting rents and depositing in the court, it will affect my right, my lords. That is the summons substance. Now we will come to the application filed by the respondent number 1. What they have stated, what the reasons they have asserted. There should be some loss, damage, or demanding immediate action. Kindly see page number
D3. New plaintiffs entry.
Now
plaintiff.
Plaintiff ಇವರಿಗೆ ಆ ಪ್ರಾಪರ್ಟಿ ಸ್ಪೆಸಿಫಿಕ್ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ರೈಟೇ ಇಲ್ಲ ಅಂದ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಎಲ್ಲಿ ಬರುತ್ತೆ?
Kindly
ಸರಿ ರೀ, they have relinquished the right share, their right in favor of defendant number 3.
ಹೌದು.
Who is a brother of my plaintiff?
How a court can direct them to deposit the rent in the court?
The court commissioner has to deposit. The property is
appoint ಆಗಬೇಕು.
The property is my father property who died in the year of 2021.
ಆಯ್ತು.
After that, I have issued notice to all the defendants to partition the suit schedule properties. They have refused to share the property. He is collecting more than 6.5 lakhs by the third dependent. Wherefore, I have filed a suit for partition and also filed a application for appointment.
On what basis defendant number 1 has relinquished their right in favor of defendant number 3?
They have to
understanding is this, my lords. In 2021.
Now the question is,
I'll give the dates, my lords. I'll give the dates.
suit for entry.
Suit for partition and mean profit.
ಆಯ್ತಾ?
ಅವರು ಸೂಟ್ ಹಾಕಿದ್ದು 2023 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು.
6 to 20.
Originally property belongs to whom?
My husband. My husband.
Your husband.
Please, please.
Plaintiff ಯಾರು?
Plaintiff is the daughter, one of the daughter.
One of the daughter.
One of the daughter.
ಆಯ್ತು.
Second defendant is another.
Whether the husband of you
Please, man.
executed any document during the lifetime?
One gift deed.
Any testamentary document?
One gift deed came to be executed in respect of one property.
Whether he died intestate or not?
He died interstate, my lords, but before dying, on 24/3/2021, one property came to be gifted in favor of the respondent number 1 herein. Other family understanding is that other properties will be given to the all the remaining 3 LRs, that is wife, son and another daughter. Now, after taking that property in 2021, immediately that property came to be sold by the defendant number 1. After 2 years, she comes up with a present suit saying that I have 1/3 share. It is only a family understanding. I do admit that, my lord, there is no written instrument. It is a family understanding. Now, after 2 years, that is after 2021, in 2023, she has filed a suit. In this suit, the application is filed for appointment of receiver.
Gift deed was executed by whom?
My husband to the daughter. Father to the daughter. Gift deed is executed. That is not stated. That's why under order 40 appointment of court commissioner, conduct of the plaintiff is very crucial, my lords. That is what this honorable court.
What is that property was gifted in favor of the?
It is a site.
Site.
It is a site. That is not even whispered.
Site. We the third dependent had sold and taken the money from the site which had given to me. It is a independent site. This is the property what I have claimed. It is
ನಿಮಗೆ ಗಿಫ್ಟ್ ಮಾಡಿದಾರ ಇಲ್ಲ?
ಗಿಫ್ಟ್ ಮಾಡಿದರೆ ಅದು ನನ್ನ ತಮ್ಮನೇ ಮಾರ್ಬಿಟ್ಟು ದುಡ್ಡು ಅವ್ರ
ಮಾರಿಲ್ಲ, ಅದು ಬೇರೆ
ಹೆಸರಲ್ಲಿತ್ತು.
ಮಾಡಿದಿರಿ?
ನನ್ನ ಹೆಸರಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು ನಮ್ಮ ತಂದೆ ಒಂದು ಸೈಟ್, ಅದನ್ನ ಮಾರ್ಬಿಟ್ಟು ನನ್ನ ತಮ್ಮನೇ ತಗೊಂಡಿದ್ದಾರೆ. What ever the properties?
Why the father has given the property in favor of you?
No, since I don't have any property. Since I don't have any properties.
Father had made the provision during his lifetime in favor of you also.
She married in 1998.
Maybe there was no any partition, but already property was given to you in favor of you during the lifetime of the father.
During his lifetime only it was sold. This properties are
ನಿಮಗೆ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿದಾರ ಇಲ್ಲ?
ಕೊಟ್ಟಿದ್ರು, ಅದನ್ನ ಮಾರಿದ್ದಾರೆ.
ನಾವು ಮಾರಿಲ್ಲ,
ಮಾರಿದ್ದಾರೆ.
ಯಾರು ನೀವೇ ಮಾರಿರೋದು?
ಅವ್ರು ಮಾರಿರೋದು.
ನನ್ನ ಹೆಸರಲ್ಲಿತ್ತು, ನನ್ನ ತಮ್ಮ ಮಾರಿದ್ದಾರೆ.
ನಿಮ್ ತಮ್ಮ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? ನಿಮ್ಮ ಹೆಸರಲ್ಲಿರೋ ಪ್ರಾಪರ್ಟಿ ನಿಮ್ ತಮ್ಮ
ಹೋಗಿದೆ, ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ದುಡ್ಡು
ಕರ್ಕೊಂಡು ಹೋಗಿ ಮಾರಿದ್ದಾರೆ. ಬಟ್ This property stands, still stand in name of my father.
Family arrangement was made by executing a gift deed in favor of you.
Really, there is no recital, that
No,
in
at
respect
least
of joint family, I had given this property anta. ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
to show bona fides, they should have stated in the plaint. They won't state that.
Paint ಏನು
ಏನು ಹೇಳಲ್ಲ.
They have suppressed it.
They have suppressed. That's why conduct of the party is very important as per this landmark judgments, my lords. So far as appointment of court receivers, 5 conditions have to be fulfilled. Lordship may see paragraph 17 of this judgment, my lords. This is very old judgment, 1955. This has been followed even to this day, my lords. Page number 17, paragraph 17, my lords. Paragraph 17. 5 prints, may I read, my lords?
Was there any gift deed is executed in favor of another daughter?
No.
ಇಲ್ಲ, another daughter ಇಲ್ಲ.
ಇಲ್ಲ.
Only
ಡಾಟರ್ಗೂ ಇಲ್ಲ, ಮದರ್ಗೂ ಇಲ್ಲ, ಇವ್ರಿಗೂ ಇಲ್ಲ.
ಯಾರಿಗೂ ಇಲ್ಲ.
ಎಲ್ಲ. ಇವ್ರು 28 ವರ್ಷದಿಂದ ಮದುವೆ ಆಗಿರೋದು.
ಅಲ್ಲ ಸರ್,
2 ವರ್ಷ
ಇದು ನಮ್ಮ ಅಪ್ಪನ ಆಸ್ತಿ ನನಗೆ.
ಅಪ್ಪನ ಆಸ್ತಿ ರೀ, ನೀವು ಅಪ್ಪನ ಆಸ್ತಿನೇ ತಾನೆ ನಿಮ್ಗೂ ಗಿಫ್ಟ್ ಮಾಡಿರೋದು.
ಅಲ್ಲ, ಅಪ್ಪ ಕೊಟ್ಟಿದ್ರು, ಅಪ್ಪ ಇರುವಾಗ್ಲೇ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಮಾರಿದ್ದಾರೆ. ಇದರಲ್ಲಿ
You have enjoyed the
fruits
sale-
of the- I have not,
sale proceeds.
ಇಲ್ಲ ಇಲ್ಲ.
I may be permitted to read this, man. Very interesting judgment.
Huh.
The 5 principles which can be described as a panch sadachar of our courts exercising equity jurisdiction in appointing receivers are as follows. Appointment of a receiver pending a suit is a matter of resting in the discretion of the court. Discretion is not arbitrary or absolute. It is a sound and judicial discretion, taking into account all the circumstances of case, exercised for the purpose of permitting ends of justice and protecting the rights of the parties interested in the controversy and subject matter, and based upon the facts, there is no other adequate remedy or mean accomplishing the described desired objects of the judicial proceedings. Second matter, court should not appoint a receiver except upon a proof by the plaintiff that prima facie he has a very excellent chance of succeeding in this suit. ಮೂರನೇದು, not only there must be the plaintiff show a adverse and conflicting claims to the property, but he must show some emergency or danger or loss demanding immediate action, and of his own right he must be reasonably clear, free from the doubt. The element of danger is an important consideration. The court will not act on possible danger only. The danger must be great and demanding immediate relief. It has been truly said that court will never appoint a receiver merely on the ground that it will do no harm. ನಾಲ್ಕನೇ ಸ್ವಾಮಿ, an order appointing receiver will not be made. ಇದು ಬೇಕಾಗಿಲ್ಲ, ಐದನೇದಕ್ಕೆ ಬರ್ತೀನಿ. The court on the application of receiver looks into the conduct of the party who makes the application and who usually refuses to interfere unless his conduct been free from blame. He must come to the court with clean hand, and he should not be disentitled himself to the equitable relief by the laches, delay or acquiescence, etc. Therefore, these 2 conditions, one is immediate danger or demand for what is the loss to the property, as well as conduct of the plaintiff is very important. If Lordship sees application at 52, page number 52, except for stating that the plaintiff has 1/4 share, nothing is stated. ಏನಂತ ನಮ್ಗೆ ಇಲ್ಲಿ ತೊಂದರೆ ಇದೆ, if the rents are not deposited before the court, this is the damage which will be caused to us, nothing. And even the trial judge also, he proceeds to hold that they have an excellent case, therefore they are entitled for the relief. The findings are at page number 20 and paragraph number 20 onwards, page number 30, my lords.
Whether you took the defense in the written statement that already property was given.
Please, my lord, that is family understanding ಆಗಿದೆ ನಮ್ದು. Therefore that property gift, ಅವ್ರು gift ಕೊಟ್ಟಿರೋ ಪ್ರಾಪರ್ಟಿ ಅವ್ರ ಹತ್ರ ಇತ್ತು, ಉಳಿದಿದ್ದು ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನಾವು ತಗೊಂಡಿದ್ದೀವಿ.
Rent agreements.
Really the discussion.
Written statement is at page number 56 onwards, my lords. 56, annexure D.
Written statement.
Please, my lords.
Paragraph.
I'll mention so on. If your lordship sees paragraph 18, page number 66, my lords. ಅಲ್ಲಿಂದ ಹೇಳ್ತಾ ಹೋಗ್ತಿದ್ದೆ. Defendant respectfully submits that during the lifetime of defendant's husband H. Shankarappa, apart from spent huge amount towards performance of marriage, he also gifted property under a registered gift deed dated 24/3/2021, wherein gifted a property bearing so and so, so and so. It is further submitted that the execution of gift deed
Gift was in the year 2021.
ಹೌದು
Suit was filed in the year
2023.
ಹಾ.
ಅಲ್ಲಿವರೆಗೂ ಇದು ರೆಂಟ್ಸ್ ಬಗ್ಗೆ ಏನು ಅವ್ರದ್ದು ತಕರಾರೇ ಇಲ್ಲ.
ನಾನು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. I have stated in my plain
ನೋಟಿಸ್
seeking demand of partition.
ಅದೆಲ್ಲ ಆಯ್ತ್ರಿ, ನೋಟಿಸ್ ಆಯ್ತು. ಬಟ್
ನಾವು ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮೆಲಾಡ್ಸ್
ಗಿಫ್ಟ್ 21 ಅಲ್ಲಿ ನೀವು ಗಿಫ್ಟ್ ತಗೊಂಡಿದಿರಲ್ಲ.
ಹೌದು, ಅವರು ಫಾದರ್ ಎಕ್ಸ್ಪೈರ್ ಆಗಿದ್ದು ವಿತಿನ್
and interest for the rent properties and also belonging to different number 3 agreed to relinquish all rights also.
Now the suit was filed in 2023. Gift was in 2021 and father died on 2 months after marriage, that is 21/5/2021. They had any right over the property, they should have approached immediately. After 2 years they have filed this suit.
Plaint ಅಲ್ಲಿ I have issued notice at the ink page party.
Notice ಆಯ್ತ್ರಿ. Have you pleaded with regard to the gifting of
No,
property?
no,
in favor of
not
you?
even a whisper, my lords. About the gift, not even a whisper. And now trial court, my lords, if your lordship sees the findings of the trial court, page number 30, my lords. 20 onwards, IA number 2 ಬಗ್ಗೆ ಹೇಳ್ತಾ ಹೋಗ್ತಾರೆ. Insofar as IA number 2 appointment of court receiver is concerned, income generate.
There are 2 IAs.
2 IAs.
One IA ಏನು?
Temporary
alienate.
not to alienate. We are not challenging that.
Only appointment of receiver.
Only appointment of receiver. No reasons are assigned. Paragraph 31 ಅಲ್ಲಿ if your lordship sees in the bottom, my lords.
ಹೇಳಿದ್ದಾರೆ ನೋಡಿ ಸರ್, 15ರಿಂದ ಹೇಳ್ಕೊಂಡು
ಅಲ್ಲ ಅದನ್ನೇ ಓದ್ತಾ ಇದ್ದೀನಿ.
ಅದರಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ.
ಇದು paragraph 30 page number 31 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ಸ್ ಮೇಲೆ 3 lines.
ಇದೆಂತದ್ರಿ ಎಕ್ಸಲೆಂಟ್ ಚಾನ್ಸ್.
ಅಷ್ಟೇ, ಎಕ್ಸಲೆಂಟ್ ಚಾನ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದ ಸೂಟ್ ಅವ್ರದ್ದು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಬೇಕು. What is the danger? What is the immediate action should be taken? Nothing is stated. Conduct we have stated nothing. We have cited 3 judgments. Judgments cite ಮಾಡ್ತಾರೆ ಬಿಟ್ರೆ what is the judgment ಅಂತಾನೂ ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ. This judgment was cited by the Honorable Trial Court, my lord, but
ರಿಗಾರ್ಡಿಂಗ್ ಗಿಫ್ಟ್ ಕೊಟ್ಟ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್ ಈ ಕೇಸಲ್ಲಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಆರ್ಡರ್ ನಲ್ಲಿ
ಮಾಡಲ್ಲ ಅವರು. ಮಾಡೇ ಇಲ್ಲ. ಒಂದ್ ಕಡೆ ಇದ್ದಂಗಿದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಹೇಳಿ.
ಪ್ಯಾರಾಗ್ರಾಫ್ ಪೇಜ್ ನಂಬರ್ 23 ಪ್ಯಾರಾ 13 ಅಲ್ಲಿ ನಮ್ ಕಂಟೆನ್ಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ.
ಕಂಟೆನ್ಷನ್ ಬ್ಯಾಡ್ರಿ, ರೀಸನಿಂಗ್
ಇಲ್ಲ. ರೀಸನಿಂಗ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
When they have no existing right, how their interest is affected for appointing the court commissioner? That is the question. When they have no existing right in respect of A or C schedule property, the appellant is how affected their right to challenge the order passed by the trial. ಇವ್ರಿಗೆ ಈ ಆಸ್ತಿಯಲ್ಲಿ ಹಕ್ಕೆ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಅವ್ರ ಹಕ್ಕ ಮೇಲೆ ಯಾವ ರೀತಿ ತೊಂದರೆ ಆಗುತ್ತೆ ಕೋರ್ಟ್ ಆರ್ಡರ್?
ಈ ಡಿಫೆಂಡ್ ನಂಬರ್ 3 ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ವಾ?
ಇನ್ನ
represented before the court, not
He is
deposited
enjoying
the
the
rents
fruits.
are
6.5 ಲಕ್ಷ ರೆಂಟ್ ಬರುತ್ತೆ.
under the circumstances it is necessary to appoint the court commissioner. Why the third defendant is not before?
ಅವ್ರಿನ್ನ ಅಪೇರ್ ಆಗಿಲ್ಲ ಸರ್. ಅವ್ರಿನ್ನ ಅಪೇರ್ ಆಗಿಲ್ಲ.
They are hand in glove with each other.
ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದಿರಿ ನೀವು?
ಮಾಡಿದೀವಿ. ಅವ್ರಿಗೆ ಬೇಕಾದ್ರೆ ನೋಟಿಸ್ ತಗೊಂತೀವಿ.
ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
ಆಯ್ತು. I'll take notice to both of the respondents, my lords. Both the respondents.
ಈಗ ನೀವು both respondents ಯಾರ್ಯಾರು?
ಇನ್ನು ಇಬ್ರು 2 and 3 ಇದಾರೆ. 2 ಮಾತ್ರ ಮೆಮೊ ಹಾಕ್ತೀನಿ, 3 ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಸ್ವಾಮಿ.
ನೋಡಿ, the counsel appearing for filed memo ಅಂತ ಬಂತಲ್ಲ, dispense the notice against
ಕೊಡ್ತೀನಿ.
R2. The same is dispensed. Issue emergent notice against respond number 3.
Start for
The
stay.
counsel appearing,
I start for stay, my lords, because
ಇಲ್ಲ ನೋಡಿ ಸ್ವಾಮಿ, ಲಕ್ಷಾಂತರ ರೂಪಾಯಿ ರೆಂಟ್ ಎಂಜಾಯ್ ಮಾಡ್ತಿದ್ದಾರೆ D3.
ನೀವು ಎಂಜಾಯ್ ಮಾಡಿದಿರಲ್ಲ.
ಅಲ್ಲ ನಾವಿಲ್ಲಿ
ಪ್ರಾಪರ್ಟಿ ಗಿಫ್ಟ್
ಕೆಂಗೇರಿಯಲ್ಲಿ
ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಸೋಲ್ಡ್.
ಕೋರ್ಟ್ ಕಾಣಿ ಎಲ್ಲಿ ನನ್ಗೆ ಕೊಟ್ಟಿರೋದು
ನೀವ್ ಯಾಕೆ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ ನಾವು ಸಪ್ರೆಸ್ ಮಾಡಿರೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ.
ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ ನಾವು ಸಪ್ರೆಸ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಬರಲಿಲ್ಲ. ಅವರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನನಗೆ ಕೊಟ್ಟಿರೋ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ ಅಂತ ಹೇಳಿದಾರೆ ನೋಡಿ.
Heard the appellant counsel and also the counsel appearing for the respond number 1 and counsel for the
ಪುತ್ತನಹಳ್ಳಿ ಅಂತ
appellant insists for
ಕೆಂಗೇರಿಯಲ್ಲಿ
granting of stay on the ground that the respondent number 1 got the share in the property by way of gift
ಲಿಂಗದೇರ್ನಹಳ್ಳಿ ಕೆಂಗೇರಿ ಹೋಬ್ಳಿ ಎಲ್ಲೋ
executed in
ಹಳ್ಳಿ
the year 2021 and immediately filed the suit in 2023 and already sold the property which was gifted on 24/3/2021 in favor of the plaintiff respondent and suppressing the said fact in the plaint had approached the court and obtained an order and having considered the factual aspect of granting of gifting of property in favor of the respondent number 1 in the year 2021 and filing of the suit, it is appropriate to stay the impugned order till the next date of hearing. Passed on I number
2, my lords.
2 till the next date of hearing. This matter on 4th of November.
Much obliged. Notice to R3 ಅಂತ.
R3 ಮಾಡಿದ್ನಲ್ಲ, issue notice to R3.
okay.
You pay PF immediately.
Please, today,
If you fail to pay the process,
today itself.
next date it will be vacated.
We'll pay today.
Heard in hearing 46,
Hmm.
Vinod Reddy V.
For the appellant.
RSA.
Suit is for specific performance.
Hmm.
Trial court decreed this suit.
Why it was adjourned earlier?
Earlier it was adjournment on the other side. They requested.
Release ಮಾಡೋಣ, ಆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗ್ಬಿಡಿ. ರೆಗ್ಯುಲರ್ ಯಾರು RSA ಬೆಂಚ್ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ.
This is after hearing the lengthy hearing.
Hearing ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಪಾಠ ಆಗಿದೆ ಸ್ವಾಮಿ.
Parted. ಆಯ್ತು ಕೊಡಿ.
Suit is for specific performance decreed by the trial court. First appellate court reversed on the ground that there is a recital in the
Divergent finding.
agreement saying that since there is an prohibition of registration of bits of lands, it cannot be registered. And the trial court says that, the first appellate court says that, well, this appeal is an premature. The suit is an premature, hence it cannot be decreed. Suit
Only
cannot
on
be
the ground of
dismissed.
premature.
Yes, my lord. After hearing this, my lord, this honorable
ಅದೇನ I directed you to
directed,
produce
I have
documentation.
produced the circular.
ಏನೋ last time ಏನೋ circular ಕೊಡಿ ಅಂತ ನನಗೆ
Gazette
ಹೇಳಿದ್
notification
ನೆನಪಿದೆ.
has been produced.
ಹಾ.
In the Gazette notification, the notification says that, my lord, page number 3, first param, ಅನುಬಂಧ 1 ಅದರಲ್ಲಿ. ಈ ಕೆಳಕಂಡ ಕೃಷಿ ಜಮೀನುಗಳು ಅಥವಾ
Second, ಯಾವಾಗ ಹಾಕಿರೋದು ನೀವು?
ಅಲ್ಲ ಸಪರೇಟ್ ಆಗಿ ಮೆಮೋ ಹಾಕಿ
ಮೆಮೋ ಹಾಕಿದ್ರೆ ಯಾವತ್ತು ಹಾಕಿದ್ರಿ ಹೇಳಿ.
ಮೆಮೋ is filed on
7/2024.
10/7/2024.
24.
ಈ ಕೆಳಕಂಡ ಕೃಷಿ ಜಮೀನುಗಳು ಅಥವಾ ಭೂ ಪರಿವರ್ತನೆಯಾದ ಅಭಿವೃದ್ಧಿ ಹೊಂದದ ಸ್ವತ್ತುಗಳನ್ನು ಪರಭಾರೆ ಮಾಡು-
ಓದ್ತಾ ಇದ್ದೀರಿ ಅದರಲ್ಲಿ?
ಮಲಟ್
ನೀವು ನೋಟಿಫಿಕೇಶನ್ ಹಾಕಿದಿರಿ?
Yes, my lord.
Gazette notification.
Gazette notification, where it has been permitted for the registration of the lands. At page number 3, my lord.
ಅದನ್ನೇ ಕೇಳಿದೆ ಯಾವ ಪೇಜ್ ಅಂತ.
Page number 3, ಅನುಬಂಧ 1. ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪೇರ ಫಸ್ಟ್ ಅಂತ ಒಂದು ಈ ಕೆಳಗಂಡಂತೆ ಕೃಷಿ ಜಮೀನು ಅಥವಾ ಭೂ ಪರಿವರ್ತನೆಯಾದ ಅಭಿವೃದ್ಧಿ ಹೊಂದದ ಸ್ವತ್ತು ಪರಭಾರೆ ಮಾಡುವುದಾಗಿ ಕೆಳಕಂಡಂತೆ ದರಗಳನ್ನು ಅಳವಡಿಸಲಾಗಿದೆ. 5 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ವರೆಗೂ ಜಮೀನಿಗೆ 5 ಗುಂಟೆ ಸೇರಿದಂತೆ ಇನ್ಕ್ಲೂಡಿಂಗ್ 5 ಗುಂಟಾಸ್ ಅಂಡ್ ಅಪ್ ಟು 5 ಗುಂಟಾಸ್ ಸಂಬಂಧಿಸಿದ ಆಯಾ ಪ್ರದೇಶ ನಿವೇಶನದ ದರ ಅಥವಾ ಆಯಾ ಕೃಷಿ ಜಮೀನಿನ ತರಹದ ದರ ಪ್ರತಿ ಎಕರೆ ದರಗಳನ್ನು ಪ್ರತಿ ಚದರ ಮೀಟರ್ಗೆ ಪರಿವರ್ತಿಸಿದಾಗ ಬರುವ ದರ ಯಾವುದು ಹೆಚ್ಚೋ ಅದನ್ನು ಅಳವಡಿಸತಕ್ಕದ್ದು. It can be adopted and it can be registered ಅಂತ ಇದೆ. Now in this case, the condition is that, my lord, the bits of lands cannot be registered anta, that has been rejected by the first appellate court. Now in view of this Gazette notification, this
ಇದು
appeal has
5 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ವರೆಗಿನ ಅಂತ ಇದೆಯಲ್ಲ?
also
ನಿಮ್ ಲ್ಯಾಂಡ್ ಎಷ್ಟಿದೆ?
2.25 ಗುಂಟೆ.
2.25 ಗುಂಟೆನಾ?
This has been sold for the purpose of constructing farm shed and house, my lord. The same thing has been constructed and position has also delivered in
But
the year
this notification of the year 2023 ಅಲ್ವಾ?
23, my lord. Subsequent notification.
We are residing in the property, my lord, and there is an cow shed and as well as the farm silk rearing house, my lord. And also the sheep shed is also existing, my lord. And the electricity is also in our name, my lord, and all the position as was
Yes,
delivered
counsel, ನಿಮ್ಮ
as
argument
on the
ಹೇಳಿ.
date of.
Absolutely, there was no cause of action for the plaintiff appellant to file the suit. This was exactly the observation made in the judgment passed by the first appellate court. Your lordship may kindly turn to para number 81 of the first appellate court's judgment, Mela. That is at the page number 218, para number 81. Page number 218 in the paper book, para number 81. The statutory bar which has been incorporated in the agreement, if looked into, it is found that there is a prohibition on the owners of the agreement not to sell the property in bits, and that is the reason why the authorities concerned have also not visited the document. The plaintiff, having called upon the defendant to perform their part of the contract, ought to have proved that such statutory bar has been withdrawn. Only then the plaintiff would have been entitled to call upon the defendants to perform their part of the contract. Unless and otherwise, the plaintiff proved that there was notification, order, or permission by the competent authorities, wherein the authorities have permitted for registration of the said deed, and in the absence of any condition as such in the document exhibit P1, that the defendants themselves should have got the permission from the competent authorities to enable the plaintiffs to get the said deed registered. Definitely, the agreement, that is the social document, remains unenforceable. My lord. So, the very contention of the court below is that there was absolutely no cause of action, and your lordship may kindly turn at the plaint averment, my lord. The plaint averment.
The word cause of action has been not at all used.
ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ ಆಮೇಲೆ ಹೇಳಿರಂತ ರಿಪ್ಲೈ ನೀವು.
Page number
page.
Paper book page number finally, last and few lines, last two lines. The plaintiff and last line, the plaintiff and defendants went to the sub-registrar, Kolar, for inquiry for registration of the regular said for the successor property, but the sub-registrar Kolar informed to the plaintiff and to the defendants that registration of small bits of agricultural land, like house sites in an agricultural land, is not permissible, and refused to register the same till the said land is converted from agriculture to agriculture use. The witness to the said agreement of sale advised both the plaintiffs and the defendants to enter into an agreement of sale and to deliver possession of the suitable property through the agreement of sale to the plaintiff. This is the contention taken by the plaintiff in their suit. If that is so, the burden of proving that the embargo on the registration of the smaller bits of land lies on the plaintiff. So that only gives rise for the plaintiff to file the suit. Unless and until such a document is produced to show that such an such an embargo was lifted, the plaintiff cannot have any cause of action for filing the suit. This is exactly the contention taken by the first appellate court, my lord. Since there was no cause of action for filing the suit, the first appellate court has very rightly dismissed the suit of the plaintiff. So now, before this honorable court and the last of hearing has produced the notification, which is of the year 2023, to show that by this notification, the cause of action arose for him to file the suit in the year 2008. So therefore, my lord, the plaintiff has no cause of action. That is one point. Another point to be noted here is that, my lord, the boundaries of the property, suitable property, the property with the boundaries as mentioned in the suit did not belong to the defendant as on the date of the agreement. The date of the agreement is, my lord,
belongs to whom then?
Some other person by name Sonnappa. The agreement of sale is dated 28th August 2005. That is exhibit P1. And the defendant purchased the property containing the boundaries as mentioned in the suit schedule in the year 2006. That is nearly 1.5 year after the sale agreement. So the plaintiff cannot contain, I cannot agree to sell a property which does not belong to me.
But later on you have purchased the property.
Later on we purchased the property.
ಯಾವಾಗ?
In the year 2006, Mila, 1/12/2006. 1/12/2006, we purchased the property as per exhibit D1. To identify the property, my lord, as in the client schedule, the boundaries of the property is, the lordship may kindly turn to page number 58, my lord, 58. The boundaries of the suitable property.
Yes.
ಪೂರ್ವಕ್ಕೆ ಚೇರ್ಮನ್ ನಾರಾಯಣಪ್ಪನವರ ಸತ್ತು, ಪಶ್ಚಿಮಕ್ಕೆ ನಮ್ಮದೇ ಉಳಿದ ಸೊತ್ತು ಅಂತ ದ ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ ಟು ದ ಡಿಫೆಂಡೆಂಟ್ಸ್. ಉತ್ತರಕ್ಕೆ ನಮ್ಮದೇ ಉಳಿಕೆ ಸೊತ್ತು, ದಕ್ಷಿಣಕ್ಕೆ ನಮ್ಮದೇ ಉಳಿದ ಸೊತ್ತು. ಸೊ ಆಸ್ ಪರ್ ದಿಸ್ ಬೌಂಡ್ರೀಸ್ ಮೇಲೆ ದ ಈಸ್ಟರ್ನ್ ಬೌಂಡ್ರಿ ಈಸ್ ದ ಲ್ಯಾಂಡ್ ಬಿಲಾಂಗ್ಸ್ ಟು ಒನ್ ಚೇರ್ಮನ್ ನಾರಾಯಣಪ್ಪ. ಆಸ್ ಪರ್ ಮೈ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್.
ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ನಿಮ್ದು ಇನ್ನು?
ಇನ್ನೊಂದು 10-15 minutes.
ಆಯ್ತು, ಕಂಟಿನ್ಯೂ. 2:30.
My lords, may I seek a adjournment? May I seek a adjournment?
Adjournment ಯಾವ್ದು ಹೇಳಿ?
50, my lords. Serial number, item number 50, my lords.
15.
my lords.
ಅದು ಆರ್ಡರ್ಸ್ ಇರೋದು, ಈಗ ಏನ್ ಮೆನ್ಷನಿಂಗ್ ಮಾಡಂಗಿಲ್ಲ. ಹೇಳಿ, ಬೇರೆ ಏನಾರು ಇದೆಯಾ? 15 ಅಂದ್ರೆ ಯಾವ್ದ್ರ?
50, my lords.
50
Please, my lords.
50. ಹೇಳಿ ಏನಾದ್ರು?
Senior is out of station. Senior is in out of station.
ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್.
Please, my lords.
50 ಯಾವ್ದು?
50, Basavaraja.
50 HK ಬಸವರಾಜು.
Please, my lords.
ಅದರ್ ಸೈಡ್ ಯಾರು? ಗೋರಪ್ಪ. ತಗೊಳ್ಳಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks time and counsel for the respondent also present. ಯಾವಾಗ ಇರ್ತಾರೆ ನಿಮ್ ಸೀನಿಯರ್?
Next week, my lords.
Is this matter on 29/10?
Please, my lords.
48 ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
ಸೀನಿಯರ್ ಇಲ್ಲಿ ಹೇಳ್ತಿದೆ
ಹಿರೇಮಠದ್ದು. ಅಂದ್ರೆ ಚೂಡು ಇಬ್ರು ಇದ್ದೀರಾ? ಇಬ್ರು ಇದ್ರು ಮಾತ್ರ ಡೇಟ್ ಕೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 55.
57 ಇಬ್ರು ಇದ್ದೀರಾ? ಹೇಳಿ ಏನಾಗ್ಬೇಕು? RFA 2006 no adjournment. ಇಬ್ರು ಇದ್ದೀರಾ ಅಂತ ಕೇಳಿದೆ, ಅದಕ್ಕೆ. ಇಬ್ರು ಇದ್ದೀರಾ?
Both the sides are present. The parties have made a proposal for settlement.
ಏನಿದೆಯೇನ್ರಿ ಸೆಟ್ಲ್ಮೆಂಟ್?
ನಮ್ ಕ್ಲೈಂಟ್ ಇಂದ ಇನ್ನೊಬ್ರು ಇದಾರೆ, ಅವರಿಂದ ಮಾಡಿಸ್ತಾರೆ ಸೆಟಲ್ಮೆಂಟ್. ಇದು
ಈಗ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗುತ್ತಾ ಇಲ್ವಾ ಅಷ್ಟು ಹೇಳಿ?
ಚಾನ್ಸಸ್ ಇದೆ.
ನೀವ್ಯಾರಿಗೆ?
We are trying our level best.
ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗೋದು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಒಬ್ಬರೇ ಅಲ್ಲ, ಬಹಳಷ್ಟು ಜನ ಇದ್ದಾರೆ ಇಲ್ಲಿ.
1, 4 to 8
ಎಲ್ಲ ಸರ್ವ್ಡ್ ಎಲ್ಲ ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಇದಾರಲ್ರಿ, ಹೆಂಗ್ರಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗುತ್ತೆ ಇದು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್.
ಅವರೆಲ್ಲ ಇಬ್ಬರಲ್ಲಿ ಮಾತ್ರ ಸೆಟಲ್ಮೆಂಟ್ ಮಾತಾಡ್ತಾರೆ.
ಅದೇ
ಬೇರೆಯವರು ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ ಇವನ್ನ ಮಾತಾಡ್ತಾ ಇರೋದಕ್ಕೆ.
ಅಲ್ಲ, ಹೇಗೆ ಅವ್ರನ್ನ ಬಿಟ್ಟು ಹಿಂಗ್ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳಕ್ ಆಗುತ್ತಾ ಅಂದೆ?
ಅವ್ರು ಇದಕ್ಕೆ ಈ ಪ್ರಾಪರ್ಟಿ ಇವ್ರು ಕೇಳ್ತಾ ಇರೋ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
ನೀವ್ ಯಾರಿಗೆ? R9?
4 to 9.
4 to 9 ಇಲ್ಲಿ ಯಾರ ಬರೀ HS ಸುರೇಶಪ್ಪ ಗೌಡ ಫಾರ್ R9 ಅಂತ ಇದೆ.
4 ABC.
ನೀವು ಮಾತ್ರ ಕಂಟೆಸ್ಟಿಂಗ್? ನೀವು ಮಾತ್ರ ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್? ಒಂದ್ ವಾರ ಕೊಡ್ತೀನಿ. 2006 ಏನಾದ್ರು ಸೆಟ್ಲ್ಮೆಂಟ್ ಇದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ 20 ವರ್ಷ ಆಗಿದೆ ನಮ್ ಕೋರ್ಟಲ್ಲೇನೆ. 18 ವರ್ಷ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್. ಆಯ್ತಾ? ಅದು ಫಸ್ಟ್ ಅಪೀಲ್. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks time on the ground of settlement and counsel for the respondent. 4 to 9 4 to 9
149.
is present and submits that there is an element of settlement and hence list this matter on 25/10. If no settlement, make the submissions on main appeal.
Serial number 55, my lords.
55.
From the other side.
ಹೇಳಪ್ಪ.
Appellant. Can it may be out next Thursday, my lord? Nandish Patil is in Dharwad today. Can it may be out next Thursday, my lord? He'll be physically.
ನೀವ್ ಯಾರಿಗೆ ಹೇಳಿ?
For appellant.
Other side are
I have informed SV Prakash, my lord.
ಹೇಳಿದಿರಾ?
ಹೇಳಿದ್ದೀನಿ.
Apparent counsel seeks time and counsel also submits that he has already informed
ನಾನು
counsel for R4. ಹೌದಾ? ಅವ್ರೊಬ್ರೇ ತಾನೆ contesting.
please.
AGA ಇದಾರಲ್ಲ. AGA 1 to 3 is also present. List this matter on 24/10.
Serial number
47.
47 ಹೇಳಿ ಏನಾಗಬೇಕು?
ಮೊನ್ನೆ ದಿನ ನಾನು I took time to have the matter today. Went through some actual aspect clarification is required.
Other side ಇದಾರಾ?
I
Other-
will inform you. It is already.
ವಿಪಿನ್ ಹೆಗ್ಡೆ ನೀವಾ? ಆಯ್ತು. Apparent counsel seeks time and counsel for R1 is also present. Release this matter on ಯಾವತ್ತು?
ಸೋಮವಾರಕ್ಕೆ.
ಸೋಮವಾರ ಇಲ್ಲ, ಸೋಮವಾರ ನೋ ಸಿಟ್ಟಿಂಗ್. ಬೇರೆ ದಿವಸ ಯಾವ್ದಾರು ಹೇಳಿ.
Wednesday, next any day.
23/10.
Serial number
Lordship
81.
kindly.
Serial number
81.
81.
Yes, ma'am. Appear for
230 matters
Yes, madam.
230 matters ಎಲ್ಲ ಈಗ ಯಾವ್ದು ಕೊಡೋದಿಲ್ಲ ಡೇಟ್. ಬೇರೆ ಏನೋ matters ಇದೆಯಾ?
49, serial number 49, my lord.
49 ಹೇಳಿ ಏನಾಗಬೇಕು?
I pray for time, my lord. On 7th,
ಸಾಂಗ್ವಿ ಹೇಳಿ.
on 7th November, it may kindly be listed, my lord.
ಅಭಿನಯ್ ವೈಟಿ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ?
Abhinay is not appearing. He has intimated
ಇದಾರಲ್ಲ ಅವರೇ
that.
ಇರೋದು, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಅವರೇ ಇರೋದು.
Correct, sir. But
ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ ಇಲ್ಲ?
ಹೇಳಿದ್ದೀನಿ sir. He was submitting that he is not appearing in this case.
ಬಟ್ ಅವ್ರು
Because
ಅಪಿಯರ್
he-
ಆಗೋದಿಲ್ಲ ಅಂತ ಬಂದ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು.
Your lordship may have it on 7th November, my lord.
No counsel
other-
unless the consent from other side, no adjournment.
Please.
ಅಷ್ಟೇ ಅಲ್ಲ? ಕಲ್ಬುರ್ಗಿ ಒಂದು ಇದೆಯಾ ಮಧ್ಯಾಹ್ನ?
ಪಾಸ್ವರ್ಡ್ ಎಷ್ಟಿದೆ ಮೇಡಮ್? ಇದು ಆಯ್ತು. 230 ಗುಲ್ಬರ್ಗ ಮಾಡ್ತಿದ್ದೀರಾ? 85 ಬೇರೆ ಲಿಸ್ಟ್ ಬೇರೆ ಇದೆ. ಅದೇನಿಲ್ಲ ಸರ್, ಅದು ಇನ್ನೊಂದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋ ತರ ಇರುತ್ತೆ. ನೋಟ್ ಅಂದ್ರೆ ಇವಾಗ 1 ಏನಿದೆ ಹೇಳಿ ನಿಮ್ದು? ಬೇರೆ ಅಕ್ಯೂಸ್ ಇರ್ತಾರಲ್ವಾ ಅವರು, ಅದೇ ಯಾರು ಬೇರೆ ಮಹಾಲಿಂಗಪ್ಪ ಹಾಕಿದ್ರು ಅದೇನೆ ನೋಟ್ ಅಂದ್ರೆ ಅದೇನೆ ಹೇಳಿದ್ ನಾನು. ಬೇರೆ ಅವ್ರು ಅಕ್ಯೂಸ್ ಇದ್ದಾರೆ ಯಾರು ಇಲ್ಲ, ಅವ್ರೊಬ್ರೆ ಅಂತ ಬೇರೆ ಆ 5 ಜನದಲ್ಲಿ ಬೇರೆಯವರೆಲ್ಲಾನು ನಮ್ಮ ಮುಂದೆ ಬಂದಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರನೇ ಇದು ನಮ್ಮ ಮುಂದೆ ಬಂದಿರೋದು ಅಂತ ಅದಕ್ಕೆ ಹಾಕಿರೋದಷ್ಟೇ. 230 ಇದೆ ಇನ್ನಲ್ಲಿದೆ 230 ಎಲ್ಲ ಇಟ್ಬಿಡಪ್ಪ, ಆಮೇಲೆ 59 ಹಾ ಇಡಕ್ಕಾಗಲ್ಲ. ಫಾಸ್ಟ್ 4 ಇದೆ, 4 5 ಇದೆ ಅಷ್ಟೇ. 27 ಅದು ಅಯ್ಯ ಅಲೋ ಆಯ್ತು ಸರ್. ಈಗೆಲ್ಲ ಸ್ವಲ್ಪ R9 ಆಮೇಲೆ ಆ ವಕಾಲತ್ ಮೇಲೆ ಕಂಪ್ಲೈ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ. 28 ಒಂದಿದೆ ಮೇಡಮ್, ಒಂದ್ ಗುಲ್ಬರ್ಗ ಇದೆ, ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಅದಾದ್ಮೇಲೆ ಪಾಸ್ ಓವರ್ ತಗೊಂಡು ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ, ಫೈನಲ್ ಇಯರ್ ಹೋಗುತ್ತೆ. ಈಗ ಒಂದ್ ನಡೀತಾ ಇತ್ತಲ್ಲ RS, ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಮೇಡಮ್. ಹೇಳಿ. ಇಲ್ಲ ಹೋಗಿಲ್ಲ ಸರ್, ಇದೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಡ್ತೀರಾ? ಹಾ ಡೇಟ್ ಅದರ ಇದ್ರೆ ಬೇಡವಾ? ಹಂಗೆ ಹೇಳೋದು ಬೇಡ ಅಂತ ಅಲ್ಲ, ಒಂದ್ಸತಿ ಬಂದ್ಮೇಲೆ 2 weeks ಕೊಡ್ತಾರೆ. 2 weeks ನಂತರ. ಅಷ್ಟೇ ಸರ್, ನೋಟ್ ಅಂದ್ರೆ ಅದೇನೆ. ಅಲ್ವಾ, ನಮ್ಗೇನೆ ಗೊತ್ತು, ಕೇಳಿದ ತಕ್ಷಣ ಏನೋ ಏನೋ ಇರುತ್ತೆ. ಇವಾಗ ನಾನು ಏನ್ ಹೇಳ್ಬೇಕು
ಇದೇ ಮತ್ತು ಅವರು ಒಂದು ಫೋನ್ ಹೇಳ್ತಾರೆ, ಇನ್ನೇನು ಫೋನ್ ಅಂತ
ಜೊತೆಲಿ ಇದ್ದಾಗ ಎಲ್ಲ ಬಣ್ಣ ನೋಡಿ ಯಾವನು ನಿಂತ್ಕೊಳ್ಳಲ್ಲ. ಹೋಗ್ಲಿ ಮಾಡಕ್ಕೆ ನನ್ ಜೊತೆ ಮಾತಾಡುವ ಏನ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳು ಅಂತ ಅವನಿಗೆ ಹೇಳ್ತಾರೆ. ಅವನೇ ಸಾವಿರ ಕಟ್ಟಿಸ್ಕೊಂಡು ಕೆಲ್ಸಕ್ಕೆ ಹೋಗಿ ಏನಾದ್ರು ಒಂದು ಸ್ಥಾನಕ್ಕೆ ಕೂತ್ಕೊಂಡು ಅನ್ಸುತ್ತೆ ನಿಮಗೆ ಕೆಲ್ಸಕ್ಕೆ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಯಾವುದೋ ಕಂಪ್ನಿಗೆ ಹೋಗ್ತಿದ್ದೀನಿ ನಾನು ಅದೇ ಅಂದೆ ನೀನ್ ಪರ್ಸನಲ್ಲೇ ಆಗ್ಲಿ ಕಣೆ ನಿಮ್ ಪರ್ಸನ್ ಆಯ್ತಲ್ಲ ಏನ್ ಹೇಳ್ತಾರೆ ಇವ್ರಿಗೆ ನಾವು ಹೇಳಿದ ತಕ್ಷಣ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತೀಯಾ ಕೇಳಿದ ತಕ್ಷಣ ಎಕ್ಸಿಕ್ಯೂಟ್ ಅದು ಹಿಂಗೆ ಅನ್ಕೊಂಡೆ ನಾನು ಇವಾಗ ಎದ್ದೋಗುವಾಗ ಏನಾದ್ರು ನೆನಪಾಗುತ್ತೆ ನಮ್ಗೆ ನಿಮ್ ಮುಖ ನೋಡಿ ಕೇಳಿದ್ರೆ ಏನು ಇಲ್ಲ ಅಂತ ಕೇಳ್ತಾರೆ. ನಾನ್ ಸ್ವಲ್ಪ ಅಕಸ್ಮಾತ್ ಇವತ್ತು ಕೇಳಿದ್ರು ನಾಳೆ ಕೇಳ್ತಾರೆ ಯಾಕ್ರಿ ಹೇಳಿ ಹೇಳೇ ಇಲ್ಲ ಇವಾಗ ಹೇಳ್ತೀನಿ ಸಾಯಂಕಾಲ ಮದುವೆ ಮಾಡ್ಕೊಂಡು ಇವ್ರದ್ದು ಬೆಳಿಗ್ಗೆ ಅವ್ರವ್ರು ಎಷ್ಟು ಫೇಕ್ ಇದ್ರು ನೋಡ್ಕೋಬೇಕು. ಎಲ್ರಿಗೂ ಫೇಕ್ ಇರೋದು ಇವಾಗ ಯಾರೇನು ತುಂಬಾ ಪರ್ಫೆಕ್ಟ್ ಇನ್ನೊಬ್ರ ಬಗ್ಗೆ ಮಾತಾಡೋದು ಅಂತ ಅಂತದ್ದೇನು ಯಾರು ಮೇಡಮ್ ಸ್ಟಾಫ್ ನೀವು ಯಾವ ಪೋರ್ಟಲ್ಗೆ ಬಂದಿದ್ದೀರಾ? ಯಾರು ಸಾಯ್ತು ಯಾರ ಹತ್ರ ಇಲ್ಲಿ ಯಾರು ದಿವ್ಯಾ ಅಂತ ಬಂದಿದ್ದಾರೆ ದಿವ್ಯಾ ಯಾರು ದಿವ್ಯಶ್ರೀ ಅಂತ ಇಲ್ಲ. ನೀವು ಬೇರೆ ನೋಡಿ ಯಾವ ಸಾಹೇಬ್ರು ಅಂತ ನೋಡಿ. ಪೋರ್ಟಲ್ ಹಳೇದೇ ಇರುತ್ತೆ, ನೀವು ಆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿರ್ಬೇಕು. ಈಗ ಚೇಂಜ್ ಆಗತ್ತೆ ಪೋರ್ಟಲ್ಸ್, ಈಗ 1 week ಇಂದ ಚೇಂಜ್ ಆಗಿದೆ. ಅದಕ್ಕೆ ಸಾಹೇಬ್ರು ಯಾರು ಅಂತ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ಚಂದ್ರಶೇಖರ್ BK ಚಂದ್ರಶೇಖರ್ ಅವರು ಅಪಿಯರ್ ಆಗಿರೋದು. ರೆಸ್ಪಾಂಡೆಂಟ್ 242G ಸುರೇಶಪ್ಪ ಗೌಡ 1 is already dead. 2 4A to G 5A to C. ಅವರ BK ಸುರೇಶ್ ಬಂದಿದ್ದು ನೋಡ್ತಾರೆ ಅಷ್ಟೇ. ಇಲ್ಲಲ್ಲ ಮೇಡಮ್, ದೇವದಾಸ್ ಪೋರ್ಟಲ್ ಬೇರೆ. ಅದೇ ಅವರು ಲಾ ಕ್ಲರ್ಕ್ನ ಕೇಳ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ ಮೇಡಮ್. ಅದಕ್ಕೆ ಅವ್ರು ಯಾರು ಜಸ್ಟಿಸ್ ಇರ್ತಾರೋ ಅವ್ರನ್ನ ಕೇಳಿದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗತ್ತೆ ಅಂತಂದೆ. Very good. They have not attended them. ಆರ್ಸಿ ಅಥವಾ CPC ಇಬ್ರು ಯಾರಿಗಾರು ಕಳ್ಸಿ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು ನನಗೆ. ಆರ್ಸಿಗ್ ಬೇಡವಂತ ಸರಿ ಬಡದಾಕ್ಬಿಟ್ಟು ಹಾಕಮ್ಮ. ಆಯ್ತು ಬಡದಾಕ್ಬಿಟ್ಟು ಅವರೇ ಹೇಳಿದಕ್ಕೆ ನಾನು ಹಾಕಿದ್ದೀನಿ.
Kalburgi.
Kulburgi bench.
Matter pertains to Kalburgi bench. Serial number 1, Mahantesh Patil.
My lord,
Hmm.
short time accommodation, my lord, senior will be out of station.
First time ಆಗಿದೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮಾಂತೇಶ್ ಪಾಟೀಲ್. ನಟರಾಜನ್. Yes, counsel, why you are seeking time repeatedly?
My lord, it's the last time, my lord. Senior will be out of station, my lord, this time.
Not last time. Almost 10 adjournments. Lord, the petitioner of counsel seeks time again. List this matter on. Next after 411 ಬರ್ತಾ ಯಾವಾಗ ನೋಡಿ. Wednesday. 6th ಆಯ್ತು 611.
Thank
2:30.
List 1, matters at 2:30. Complaints for first time, 62.
Swaraj TA.
Petitioner, my lord. Sir, I will complain, office objection, my lord, 1 week time may be granted.
Counsel
In the
seeks 1
meanwhile,
week.
notice may be
Counsel
issued.
seeks 1 week time to
Central
comply with
government.
office objections and hence 1 week time granted.
Unni Krishnan M name may be mentioned, my lord. I will solve the copy in the meanwhile. Unni Krishnan M.
ಮಾಡ್ಕೊ ಬನ್ನಿ ಆಮೇಲೆ ನೋಡೋಣ.
Sir,
ಕಂಪ್ಲೈ ಮಾಡಿ. This matter next Wednesday working ಕೊಡಿ.
started.
2310.
2310.
63.
63.
Balakrishna
Balakrishna MR.
So petitioner is seeking bail, seeking benefit under section 479 of the BNSS 2023 pursuant to the Apex Court judgment, my lord. Hence, this petition has been filed under section 439, read with section 479 of the BNSS.
What is the office objection, counsel?
Advocate submission.
Provision only na?
Asked.
Bail provision na? ಅದೊಂದೇನಾ? told. The office objection is overruled. List this the HCGP is directed
Alla,
to take notice.
M. Unni Krishnan is a CGSC. He may be directed to take notice, my lord.
Counsel Sri
M. Unni Krishnan.
M. Unni Krishnan is directed to take notice for respondent.
Respondent. Only one respondent.
Sole respondent.
Yes, yes, ma'am.
List this matter on 2310.
Central government standing counsel. Previous occasion he had
Central-
appeared in this matter, my lord.
Central government standing counsel ಅಂತ
Yes.
ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. Next.
Date may be fixed, my lord.
Date 23rd.
Yes, much of that.
64.
Rakshit R.
Rakshit R.
ಇಲ್ವಾ?
ಇಲ್ಲ.
Petitioner counsel is absent. 1 week time granted to comply with office objection and post the matter after compliance.
Second time non-compliant,
M.
65.
Krishnegowda.
M. Krishnegowda.
Matter is listed for second time for compliance and counsel is absent. List this matter after compliance.
66.
Nagraj H. G. Manjunatha, same order.
First time order, 67.
First time,
Sir, first time.
HCGP is directed, additional SPP is directed to take notice and list this matter on 2310.
68. Latif B.
Prateep B, same order, first time, 2310.
69.
Ganesh, same order,
70.
70.
69.
69, 1 week time.
Petitioner is the one, he's cardiac patient, he has to issue.
ಸರಿ ರೀ, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದೀನಿ, ಲೆಟ್
Yes.
ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ.
70.
70. 70 also same order.
Orders matter 71.
71. Office objection along with counsel submission in.
My lord, the order sheet, they sought for order sheet up to date. Up to date, no progress because there was a stay before the first appellate.
ಯಾವ್ದು ರಿಲೆವೆಂಟ್ ನೀವು ರಿಲೈ ಮಾಡೋದು ಯಾವ್ದು ಅದಿದೆಯಾ?
Order is it?
ನೀವು ರಿಲೈ ಮಾಡೋದು ಯಾವ್ದು? ಅದು ಲೆಜಿಬಲ್ ಇದೆಯಾ?
Legible ಇದೆ.
ಯಾವ್ದು ಅದು ಹೇಳಿ?
Ink page number 31.
31.
Discharge application.
Sorry, counsel submits that the discharge order has been challenged before this court, hoda, and the same is legible, and hence office objection is overruled. First time, HCGP is directed to take notice, HCGP in additional SPP is directed to take notice and list this matter on 2310.
Please, please.
Anand Muttalli.
70.
First time,
No, my lord, these office objections are all.
HCGP ಆಗಿದೆ.
notice order ಆಗಿದೆಯಾ? ಆಯ್ತು ಹೇಳಿ.
My lord, there's a private complaint which was filed,
Hmm.
purely a civil transaction.
Hmm.
The police have filed a FIR first.
Hmm.
Thereafter, after the investigation, my lord, B report was submitted.
B report was submitted.
Yes, my lord. That B report was challenged.
Hmm.
And the magistrate passed an order, we are rejecting the B report, taking the cognizance against all the accused.
Hmm.
Against, thereafter, my lord, first and second accused,
Hmm.
approached the sessions court, and sessions court has allowed the petition and passed the complaints with regard to first and the second accused. That was challenged before this honorable court. This honorable court also confirmed that order.
Hmm.
My lord, what happened is, there is a contract between the complainant and the company.
Hmm.
In the year 2010.
Now the present petitioner is accused number
3, my lord.
3.
Yes, my lord.
1 and 2 already.
Share at page 109.
Hmm.
So, my lord, in 2010, the contract was entered.
Hmm.
We were supposed to supply some garments.
Hmm.
But unfortunately, in 2012, this company got liquidated by the order of this honorable court.
Hmm.
When the company got liquidated, my lord, all the assets and affairs of the company was handed over to official liquidator.
Hmm.
That liquidation order is also furnished at page 59, my lord. Due to company itself is not in existence,
Hmm.
there is no question of supplying further, garments to the complainant.
Hmm.
So, complainant went and filed a complaint.
Hmm.
That complaint was not accepted, the PCR was filed, my lord.
Hmm.
Police have, after conducting the thorough investigation, filed a proper B report. No intention to cheat from the beginning, because from 2010 till the company got closed,
Hmm.
the materials were supplied
Hmm.
as per the contract, my lord.
Hmm.
Since company itself became, liquidated,
Hmm.
so there was no question for the office bearers of the company to take that contract forward, my lord.
Hmm.
This is the gist of the transactions, my lord.
Hmm.
And the accused number 3 was one of the director of the company.
Hmm. He was the director.
Director, my lord.
Hmm.
And company is not made a party, my lord. First ground is, my lord, the company is not made a party.
Hmm.
The second ground is Priyanka Srivastava compliance is not done.
Hmm.
And also, my lord, the Hriday Ranjan Verma is very clearly attracted because there was no intention to cheat the company, the complainant from the beginning.
Hmm.
So, but however, from last 12, 13, 14 years, this complaint is going on, my lord.
Hmm. Yes, who appears for R2?
Nobody is appearing from quite some time.
Veeranna for R2. ಯಾರು ಇದಾರಲ್ರಿ ಕೌನ್ಸಿಲ್ ವೀರಣ್ಣ? ಅದೇ ಏನೋ ಇದಾರಲ್ಲ ರಟ್ಟಿಹಳ್ಳಿ ಗೀತಾ ವೀರಣ್ಣ ಇಲ್ವಾ? ನಿಮ್ದೇನ್ ಸ್ಟೇಟ್ ಏನಿಲ್ವಾ ಮೇಡಮ್? Sorry. Additional SPP seeks time and counsel for R2 is also absent and one more opportunity is given to the R2 counsel. If R2 counsel doesn't appear in the next state of hearing, matter will be heard in the absence of R2. And is this matter on 2310? 2310.
Much.
23.
ಶ್ರೀವಾಸ್ತವ. ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ರೀಚ್ ಆಗೋ ಡೌಟ್. ಆಯ್ತು, ಪಾಸ್ ಓವರ್. ನೆಕ್ಸ್ಟ್ ಮೋಹನ್ ಕುಮಾರ್ ಡಿ.
74.
Petitioner, let's see, in this case, my lords, it's covered by accused number 5, 6 and 11 quash ಆಗಿದೆ sir. 5, 6 and 7 ಗೆ quash ಆಗಿದೆ. By the coordinate bench, my lord. But this is the offense punishable under.
Reason in quashing ಗೆ.
My lords, materials ಏನು ಇಲ್ಲ ಅಂತ ಇವ್ರ ಮೇಲೆ sir. Yeah, they are agents and employees, my lords. In this case. So I am also an agent.
In this matter, trial has already begun. Trial start ಆಗಿದೆ.
Already trial commence ಆಗಿದೆ.
Trial commence ಆಗಿದೆ sir.
1 to 8 have been examined.
PW 1 to 8 have been examined.
Witness summons CW 28 and 36 ಗೆ issue ಮಾಡೋರಿದ್ದಾರೆ. Trial has begun, your lordships. And this petitioner is also he is also, his 2 crimes have been registered against this present petitioner also. In 2 different police stations.
ಈಗ ಒಂದು FIR, ಒಂದ್ ಚಾರ್ಜ್ ಶೀಟ್ ಮೇಲೆ ಇದು ಇವತ್ತು ಬಂದಿದೆ ಸ್ವಾಮಿ, ಇನ್ನ 2 ಇದೆ.
ಎರಡಿರ್ಲಿ, ಬಟ್ ಈ ಕೇಸಲ್ಲಿ ಆಲ್ರೆಡಿ ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಆಗಿದೆ ಅಂತ
ಟ್ರಯಲ್ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಆಲ್ರೆಡಿ ಇದು co-accused ಸೇಮ್ ಫೂಟಿಂಗ್ ಸ್ವಾಮಿ, ನಾವು ಮತ್ತೆ ನಮ್ದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, 2 and 3 ಗೆ ಅವರು ರೋಲ್ ಇರೋದು.
ನೀವು ಅಕ್ಯೂಸ್ ನಂಬರ್ ಎಷ್ಟ್ರಿ?
ಅಕ್ಯೂಸ್ ನಂಬರ್ 8 ಸ್ವಾಮಿ.
8. ಹಾ,
ನಮ್ಮ ಮೇಲೆ ಯಾವ ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಸರ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ, ಹೇಳಿ ತೋರಿಸಿ. ಫೋಟೋ ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಮ್ ನಂಬರ್ 17.
ಪೇಜ್ ನಂಬರ್ 25.
ಬೇರೆಯವ್ರಿಗೆ ಕ್ವಾಶ್ ಆಗಿದೆ ಅಂತ ಹಾಗೆ ಬಂದ್ರ, ಓದ್ಕೊಂಡ್ ಬಂದ್ರ?
ಇದ್ರಲ್ಲಿ ಅಲ್ಲ,
ನೋಡ್ಕೊ ಬನ್ನಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನ್ ಅಲಿಗೇಷನ್
ಆಗಿದೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಮ್ದ್ರಲ್ಲಿ ಮಿಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಆಯ್ತು, ನೋಡ್ಕೊ ಬನ್ನಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್
ಸ್ವಾಮಿ R2 ಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ನೋಟಿಸ್
R2 ಯಾರಿದ್ದಾರೆ? ಫಸ್ಟ್ ಟೈಮ್
ಕಂಪ್ಲೇನೆಂಟ್ಸ್.
ಫಸ್ಟ್ ಟೈಮ್ ಇದು?
ಫಸ್ಟ್ ಟೈಮ್.
ಫಸ್ಟ್ ಟೈಮ್ ಹಾಗಾದ್ರೆ ಅಡಿಷನಲ್ SPP is directed to take notice and issue notice against R2 na? R2. List this notice ಹೋಗ್ಬರ್ಬೇಕು ಅಂದ್ರೆ 2 ವಾರ. 30th 30/10.
Meanwhile, IA number 1 maybe.
ಏನ್ IA number 1? ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ, ಈಗೇನ IA number 1 ಹೋಗ್ ಬರ್ಲಿ, ನೋಟಿಸ್ ಹೋಗ್ ಬರ್ಲಿ ನೋಡ್.
75.
ಕರುಣಾಕರ. Petitioner counsel press time. List this matter ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
Next week.
23/10.
After 20.
23/10 or 30/10?
23.
23/10.
76.
Prasanna Kumar P. DB Patil.
76 to 79 may not all connected.
All are connected,
All are connected, not same petitioner. Not your lordships may not earlier order. Not at page number 58, not in the first matter. Petition 5918 of 24. When your lordship was pleased to not quash the proceedings on merits. But as against not the assistant commissioner of police. There no allegation is not that the petitioner and the assistant commissioner of police had demanded and accepted illegal gratification, not during COVID period, not from cigarette suppliers. Not this order on merits. But you not in this petition at page 58.
This petitioner is accused number?
Not he is accused number 2, my lord.
2.
The one your lordship was pleased to quash, my lord, was accused number 1.
A1 was quashed.
A1 was quashed. Not during pendency of the petition, my lord, at page 58. Your lordship was also pleased to grant an interim order, which was called in question not before the apex court, that SLP has been dismissed. Now my learned friend says, my lord, even this order, which is dated 8th September 2021, is also challenged before Supreme Court, but there is no interim order. This is not my first ground. But I am not on the same allegations. The respondent statement also conducted departmental inquiry proceedings, not as against the petitioner and Prabhu Shankar. But exoneration, my lord, order is at page 45. But all the witness,
In all the cases is accused number 2?
please, my lord. But as against both these, my lord, accused, departmental inquiry was conducted. All the witnesses were examined, and my lord, ultimately they have been, my lord, exonerated in the departmental inquiry proceedings. But I had brought to your lordship's kind notice, my lord, on the other day, the judgment of the apex court, my lord, in Ashu Surendranath Tiwari's case.
Paragraphs.
But after referring to, my lord, paragraph number 11 and 12, the earlier orders, but apex court, my lord, would conclude. But earlier judgment of Radhesham Kejriwal, not PS Rajya, not para 9, 10, 11 and 12, but have been applied. Ultimately, my lord, the apex court has agreed with the earlier orders and held, my lord. And this judgment, but has been consistently followed, my lord, by this honorable court. May I just, my lord, bring to your lordship kind notice. 2 recent orders, my lord, of this honorable court. May I just. But after following, my lord, Ashu Tiwari's case, not this honorable court, my lord, was pleased to hold. Not that the proceedings, my lord, would not be quashed.
What is the allegation against this petitioner?
Not allegation against the petitioner, not your lordship will find. Not the FIR may not at page number 20.
In first case.
In the first case, not complaint at page 22. It's not page 24. Not para 2. ಬಾಣಸ್ವಾಡಿ ಪೊಲೀಸ್ ಠಾಣೆ ಸಂಖ್ಯೆ ಸೋ 420 IPC ಕೇಸಿನ ಆರೋಪಿಯಾದ ಶುರಸ್ ಎಂಬುವನನ್ನು ಕೇಸಿನಿಂದ ಕೈಬಿಡಲು ಎಸಿಪಿ ಪ್ರಭುಶಂಕರ್ ಅವರ ಸಮ್ಮತಿ ಮೇರೆಗೆ ಮಧ್ಯವರ್ತಿಯಾದ ಸೋರವರಿಂದ ಅಜಯ್ ರವರು 15 ಲಕ್ಷ ಲಂಚದ ಹಣವನ್ನು ಸ್ವೀಕರಿಸಿ ಈ ಮೂಲಕ ತಮ್ಮ ಅಧಿಕಾರ ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡಿರುವುದು ಸೋನ್ಸ್ ಹೇಳಿಕೆಯಿಂದ ಹಾಗೂ ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಸ್ಕ್ರೀನ್ ಶಾಟ್ಗಳ ಪರಿಶೀಲನೆಯಿಂದ ಜೈನ್ ರವರ ಅಪರಾಧ ನಗರ ವರದಿಯನ್ನು
15 ಲಕ್ಷ ರಿಸೀವ್ ಮಾಡಿದಕ್ಕೆ ಏನಾದ್ರು ಮೆಟೀರಿಯಲ್ ಇದೆಯಾ?
There is absolutely no material, not that your lordship will find, your lordship's finding, not in the earlier order, not would starts not at page 93. From paragraph number 44 onwards, what your lordship not was pleased to not in detail deal with not each of the aspects not of demand, acceptance, recovery. And this may not the witness which they cite in the FIR has not been examined in the departmental inquiry proceedings.
Alla, whether regarding acceptance of this 15 lakhs,
Please, my lord.
no recovery.
No recovery. And my lord, the person who is said to have paid not is not the complainant. That also your lordship was pleased to note, not in your lordship's earlier order.
Whether the person who gave the money of rupees 15 lakh has been examined
Please, he has been examined, my lord, in the departmental inquiry proceedings.
by the IO during the course of investigation, not in the departmental inquiry.
In the departmental inquiry, I'm sorry to interrupt now. In the departmental inquiry, in one of them, the complainant has not been examined,
Complainant?
has not been examined.
Huh.
And he has given a one
Sir, the person who gave the money of rupees 15 lakh.
He is the complainant, my lord.
So I'm sorry,
He
he's
is the
not the
complainant.
complainant. He's not the complainant. But that is, that also has been observed by your lordship, not in the earlier order, not complaining.
Departmental inquiry nalli, who gave the money of rupees 15 lakh to this petitioner
Please, my lord.
is examined or not?
He's examined, but I'll place on record is not his evidence. Complaint is by Assistant Commissioner of Police, not by the person who is said to have paid the money.
The person who makes an allegation that
He has been examined.
he made the amount, paid the amount of rupees 15 lakh.
Not he has been examined.
This petitioner has been examined.
He has been examined, not your lordship. I'll not place on record, but his evidence will not.
Evidence kodi ನೋಡ್, we'll see.
Please, my lord.
ನಿಮ್ ಪ್ರಕಾರ ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ವಾ?
My lords, my sum and substance of my submission would be, my lords, that the degree of evidence that is being adduced there is on a different parameter. And I have the latest judgment of the Supreme Court, my lords, where a coordinate bench of this honorable court was pleased to quash criminal proceedings on the very ground. The honorable Supreme Court observed that the honorable court or the honorable high court should have gone into the fact that there are other evidences also, because entire gamut of electronic evidence, WhatsApp chats, they are all not part of the departmental inquiry at all. So it is, if we go by the merits, as my learned friend has cited in terms of Ashu Tiwari case, it is not an exoneration on merit would be my respectful submission.
I have already distinguished that judgment
Please, my lord.
in another case.
And latest, my lords, I only had to interrupt my,
I think that judgment also I have referred.
so Supreme Court, my lords, as late as 2024, my lords, may please permit me. I'll give a copy.
2024 only I have relied upon. In a
Yes,
case,
lords.
in a case of trap case.
Please, my lords, please. The honorable Supreme Court was pleased to observe that there
Same
is a specific
Sanju
case.
Rajan Nair.
Please.
Para
I
9.
also relied upon this judgment and passed an order. I think in the month of June or July.
My lords, para 9, we may also observe that it was pleaded case of the Lokayukta before the High Court that the continuance of the trial was not on the very same evidence as that way, as what weighed with the authorities in exonerating the employees in departmental proceedings. This fact also appears not to have been considered by the High Court in its correct perspective. And not to mention, my lords, earlier also, this Supreme Court observes that they couldn't have gone into fact-related endeavors like demand, acceptance, etc., because they are all a question of trial to be gone into in a separate
But
forum.
that's what I
Please, my
gave
lords.
the reasons in a case of trap case also. Some other accused sought for quashing of the proceedings. I
Please,
distinguished the judgment of the earlier judgment and also relied upon this judgment.
Please,
ಆಯ್ತು.
please.
It depends upon each facts of the case.
Please,
But
please.
the fact remains
Hmm.
that your lordship not have already considered the merits of the matter not in the earlier petition which has become final.
That it depends upon the allegations
Of course.
made against each of the accused.
Please,
ಇದ್ರಲ್ಲಿ ಏನು ಇವನ್ he had received the amount of rupees 15 lakh ಅಂತ.
lakhs and FIR.
ಹಾ.
Not there is no recovery.
My lords, there are WhatsApp chats in terms of evidence, because now at this stage, my lords, the investigation is concluded. We are now in the process of seeking final approval for sanction under section 19. There, my lords, I'll provide the entire charge sheet material in terms of a sealed envelope before this.
ಇನ್ನು charge sheet file ಆಗಿಲ್ಲ.
Charge sheet file ಆಗಿಲ್ಲ. That is why I am saying, my lords, it is very premature and a stage at this juncture to interfere. Not to mention, my lords, I only want to bring, because the main leg of the argument of the learned counsel for the petitioner seems to be the exoneration in the departmental inquiry. My lords, I want to bring to the notice of this honorable court a very interesting article written by one of the lawyers, invariably may not have much of value in terms of rule of stare decisis. Nevertheless, my lords, I only want to point out, after analyzing the three judgments of Kejriwal, of Tyagi and Ashu Tiwari, this article, my lords, may please have at page, on the third page, before he comes to the conclusion. Page number 4, my lords. Exoneration in disciplinary proceedings not dispositive. What are the reasons it should not be done? I'll just read out 4 small points. Strict rules of evidence do not apply to disciplinary proceedings. Thus, analysis of the evidentiary material by departmental officers during disciplinary proceedings cannot be considered as conclusive by the criminal courts, which are bound by Evidence Act. Next one, my lords. At the stage of framing charges against the accused, the trial court merely has to conduct a preliminary inquiry to assess whether the material relied on by the prosecution gives a strong suspicion that the accused has committed the offense. The court will not examine the relevance, admissibility, and weightage of the evidence and determine the guilt of the accused at this stage. Therefore, prosecution does not have to prove its case beyond reasonable doubt. Now, the final one, my lords, very important one. An independent assessment of the entire material may still lead the court to a conclusion different from what is reached in the disciplinary proceedings. Because this is what the Honorable Supreme Court said, my lords, that if there is some other material on which weight is being placed now, the resultant effect may be thoroughly different. However, my lords, I'll continue. For instance, section 20 of the Act creates a legal presumption of guilt in case if an official obtains an undue advantage. Thus, the preliminary examination of even circumstantial evidence can result in a legal presumption of guilt, which will have to be rebutted by the accused at the time of trial. This legal presumption does not apply to disciplinary proceedings. Not to mention, my lords, finally, if it is held that an official accused of corruption cannot be prosecuted if the disciplinary proceedings have been absolved, then prosecution of the acts of corruption could be launched only if the official is held guilty in the disciplinary proceedings, making the initiation of prosecution dependent on the conclusion of the disciplinary proceedings. This is not an interpretation of the framers of the statute. The Honorable Supreme Court, even in the Constitution bench, has said, my lords, that all provisions are to be construed in a manner to reach the objective of the statute, which is to curb corruption as such. So, my lords, my respectful submission is primarily, my lords, at this juncture, when the investigation is yet to be concluded, charge sheet is yet to be filed, it's our specific case, my lords, that there is material to show, rather entire electronic evidence is not being taken into consideration at all in the departmental proceedings. That may bring out a total different conclusion altogether. And we'll submit, my lords, for the perusal of this court, the entire charge sheet material available for the perusal of the court.
Yes. Yes. What is the allegation in second case?
No, your lordship may kindly have a look at
First case,
page 56 alla ide.
15 lakh.
But in page 56, your lordship will find of this petition itself. But as against my lord Prabhu Shankar, which your lordship was pleased to quash. Page 56, my lord. ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಸಲ್ಲಿಸಿರುವ ನೋಡಿ in the middle of the page ಬುಲೆಟ್ ಪಾಯಿಂಟ್ಸ್ ಇದೆ. ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಸಲ್ಲಿಸಿರುವ ವಿಚಾರಣೆ ವರದಿಯಲ್ಲಿ ಕೆಳಕಂಡ ಅಂಶಗಳನ್ನು ಗಮನಿಸಲಾಗುತ್ತದೆ. ಸೋ ಪ್ರಭುಶಂಕರ್ ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್ ನಾಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ ಕ್ವಾಶ್ಡ್ ACP ರವರು 62.5 ಲಕ್ಷ ರೂಗಳನ್ನು ಕೊಡಬೇಕೆಂದು ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದರೆಂಬುದು ಮತ್ತು 32.5 ಲಕ್ಷ ರೂಗಳನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ ಎಂಬುದು ದೃಢಪಟ್ಟಿರುವುದಿಲ್ಲ ಎಂಬುದು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ನಾಟ್ ವಿತ್ ರೆಫರೆನ್ಸ್ ಟು ಸೆಕೆಂಡ್ ಅಲಿಗೇಷನ್. ಅಮಾನತು ಪಡಿಸಿಕೊಂಡಿರುವ ಕ್ರಮವಾಗಿ 25 ಲಕ್ಷ.
This is in respect of A1 na?
A1.
What about A2? Even A2 ಅಲ್ವಾ?
Now I'm not, I'm A2.
A2 ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಏನಿದೆ?
ಇದರಲ್ಲಿ D ನ ಇದರಲ್ಲಿ ನೋಡಿ your lordship will find it.
ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ನಡವಳಿಕೆಗಳು ಇದಂದ್ರೆ ಇದೇನು ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ
Departmental enquiry proceedings.
ಹಾ.
Page annexure F, page 45.
ಹ್ಮ್.
Not as the report of the departmental enquiry.
ಹ್ಮ್. ಅಲ್ಲ, what is the allegation against him?
Please,
He had accepted the amount of rupees 15 lakh ಅಂತ.
But allegation
ಈ
is.
ಕೇಸಲ್ಲಿ
ಹೌದು.
ಹೌದಾ?
ಹೌದು.
ಹಾ. What is the incriminating material collected by the prosecution?
Not the prosecution, not says in the complaint that they had examined the person who is said to have paid the money.
ಹಾ.
Not that finding,
ಹ್ಮ್.
not page 53.
ಹ್ಮ್.
Not last, not about 5 lines.
ಹ್ಮ್.
ಸದರಿ ದಿನದಂದು ಸಾಕ್ಷಿ 5 ಆದ ಅನ್ವರ್ ಫಹೀಂ ರವರೊಂದಿಗೆ ಮಾತನಾಡಿದ್ದರು ಮತ್ತು 15 ಲಕ್ಷಗಳಿಗೆ ಬೇಡಿಕೆ ಇಟ್ಟು 5 ಲಕ್ಷಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದರು ಎಂಬ ವಿಚಾರಗಳನ್ನು ಅಲ್ಲಗಳೆಯುವಂತಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಸದರಿ 7 ಲಕ್ಷ ರುಗಳು ತಮ್ಮ ಕಚೇರಿಯಲ್ಲಿ ಇತ್ತು ಎಂಬುದರ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲಾತಿಗಳು ವಿಚಾರಣೆಯಲ್ಲಿ ಲಭ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಆರೋಪಿ ನಂಬರ್ 1 ರವರಿಗೆ 7 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೆ ಎಂಬುದರ ಬಗ್ಗೆ ಯಾವುದೇ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿಯಾಗಲಿ ದಾಖಲಾತಿಗಳಾಗಲಿ ವಿಚಾರಣೆಯಲ್ಲಿ ದೊರೆತಿರುವುದಿಲ್ಲ. This is not as against the accused number 2. Ultimate findings not are at page 56.
All the accused have been
Exonerated. Please. And your lordship's order but has become final as on today.
Not yet final. According to you, the appeal is filed before the
SLP
apex
is
court.
filed, SLP is pending, there is no interim order. But this was passed on 8th September 2021.
What is the allegation in second matter?
The first matter is about masks. Second matter is about cigarettes. That's the only subtle
One
difference.
with regard to the mask.
Masks, N95 masks. Second one is as regards cigarettes.
Cigarettes.
During COVID period, permission to sell it and all that.
Permission to sell.
How it transpired was, my lords, the economic offences wing of CCB first conducts a raid.
Not, I'll place on record the evidence of not the persons who are said to have not paid money, but their evidence not rendered in the department inquiry procedure. That your lordship may not consider.
ಅಲ್ಲ, ನಾನು ಹೇಳೋದು ಈಚ್ ಕೇಸಲ್ಲಿ ಏನು ಅಲಿಗೇಷನ್ ಇದೆಯೋ ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಮಾಡಿ
ಮಾಡ್ಕೊಡ್ತೀನಿ.
ನಿಮ್ಮ ಪಿಟಿಷನರ್ ಮೇಲೆ ಏನು ಅಲಿಗೇಷನ್
Please.
and also what they have relied upon
Please.
and also what is the finding in the departmental enquiry.
I shall.
ಅದನ್ನ ಮಾಡಿ.
Please.
You also both assist the court.
Please, my lords. I will also file one detailed compendium, my lords, citing out what are the crime numbers and what is that.
Third in part, both the counsels seeks time to place on record the evidence material of the departmental enquiry and also the synopsis.
Please.
List this matter on 30th.
Please.
30th.
Please, my lords. Interestingly, my lords, in the 161 statement before us, they say something, whereas in the departmental proceedings, they have technically gone hostile. And my lords, there as a
record ಇಲ್ಲ ಅಂದ್ರೆ ಇವರು
ಅಲ್ಲ 161 ಇದೆ ಇಲ್ಲಿ.
ನೀಲಿ ಎಕ್ಸಾಮಿನೇ ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ.
ಅಲ್ಲ, that is only complainant I said, my lords, not the others. Only one complainant in one case is what I said, not in the others. The others, my lords, in 161 statements, they agree for me. There they go and become hostile. And in terms of rules, at least I could have crossed them as a hostile witness. That also is not there in a departmental proceedings.
As we'll see first papers.
Please. Deputy.
Notes. Up to 79.
Please.
Hearing on IA 80, Mohan Kumar D.
Petitioner, my lord. At the successive bail application, my lord, the 7th bail application.
First time ಬಂದಿದೆಯೇನ್ರಿ?
ಇಲ್ಲ, ಇದು ಸುಮಾರು ಸಲ ಬಂದೋಯ್ತು. ಐಎ ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದು.
ಈಗೇನು ಅಯ್ಯ ಹಾಕಿದ್ದೀರಾ ನೀವು?
ಐಎ. ಸ್ವಾಮಿ
ಅಯ್ಯ ಹಾಕ್ಬೇಕು, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್.
ಅಲ್ಲ, ಅದರಲ್ಲಿ 7th is the successive 7th bail application.
ಆಯ್ತು, ಆಗ್ಲಿ.
He is in judicial custody 8 years, my lord.
ಆಯ್ತು. ಅಫೆನ್ಸ್ ಏನು?
302.
302. What is the punishment?
Life or
Is it a ground for?
No, my lord. The mother is bedridden, my lord. At least one.
Allegation ಏನು ಹೇಳಿ ಇವನ್ ಮೇಲೆ?
My lord, the accused number 1 and 2.
ಇವನ್ ಎಷ್ಟನೇ ಅವನು? ಅಕ್ಯೂಸ್ ನಂಬರ್ ಎಷ್ಟು ಅವನು?
Accused number 2.
A2. ಹೇಳಿ A2.
Accused number 1 is died during the judicial custody, my lord.
A1 died.
A1 died.
ಆಯ್ತು. A2
A2, my
What
lord,
is
his
the
own,
allegation?
own brother, my lord, A2.
Huh?
Own brother, A1 brother,
A1 brother, A2.
A2.
Allegation ಏನ್ material ಏನ್ ಹೇಳಿ.
My lord, as per the charge sheet, my lord, A1 and 2,
ಹಾ.
the stab injury to deceased Nagaraju.
Stabbed.
Stab.
ಹಾ. Injuries
My lord, injuries, my lord, 21 to 22 injuries, my lord,
total.
total.
ಹಾ. Eyewitnesses ಇದಾರಾ?
One eyewitness is turned hostile.
ಹಾ.
My lord,
ವಿಚಾರಣೆ ಆಗಿದೆ ಈಗ witnesses.
chief agide, cross examination ಗೆ last to 7 date is not appear before the court.
ಯಾರು?
Witnesses.
ಏನ್ರಿ ಮೇಡಮ್? Why you are not secured the eyewitness?
Your lordship, CW2 is the eyewitness, your lordship. CW176
Huh.
not yet cross-examined.
Huh?
Not yet
ಅದೇ.
cross-examined, your lordship.
Not yet cross examined ಅಂದ್ರೆ you have not kept the witness present before the court ಅಂತ.
6 date ಇಂದ ಸತತವಾಗಿ ಒಂದು ಡೇಟ್
Verify ಮಾಡಿ ಮೇಡಮ್ next time.
Please,
Verify
your
and submit why you are not keeping the eyewitnesses before the court.
ಮೊನ್ನೆ ಇತ್ತು, ಮೊನ್ನೆನೂ ಕೂಡ ಬರ್ಲಿಲ್ಲ. ನಾವು ಒಂದೇ ಡೇಟ್
Matter is taken adjournment by the
No, my
Petitioner
lord.
Council on 4 to
ಅದಕ್ಕೆ
5 occasions.
adjournment ತಗೊಂಡಿರೋದು ಅವ್ರ ಇನ್ಸ್ಟೆನ್ಸ್ ಅಲ್ಲ ಅಥವಾ ನಿಮ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಅಲ್ಲ, you place the order sheet.
ಫಸ್ಟ್
Huh?
ಚೀಫ್ ಆದಾಗ ಐ ಹ್ಯಾವ್ ಟೇಕನ್ ಡೇಟ್ ಫಾರ್ ನೆಕ್ ಸರ್ವಿಕಲ್ ಸ್ಪಾಂಡಲಿಸಿಸ್ ಆನ್ ದಟ್ ಡೇ. ದೇರ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ರೆಗ್ಯುಲರ್ಲಿ ಐ ಪ್ರೆಸೆಂಟ್.
ಆಯ್ತ್ರಿ, ನೋಡೋಣ.
ಆಯ್ತು.
ಆರ್ಡರ್ ಶೀಟ್ ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಆಯ್ತು.
And also let them place the material. Third, the counsel appearing for the petitioner would submit that the eyewitness who has been examined in chief not appeared before the trial court on several occasions. And hence additional SPP is directed to verify and submit and why the witness has not been kept present before the trial court for cross examination. List this matter on 2310. Submission na believe ಮಾಡಿ ಆರ್ಡರ್ ಬರೆಯಕ್ಕಾಗಲ್ಲ.
ಆಯ್ತು. ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
I have an experience when I was a district judge.
ಇಲ್ಲ ಖಂಡಿತ.
Advocate came and made submission before the court that no charge has been framed.
ಇಲ್ಲ ನೋಟ್ ಮಾಡಿ 7.
ನಾ ಹೇಳೋದ್ ಕೇಳ್ರಿ. And this court believed the version of an advocate and granted the bail. But true fact is different. Charge was framed 3 years back. Case was urgent for trial at the instance of the accused on several occasions. I sent the order sheet to this court. The advocate played fraud on the court and obtained an interim bail, making the submission. But the trial was postponed by making the payment of cost by the accused. And this court accepted the submission of the advocate, granted bail. And also called the report from me. How many witnesses are examined by the court? I sent the report with certified copy, but no action was taken for making false submission and obtaining the order.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನಾನು
That is my personal experience.
ಇದ್ರಲ್ಲಿ
That
ನಾನು
too when I was become district judge in 2002.
ಇದ್ರಲ್ಲಿ ನಾನು ಒಂದು ಡೇಟ್ ತೆಗ್ದಿದ್ದೆ ಅಷ್ಟೇ. ನೆಕ್ ನಂಗೆ ಆಗ್ತಿದೆ 4 months.
ಅಲ್ಲ ಆ ತರದೆಲ್ಲ ಇಲ್ಲಿ ನಡೀತದೆ, ಅದಕ್ಕೆ ಹೇಳ್ದೆ.
ನಾನು ಧಾರವಾಡಕ್ಕೆ ಬಂದಾಗ್ಲೂ ಅಪಿಯರ್ ಆಗಿ ನೆಕ್ ಅಂತ ಹೇಳಿ.
ಆಯ್ತ್ರಿ, ಅವಾಗೇನ ನೀವು ಕುತ್ತಿಗೆಗೇನ ಹಾಕೋ ಬಂದಿದ್ರಿ. ಆಯ್ತು.
Yes, madam.
ಅಲ್ಲ ನಾನು ಯಾಕೆ ಹೇಳಿದೆ ಇದನ್ನಂದ್ರೆ ಇಟ್ ಈಸ್ ಮೈ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. I sent the report along with certified copy of entire order sheet. False submission was made and obtained an order. Even actually at the cost of the accused only, matter was urgent, even trial was commenced.
ಇಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಆರ್ಡರ್ ಶೀಟ್.
ಕೊಟ್ಬಿಡಿ, ನೀವು ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ, then I will pass an order.
Yes, my lord.
Hearing matter 81.
ಹರಿದಾಸ್ ಭಟ್.
Appear for respondent in this case.
ಹಾ.
Last time party present ಮಾಡೋದು ಕೇಳಿದ್ಮೇಲೆ
ಏನಾಯ್ತು?
ಇದು ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ಟ್ ಇದೆ ಮೇಡಮ್, ಇವತ್ತು ಬರಕ್ಕಾಗದ ಮಳೆ ಅಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಬರ್ತಾರೆ.
ಪಾರ್ಟಿ ಯಾಕೆ ಪ್ರೆಸೆಂಟ್ ಹೇಳಿದ್ವಿ?
ಇದು ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದೆ ಮೇಡಮ್.
ಓ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದ. ಆಯ್ತು. ಕೌನ್ಸಿಲ್ ಯಾರೀಗ ಟೈಮ್ ಕೇಳ್ತಿದ್ದಾರೆ, ನೀವು ಅವರ?
ನಾವೇ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ.
ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಟು ಕೀಪ್ ದಿ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವಾಗ?
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ. ಎಸ್ ಮೇಡಮ್.
22nd ಅಲ್ಲ ಮೇಡಮ್?
22nd.
22nd. ಲಿಸ್ಟ್ 1 ಪಾಸ್ ಓವರ್ ಇದೆಯಾ? ಇದ್ರಲ್ಲೂ ಪಾಸ್ ಓವರ್ ಇದೆಯಾ? ಯಾರು ಬಂದ್ರ ಕೇಳಿ. 73 ಪಾಸ್ ಓವರ್.
Petitioner in this case.
ಹೇಳಿ ಕೌನ್ಸಿಲ್.
No, the FIR has been registered under, charge sheet has been filed under 468, 420. Subsequently, my lords, a civil suit was also filed by the complainant. The matter came to be compromised and A sale deed was executed by the complainant and the accused, both of them,
Hmm.
in favor of third person.
Hmm.
Compromise petition was also filed in the trial court where let's maybe permitted to file the additional document.
ಹಾಕಿಲ್ವ ಇನ್ನು
ಅದ್ರಲ್ಲಿ ಹಾಕಿರ್ಲಿಲ್ಲ.
ಕೊಡಿ ಅವ್ರಿಗೆ ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಶುರು ಮಾಡಿದ್ದೀರಾ?
ಇನ್ನ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ.
ನೋಟಿಸ್ ಫಸ್ಟ್ ಟೈಮ್
ಫಸ್ಟ್ ಟೈಮ್.
ಆಯ್ತು. ಅಡಿಷನಲ್ SPP is directed to take notice and issue notice against respond number 2 ಇದಾರಾ?
ಇದ್ದಾರೆ.
Respond number 2 and list this matter on 3010.
Interim stay may be granted.
No interim stay.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಮ್ಯಾಟರ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಏನಾಗೋದಿಲ್ಲ, ಇದುವರೆಗೆ ಆಗದಿಲ್ಲ, 15 ದಿವಸಕ್ಕೆ ಏನಾಗಲ್ಲ.
ಅಲ್ಲ ಅವಾಗ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲ ಈಗ
Counsel,
no, Milaj, one submission, Milaj. They kindly in the compromise petition, one of the condition that he has
whatever
agreed,
it may be,
he will undertake to
I have
withdraw the
passed an
fees.
order, I have passed an order to issue notice against R2. Let the notice be served on the other side. Appear, ಇನ್ನು 2 ವಾರದಲ್ಲಿ ಏನಾಗ್ತದ್ರಿ?
ಅಲ್ಲ ಅಲ್ಲಿ ವಿಲ್ ಬಿ ಆಸ್ಕ್ ಟು ಸಮ್ ಅಲ್ಲಿ ಚಿಕ್ಕಮಂಗ್ಳೂರು ಕೋರ್ಟ್ ಅಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಟು ಗೋ ಅಂಡ್ ಅಪೀಲ್.
ಏನೂ ಆಗೋದಿಲ್ಲ 2 ವಾರದಲ್ಲಿ.
ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡು ಸ್ವಾಮಿ ಪ್ರಾಪರ್ಟಿ ಅವ್ರು ಹೇಳ್ದಂಗೆ ಇದು ಮಾಡಿ he has undertaken to withdraw the fees there also.
ನೋಡೋಣ, let him also come.
Until next date of hearing ವರ್ಗೂ
ಏನಾಗೋದಿಲ್ರಿ 2 weeks ಅಲ್ಲಿ. ಅಯ್ಯೋ ಯಾಕೆ? ಅಯ್ಯೋಗ್ ಯಾಕೆ? ಥ್ರೂ ಐಒ ಅಂತನಾ? ಆಯ್ತು. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ R2 ಥ್ರೂ ಐಒ.
This one, passed over matter, serial number 2.
Respondent in this case ಅಲ್ಲ.
ಏನ್ ಕಂಪ್ಲೇಂಟ್? ಆಯ್ತಾ? ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಯ್ತಾ? ಆಯ್ತು ಹೇಳಿ.
Lord, I received the copies, my lord.
ಹಾ.
My respectful submission, my lord.
Hmm.
I would, the matter now before the trial court is posted for the 25th, my lord.
25th.
25th. Now, this is not an executory order where they'll have to be frantically seeking for a stay of proceedings. My respectful submission, my lord, is let me file my objections. I do not know why they want to do everything in a haste, my lord. Monday, if the matter is posted, let me file a detailed objection. My apprehension, my lord.
appeal, at least let me make
my
my
apprehension,
submission.
my respectful
My
submission, my
letter
lord.
should allow us to make
The
a submission.
bankers, I'm submitting, the bankers, my lord, are getting into a bad habit whereby they obtain stay orders before the High Court, my lord. They go ahead, they perpetrate what they need to do. They go ahead, either they take physical possession of the properties, or in this case, my lord, they say they've already transferred. Now only the sale needs to be concluded, which has, where a status quo has been granted by the lower court, my lords. My submission is this, my lord, 25th there. 23ನೇ ತಾರೀಕು, I will file my objections on Saturday, my lord. I will furnish it on to them. I'll serve a notice on to them. Let the matter be heard on Monday, my lord. That's all I am seeking before this honorable court.
What is the order?
It's a status quo, my lord. It is not an executory order.
ಆಯ್ತು, ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
Lordship, may I just say one thing, my lord. 250 crores we lent him. 250 crores. He has not repaid 1 rupee. Today, my lord, the liability is 535 crores.
The notice says 336, my lord. Please, my lord.
In 2022, we issued a notice saying you have defaulted on the loan. You have to therefore repay. At that time, it was 322 crores. He did not repay. There were some discussions going on. Then, my lord, security given is pledge of shares. So the share pledge was invoked. And, my lord, the trustee is the appellant before your lordships. The trustee, my lord, is appointed by the SEBI for the purposes of ensuring that all the persons who have given money are protected by a trustee. So trustee, my lord, has obtained a transfer of the shares in its name now in terms of the pledge of the shares. Now a suit comes to be filed saying that the entire letter issued calling upon him to pay. Now, my lord, it is simple. In terms of the Contract Act, under sections 172 to 177, he has an option of paying the money and redeeming the pledge and taking the money back and taking the shares back, which he does not want to do. He cannot use the process of the court to scuttle, my lord, the payment of money. Look at this. And now please see the order. The order, my lord, is most shocking. We argued for 2 hours that day. I was on caveat. We went and argued the matter. The order, my lord, is at page 37, 38. May I just very quickly read it, my lord? Lords may only see the order.
Yes.
Plaintiff counsel filed memo, submitted their withdrawing IA number 3 is not pressed. Heard counsel, satisfied reasons. As it is hit by section 28, memo is allowed and IA 3 is withdrawn. Counsel and counsel of plaintiff address the preliminary arguments on IA number 2 and 4. Contention of plaintiff is that defendant number 1 is given notice on 28/9
and given 5 business days after the date of notice for sale, and that notice period is not completed. On the other hand, defendant number 1 submitted that the sale has not taken place. Debentures were transferred in the name of defendant number 1. Also submitted, plaintiff has not produced board trust deed, acceleration notice, not produced pledge agreement, none of the documents are produced. Then it is pertinent to note 29/9 is Sunday, 2/10 is general holiday, Gandhi Jayanti. As per notice has to be left means 5 working days, includes 39, 110, 310, 410. As is the case in Bangalore, and both parties hail from Bangalore, Saturday and Sunday are not treated as business days. Hence 6/1 is 10 is a time limit given in the notice. Plaintiff submitted that even though time limit is 6/10, defendant transferred the debentures on 39. They've infringed notice period. Where it is, we don't know where this notice period is. The defendant 1 submitted that they've not made any sale as per notice. It is only a transfer. Plaintiff counsel submitted they are ready for settlement, for which defendant number 1 submitted. For that, they have to pay the amount to the office of defendant number 1. Now, this is the only reason. Overall, hearing both counsel on IA 2 and 4, for which the defendant number 1 filed preliminary objections, file also submitted wants to file elaborate objection to IA number 2 and 4 during the next hearing date. This court opines that there should be some status quo order to be passed as against the invocation notice dated 28/9/2024 issued by the defendant till the disposal of IA number 2 for the upliftment of natural justice and for fair justice. No finding on prima facie case, balance of convenience, irreparable injury, none of that
has been passed. My respectful submission, my lords. The figures that is being put forth before this honorable court, 256, 300 and all that, my lord. The value of the shares itself is more than 500, my lord. My respectful submission before this court. Now, on the intervening night of 27th and 28th at 1:38 a.m., my lord, a mail is sent to me. And 5 days does not include Saturdays, Sundays, and bank holidays, my lord. Now, all these things I need to bring forth before my lords. Now, on Monday, if I'm allowed to file my detailed objections, I would like to address my arguments. Assuming, my lord, some stay is passed by this honorable court, I'm perfectly all right with that, as long as they undertake that the sale is not confirmed, my lord. I'm okay with that. Now, if the proceedings are to be stayed, that's perfectly all right, my lord. Now, if the sale is concluded, now they say the transfer is done. If the sale is concluded, the very purpose of me approaching not just the trial court, my lord, anywhere it is lost, my lord. My respectful submission, my lord, is this. Let me be allowed to file my detailed objections. I will hear the matter on Monday, my lord, if it is not an inconvenience to this honor. Now, no harm or injustice will be caused to them, my lord. Why do they want to shut me off?
Post the matter on Tuesday.
Please, my lord. I will file my objections on Saturday. ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ ನಾನು.
ಕಾಪಿನ ಸರ್ವ್ ಮಾಡಿ ಅವ್ರಿಗೆ
ಮಾಡ್ತಾರೆ ಈಗ
ಮಾಡ್ತಾರೆ, ಅವ್ರು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ಲಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 25th ಇದೆ ಅಲ್ವಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 25th ಇದೆ.
25th.
First of all, my lord, this is not a suit which can be filed.
They need not say such comments, my lord. They are going to prejudice this honorable court.
I kept quiet.
I am the dominus.
Whenever I open my mouth,
I know what documents I need to furnish.
Allow me to
mislead ಮಾಡ್ತಾರೆ.
You allow me to speak.
Please.
Suit is filed in the civil court. Under the Commercial Courts Act, my lord, this is a commercial dispute. 2(1)(a) of the Commercial Courts Act specifies what's a commercial dispute. Ordinary transaction of bankers or financiers is covered as a commercial dispute. We pointed out to the court saying you can't pass this order. It's completely outside the jurisdiction of the court. How can an order of this kind be passed? Court has not even referred to it.
Anyhow, an order has been passed.
Yes, but without reasons. No reason. One reason at least should be there. It can't be, my lord, without reasons.
The reason is, my lord.
Ultimately, a person, lord, who has defaulted.
I will hear the matter on Tuesday.
Of course, if you
Let him file the statement of objections on Saturday. And let him serve the copy on you.
Please, my lord.
No, if the court is saying so, I'll not say anything.
I will hear and dispose of on that day itself.
Yes,
please, my lord. Please, my lord. I will not seek for adjournments.
Very well.
Counsel for the Kevetar,
Please, my lord.
Kevetar.
How?
Kevetar seeks 2 days time to file statement of objections, and in view of ensuing holidays, sir, given 2 days time to file statement of objections. Saturday working, madam, illi office? Saturday. But the statement of objections.
Office serve ಮಾಡ್ತೀನಿ, office.
And counsel for the respondent also undertakes to serve the copy of statement of objections on Saturday itself.
Please, my lord.
And hence list this matter on Tuesday, that is on 22/10.
Please, my lord. Much obliged.
Kopi, Satish K.
ಏನಕ್ಕೆ ಇದಾಯ್ತು ವಕಾಲತ್ A1.
Preparing for
ಏನಾಯ್ತು ಅಂತ ಕೇಳಿದೆ. A1B and A1C.
Court notice has to go, my lord.
ಯಾರಿಗೆ?
Appellant number
1B and C, my lord. I am appearing for 1A.
1A ಆಯ್ತು. ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂಡ್ ಟು A1B and C ಅಂತ ಇದೆ ಮೇಡಮ್. ಅದೇನಾಯ್ತು ಅಂತ ವೆರಿಫೈ ಮಾಡಿ ಹಿಂದೆ ಬೆಳಗ್ಗೆ.
ಇದೆ ಲಾಂಗ್ ಬ್ಯಾಕ್ ಹೋಗಿರೋದು, ಆದ್ರೆ ಅದ್ರಲ್ಲಿ ಏನು ಬಂದಿಲ್ಲ ಸರ್. ಅದು ವಾಪಸ್ ಏನು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಬಂದಿಲ್ಲ.
ಯಾವಾಗ ಅದ ಇಶ್ಯೂ ಆಗಿರೋದು ಅಂತ ಹೇಳಿ ಅಂತ ಹೇಳಿದ್ರು.
4/9/2023, my lord.
23 ನಲ್ಲಿ ಹೋಗಿರೋದು.
4/9/23. Told the registry is directed to issue fresh court notice against A1B and C. Advocate ತೀರ್ಕೊಂಡಿದಾರಾ?
ಹೌದು.
ಆಯ್ತು. List this matter on 8/11.
Please, my lord.
21.
Yes, madam.
Your lordship has asked us to file a memo, my lords, seeking dispensation of notice from R9 to R14, which has been filed. It has been filed, my lords.
File ಮಾಡಿದಾರೇನ್ರಿ?
Yes, ma'am.
ತಗೊಳ್ಳಿ. The appellant counsel has filed memo to dispense the notice against
R9 to R14.
R9 to 14,
Yes, ma'am.
R9 to 14, and hence memo is accepted and notice against R9 to 14 is notice is dispensed at the risk of the appellant petitioner, the appellant. Mattena non-filing of acknowledgement for having served copy of the RP and the counsel appeared in IMF ಅಂತೇನ ಇದೆ?
ಅದು 2 ಸರಿ issue ಮಾಡಿದ್ವಿ, my lords, but it had not been served.
ಮೇಡಮ್ ಇದು RP ಅಲ್ವಾ?
RPL.
Earlier ಅವ್ರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರ ಇಲ್ಲ?
ಇನ್ನೊಂದು MFA ಅಲ್ಲಿ ಅವ್ರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ.
ಮತ್ ಮಾಡಿದಾಗ ಇಲ್ಲಂಗೆ ನೀವು ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ತೀರಿ?
My lords, that was the instruction I was asked to.
ಲಾಟು ಸರಿ, ಹಿಂದೆ ಅರ್ಲಿಯರ್ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರೆ ರಿವ್ಯೂ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ ಹೇಗೆ ರಿವ್ಯೂ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ನ? MFA ಆರ್ಡರ್ ಅಥವಾ ಯಾವ್ದ್ರ ಆರ್ಡರ್ ಇದು? ಅರ್ಲಿಯರ್ MFA ಆರ್ಡರ್ ಮೇಲೆ RP ಬಂದಿದಾರಾ?
Yes, ma'am.
ನೋಡಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರ ಕೌನ್ಸಿಲ್. ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಕ್ ಬರಲ್ಲ ಮೇಡಮ್ ಇದು. ಅರ್ಲಿಯರ್ ದೇ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಥ್ರೂ ಕೌನ್ಸಿಲ್. ಕೌನ್ಸಿಲ್ ಸರ್ವ್ ಮಾಡಿ ಅಂತ ಮಾಡಿದೀವಲ್ಲ. ಆಗಿದೆಯಾ? ಅದಕ್ಕೆ ಕೇಳಿದ್ದು. ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದ್ರೆ ನೋಡ್ಬೇಕಷ್ಟೆ. ಇವ್ರಿಗೆಲ್ಲ ಮೊದಲು ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆಯಾ ಮೇಡಮ್ ಅರ್ಲಿಯರ್?
ಇಶ್ಯೂ ಆಗಿತ್ತು, my lords, ಅವ್ರಿಗೆ ಸರ್ವ್ ಆಗಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
R9 R9 ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಬ್ರು 9 to 14 ಆಗಿದೆಯಾ ನೋಡಿ?
8 to 11 and 14 and 15 ಅಂತ ಆಗಿದೆ.
8 to 11 ಅಂದ್ರೆ
12 and 13 ಬಿಟ್ಟು
12 and 13 ಆಗಿದೆಯಾ ನೋಡಿ? ಅವ್ರೇನಾ? 12, 13, 14 ಅಪಿಯರ್ ಆಗಿದಾರಾ?
ಅಪಿಯರ್ ಆಗಿದೆ.
ಅಲ್ಲ ಅವ್ರೇನ ನೋಡಿ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಈಗ ಇದರಲ್ಲಿ 12, 13, 14 ಅವ್ರೇನ ನೋಡಿ? ಬೇರೆ ಇದ್ರೆ ಬರೋಣ. ಅದು ಸರಿ. R9 ಸೇಮ್ ಕರೆಕ್ಟ್. 10 ಅವ್ರ ಹೆಸರೇನು ನೋಡಿ? 9 ಆಯ್ತ್ರಿ, 9 ಆಯ್ತು. 10 ಏನ್ ಹೇಳಿ? 10 ಯಾರಿದ್ದಾರೆ? ಪ್ರತೀಶ್ ರೆಡ್ಡಿ ಇದ್ರಲ್ಲಿ ನೋಡಿ MFN ಅಲ್ಲಿ 11ಗೂ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ. ಆಮೇಲೆ ಅಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿಲ್ಲ, ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. Represented by whom? Natural guardian ಯಾರು ಅವನು? ಇಲ್ವಾ? ಆವಾಗ ಅಲ್ಲಿ ಅಪೇರ್ ಆಗಿದಾರಲ್ಲ ಮುಂದೆ ಹಿಂದಕ್ಕೆ ಅದರಲ್ಲಿ MFN ಅಲ್ಲಿ R2 ಏನಾಗಿದೆ? ಫಸ್ಟ್ ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ? ಅಪೇರ್ ಆಗಿದಾರ ಇಲ್ಲ? ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ, ಅಲ್ಲಿಗೆ ಅವ್ರದ್ದು ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ R2 ಅಲ್ಲ? ಅಲ್ಲೇನಾಗಿದೆ ಅದರಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ, ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ, ಹಾಗಾದ್ರೆ ಅವ್ರಿಗೆ ಮಾಡಕ್ ಬರಲ್ಲ. ಹಾ, R13 ಆಗಿದೆ, ಆಯ್ತು. ಹಾಗಾದ್ರೆ ಒಬ್ರಿಗೆ ಮಾತ್ರ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಕ್. ಇನ್ನು 14 ಏನಾಗಿದೆ ನೋಡಿ, 14 ಹೆಸರೇನು? ಹ್ಮ್ ಹ್ಮ್ ಅಲ್ಲಿ ಬರ್ಕೊಳ್ರಿ. Filed the memo to dispense the notice against R2 ಅಲ್ಲ R9 to 14 on perusal of the records. R12 was appeared through counsel in the MFA and hence notice is not dispensed against R12 and others notice is dispensed since in the original MFA also notice has been dispensed against them. The council is directed to pay PF to issue notice against R12. ಆಯ್ತಾ? 15 ಇಲ್ಲೇನು ಕೇಳಿಲ್ಲ, 14 ಆಗೋಯ್ತು ಬಿಡಿ. ಆಯ್ತು, ಮಾಡಿಲ್ಲ ನಾನು, R12 ಮಾತ್ರ ಮಾಡಿದ್ದೀನಿ ಈಗ. R12 PF ಕೊಡಿ
Please.
if PF R2 ಕೊಡ್ಬೇಕಾಗಾರೆ and also to pay PF to R2. R2 ಅಲ್ಲೇನ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋರು ಅರ್ಲಿಯರು ಒರಿಜಿನಲ್ MFA ನಲ್ಲಿ ನೋಡಿ. And if PF paid, issue notice against R2 and R12. And council also directed to serve the copy of this RP on the council who appeared on behalf of R2 and R12 in MFA. ಅವ್ರಿಗೂ ಸರ್ವ್ ಮಾಡಿ. ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅಲ್ಲಿ, ಸರಿ ಆಯ್ತು ಬಿಡಿ. R2 and R12 list this matter on 8/11. Next
33.
33.
Appearing for the respondent. I sincerely apologize for not appearing in the morning, my lord. On record my written arguments.
ಇದು ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದು ಮೇಡಮ್, ಬಂದಿದೆಯಾ ಅದನ್ನು? ಆಯ್ತು. ಹಾ, ಬೇಡ ಬೇಡ, ಅದ್ಯಾಕೆ ಇದನ್ನ ಕೊಡ್ರಿ.
This is an appeal.
7159, yes.
Yes, filed against the order passed by the Railway Claims Tribunal. Tribunal, my lord, has wholly rejected the claim for compensation filed by the appellant. My lord, in order to establish a claim for compensation, the appellant must show that the deceased was a passenger on the train.
Yes.
May I read out, my lord, the relevant provision of the Railways Act? This is section 124A, my lords. Compensation on account of untoward incident. When in the course of working a railway an untoward incident occurs, then whether or not there has been any wrongful act, negligent or default on the part of the railway administration, such as would entitle a passenger who has been injured or a dependent of a passenger who has been killed to maintain an action and recover damages in respect thereof. I'll stop here, my lords. So the operative, the most important part of this provision is that he must be a passenger. The Railway Claims Tribunal has found the deceased not to be a passenger. And there has been no material placed on record by the appellant to show that the deceased was a passenger on the train, my lords. May I just read out, my lords, the initial statement which was given by the appellant number 1, my lords. This is, my lords, at page number 9, my lords, of my written arguments.
Yes.
It starts from page number 9, my lords, page number 9 and 10. The translated version, my lord, is at page number 11 and 12. This is, my lord, statement of the father of the deceased. Immediately after the accident took place and the father went to see the deceased body, that is when a statement was taken by the police. If your lordships would kindly take the second page of the statement, my lords. It starts from the said son. The said my son was working in Birur Government Hospital on daily wage basis, contract basis. On 21/1/2017, my son left the house saying that he is going to visit his aunt who is residing at Davangere. I have taken him to the railway station in my bike at around 10:30 p.m. I have also provided him a railway ticket and returned home. This is a common averment which is made by the appellant in all his pleadings, whether it is in the examination chief or whether it is in the complaint. He has admitted that he himself purchased the ticket and gave the ticket to the son. But the most crucial aspect, my lord, in this matter is there is not even one single detail on the train number, on the train name, when the train departed from Birur railway station, when it arrived at Davangere railway station, no details have been provided. When, my lord, there is an absence of evidence or even details as to the train information on the train, cannot be assumed, my lord, that the deceased was a passenger in the train. Next, my lords, another averment made by the appellant, my lord, is that the deceased traveled from Birur to Davangere. He visited his aunt. Let me read out that portion, my lord. It's the same written arguments, my lord. Page number 15, my lords. It starts, my lord, at page number 13. Relevant portion, my lord, is at page number 16, my lords. This is the statement of the mother, my lords. It's top, my lord. It says, I along with my husband. I along with my husband and second son Siddesha and identify the dead body is of my opinion first son Manoj Kumar SR. My son was working in Birur Government Hospital as a daily wage worker on contract basis. On 21/1/2017, during night, he left the house saying he is going to the house of my younger sister Geeta, who lives in Davangere. My husband had taken him to Birur railway station and provided him a railway ticket and returned home. Therefore, my lord, this deceased went and visited his aunt. The aunt has not been produced before the court. If he had visited his aunt, my lord, then the aunt is absolutely essential to come before the court and submit that the deceased had come to her house and he left the next day. Only then, my lord, could it be established that he was a passenger on the railway station, on the train.
While coming back, accident was taken place?
Yes, my lord, coming back. My lord, my humble submission is, there is no record as to when the accident actually took place. On a circumstantial evidence basis, the FIR, charge sheet and the inquest, they all come to the conclusion that the accident took place while he was coming back. Because, my lord, there are no eyewitnesses to this accident. Next.
What is the reasoning given by the railway tribunal?
My lord, the reasoning given is, my lord, the very same reasoning that no train details have been provided by the father. When the I'll just read out the relevant portion, my lord, because they have gone into detail, my lord. My lord, would your lordships kindly take a page number, the judgment, my lords.
Paragraph?
Yes, my lords. Paragraph, my lords, 12, my lords. In paragraph 12, my lords, unnumbered paragraph is the second part of paragraph 12, my lords. It starts from on 22/7. May I read it out, my lords?
Yes.
On 22/2/2017, Srinivas Rao, keyman of, my lord, this may not be important, my lords. I'll read the second sentence, my lords. It is seen from the inquest report that the deceased suffered serious injuries, including wound on the forehead and amputation on his left hand and both the legs. The SI GRP found 5 notes of ₹100 denomination and some other paper pieces, but no journey ticket was found. The father of the deceased, as mentioned above, filed an affidavit stating that he had not only dropped off his son at Birur railway station on his bike, but also purchased the ticket for him and gave it to him as his son was traveling to Davangere to see his aunt. However, the father of the deceased has not mentioned anywhere, that is in the affidavit or the statement to the police or his deposition in court, the cost of the ticket or the train by which his son traveled. This is quite surprising since as he only bought the ticket, he would have inquired at the time of purchase of ticket which train would be available for travel to Davangere. This raises serious doubts about the truth of his statement. The distance between Birur and Davangere is only 114 kilometers by rail and the journey time is less than 2 hours, which means that the deceased...
accident ಆಗಿರೋದು ಬರುವಾಗ ಇದೆಲ್ಲ ಯಾಕೆ necessary?
Lords,
ಆಕ್ಸಿಡೆಂಟ್ ಹೋಗುವಾಗ ಆಗಿಲ್ಲ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು.
The evidence,
ಆಕ್ಸಿಡೆಂಟ್ ಬರುವಾಗ ಆಂಟಿ ಮನೆಗೆ ಹೋಗಿ ವಾಪಸ್ ಬರುವಾಗ ಆಗಿರೋದು.
yes,
ಈ
Malord.
ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಯಾಕೆ ಬೇಕು?
Malords, because the appellant must establish that he is a passenger of the train.
No, he was not the passenger on that day. While coming back only accident was taken place.
Yes, my lords.
How he could say?
My lords, whether.
This is while going to the house of Davangere. But accident was taken place while coming from Davangere to Birur.
That fact is not established by by the appellant at all. It is
Whatever
an
it may be,
assumption basis
counsel.
we are saying accident took place while he was coming back. My lords, accident can take place whether he is a passenger or whether, and it can also take place while he was crossing the railway track.
Why unnecessarily the tribunal discussed all these things?
Because, my lords, accident could have taken place while he was illegally crossing the railway track as well. If he was.
What is the material?
My lords, there is no.
Accident was taken place. That is only an assumption.
Yes, my lords.
According to the railway.
It is, but he must.
While crossing the track.
Yes, my lords.
Who speaks about that?
My lords, there is no averment on that, but in
Is it your defense in the objection statement?
Yes, my lords, it is our defense that he is not a passenger of the train.
That's all.
Yes.
But not while crossing the railway track.
No, my lord, that is not our defense.
And then?
But my lord, in order to be entitled to compensation under the act, he must show he's a passenger. One cannot assume that he's a passenger in the train. Otherwise, my lord, left, right and center, everybody will file an affidavit saying that they were passenger on the train and be entitled to compensation. That is not, my lord, the object of the act in my humble submission. My lords,
this is quite possible since the residence of the deceased as mentioned by the father of the deceased is only 1.5 kilometers from the site of the incident.
Yes, my lords. In fact, my lords, I'll continue reading, my lords. This is the important portion of the judgment. The distance between Birur and Davangere is only 114 kilometers by rail, and the journey time is less than 2 hours, which means that the deceased would be reaching Davangere somewhere around 1 a.m. in the night. The respondent
Actually, where the accident was taken place?
My lord, it took place 1.5 kilometers away from Birur railway station.
Birur railway station.
Birur railway station. The respondent counsel argued that this is an odd time to travel, and nowhere in their statements have any family members mentioned any urgency for the deceased to travel to his aunt at such an unearthly
Then what
hour.
are the materials in the records that is documentary evidence placed before the court? A1.
Yes,
What
my-
is that A1? A1 is from 22 to 6:30 AM to 7:30 AM. Place of occurrence. 7:30 AM between Birur, Naga-Wangala railway station. So Chikmagalur, Karnataka, so. ನಾಗಮಂಗಲ ರೈಲ್ವೆ ನಿಲ್ದಾಣಗಳ ಮಧ್ಯೆ ರೈಲ್ವೆ ಕಿಲೋಮೀಟರ್ ರೈಲ್ವೆ ಮೃತಪಟ್ಟು ಬಿದ್ದಿದ್ದ ಬಗ್ಗೆ ರೈಲ್ವೆ ಕೀಮನ್ ಶ್ರೀನಿವಾಸರಾವ್ ಗ್ಯಾಂಗ್ ನಂಬರ್ 1 ಅವರು ನೋಡಿ ಸ್ಟೇಷನ್ ಮಾಸ್ಟರ್ ಬೀರೂರಿಗೆ ತಿಳಿಸಿದ್ದು ಮುಂದಿನ ಕ್ರಮ ಕುರಿತು ಡೆಪ್ಟಿ ಮ್ಯಾನೇಜರ್ ಅರ್ಸಿಕೆರೆ ಮುಖಾಂತರ ಕಳಿಸಿಟ್ಟು ಸ್ವೀಕರಿಸಿದ ಸೋನ್ಸೋ A1. Then Srinivasrao that he is reported A2. PM report A3. A4 is the case diary. That is inquest. You see the inquest also?
This one.
In paragraph number 7. ಮೃತನು ಬೀರೂರು ನಾಗವಂಗಲ ರೈಲು ನಿಲ್ದಾಣಗಳು ಮಧ್ಯೆ ರೈಲ್ವೆ ಸೋನ್ಸು ಲೈನಲ್ಲಿ ರೈಲು ಹಳಿಗಳ ಮೇಲೆ ಬೋರ್ಲಾಗಿ ಬಿದ್ದಿದ್ದು ಉತ್ತರಕ್ಕೆ ತಲೆಯಾಗಿ ದಕ್ಷಿಣಕ್ಕೆ ಬಿದ್ದಿದ್ದು ಮೃತನ ತಂದೆಯ ಹೇಳಿಕೆಯಂತೆ ದಿನಾಂಕ 21/2/2017 ರಾತ್ರಿ 10:30 PM ಸಮಯದಲ್ಲಿ ಮೃತನ ತಂದೆ ಹಾಗೂ ಮೃತನ ಇಬ್ಬರು ಬೀರೂರು ರೈಲು ನಿಲ್ದಾಣಕ್ಕೆ ಬಂದು ಮಗನಿಗೆ ದಾವಣಗೆರೆಗೆ ಹೋಗುವ ರೈಲು ಟಿಕೆಟ್ ಅನ್ನು ಕೊಡಿಸಿ ಹೋಗಿ ಬರುವಂತೆ ಹೇಳಿ ಹೋಗಿರುತ್ತಾರೆ. ಅದರಂತೆ ಮೃತನು ಯಾವುದೋ ರೈಲನ್ನು ಹತ್ತಿ ದಾವಣಗೆರೆಗೆ ಹೋಗುವ ಉದ್ದೇಶದಿಂದ ಪ್ರಯಾಣ ಮಾಡುವಾಗ ವೈಲ್ ಗೋಯಿಂಗ್ ಟು ದಾವಣಗೆರೆ, ನಾಟ್ ವೈಲ್ ರಿಟರ್ನಿಂಗ್, ಆಕಸ್ಮಿಕವಾಗಿ ಚಲಿಸುವ ರೈಲು ಗಾಡಿಯಿಂದ ಬಿದ್ದು ತಲೆ ಹಾಗೂ ಕೈಕಾಲುಗಳಿಗೆ ಗಾಯವಾಗಿ ರಕ್ತಸ್ರಾವ ಹೊಂದಿ ಸ್ಥಳದಲ್ಲೇ ಮೃತಪಟ್ಟಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ದಿಸ್ ಇಸ್ ದಿ ರಿಪೋರ್ಟ್.
Yes.
ಮೃತದೇಹವು ಪಂಚರ ಸಮಕ್ಷಮ ಸೂಕ್ಷ್ಮ ಪರಿಶೀಲಿಸಿ ನೋಡಾಗಿ ಈ ಕೆಳಕಂಡಂತೆ ಇರುತ್ತದೆ. ಕುತ್ತಿಗೆವರೆಗೆ ಇಂಜುರೀಸು, Those are the injuries.
Yes.
Then what is the final report?
My lord, final report, my lord, they have denied the case of the petitioner. The DRM report, my lords. Conclusion, may I read, my lords? The inquiry into this reveals that in this case, father and brother of the deceased.
Antima Varadi, you see A5,
Yes.
document A5, column number 16. ನಾದಿನಿ ಮನೆಯಿಂದ ದಾವಣಗೆರೆ ಕಳುಹಿಸಲು ನಾನು ಬೀರೂರಿಗೆ ಬಂದು ರೈಲ್ವೆ ಟಿಕೆಟ್ ಕೊಡಿಸಿ ಮನೆಗೆ ಹೋದೆನು ಬೆಳಿಗ್ಗೆ ಬೈ in all throughout he says like that only. He came and dropped the son and also he had purchased the ticket and given the same to the son.
Yes.
To travel from Beerur to Davangere.
Yes, my lords.
ನನ್ನ ಮಗ ಬೀರೂರಿಗೆ ಒಂದು ರೈಲ್ವೆ ಟಿಕೆಟ್ ಕೊಡಿಸಿ ಮನೆಗೆ ಹೋದೆನು ಬೆಳಿಗ್ಗೆ ರೈಲ್ವೆ ಪೊಲೀಸರು ಕರೆ ಮಾಡಿ ನನ್ನ ಮಗ ಮೃತಪಟ್ಟ ಬಗ್ಗೆ ತಿಳಿಸಿದ್ದು ಹೋಗಿ ನೋಡಿ ಗುರುತಿಸಿರುತ್ತೇನೆ ಇದನ್ನು ರೈಲ್ವೆ ಗಾಡಿಯಲ್ಲಿ ದಾವಣಗೆರೆಗೆ ಹೋಗುವಾಗ ಅಂತಲೇ ಇದೆ ಸ್ಪೆಸಿಫಿಕ್. ವೈಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ದಾವಣಗೆರೆ ಆಕಸ್ಮಿಕವಾಗಿ ಕೆಳಗೆ ಮೃತಪಟ್ಟ ವಿನ ಈತನ ಸಾವಿನಲ್ಲಿ ಬೇರೆ ಅನುಮಾನ ಇರುವುದಿಲ್ಲ. ಇದೇ ಅಭಿಪ್ರಾಯವನ್ನು ಮೃತನ ತಾಯಿ ಮತ್ತು ತಮ್ಮ ಹೇಳಿಕೆ ನೀಡುತ್ತಾರೆ. ನಂತರ ಪಂಚರನ್ನು ಬರಮಾಡಿಕೊಂಡು ನಂತರ ಬಿದ್ದಿದ್ದ ಸ್ಥಳದ ಸನ್ನಿವೇಶ ಮತ್ತು ಸ್ಥಿತಿಗತಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ನೋಡಾಗಿ ಮೃತನು ಜೀವಂತವಿದ್ದಾಗ ದಾವಣಗೆರೆ ಕಡೆಗೆ ಹೋಗುವ ರೈಲು ಗಾಡಿಯಲ್ಲಿ ಪ್ರಯಾಣ ಮಾಡಿಕೊಂಡು ಹೋಗುವಾಗ ಆಕಸ್ಮಿಕವಾಗಿ ಕಾಲು ಜಾರಿ ಕೆಳಗೆ ಬಿದ್ದು ತೀವ್ರತರದ ಗಾಯಗಳಾಗಿ ಸ್ಥಳದಲ್ಲಿ ಆಕಸ್ಮಿಕವಾಗಿ ಮೃತಪಟ್ಟಂತೆ ಕಂಡು ಬರುತ್ತದೆ ಅಂತ ಪಂಚರ ಮತ್ತು ನಮ್ಮಗಳ ಏಕ ಅಭಿಪ್ರಾಯವಾಗಿದ್ದರೂ ಸಹ ಮೃತನ ಮರಣದ ನಿಜವಾದ ಕಾರಣವನ್ನು ತಿಳಿಯಲು ಬೆಂಗಾವಲಿನಲ್ಲಿ ಬೀರೂರು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಕಳುಹಿಸಿ ವೈದ್ಯಾಧಿಕಾರಿಗಳಿಂದ PM ಮಾಡಿಸಿ PM ಆದ ನಂತರ ಮೃತನ ತಂದೆ ಶ್ರೀ ರಂಗನಾಥರವರು ಕೋರಿಕೆಯಂತೆ ಮೃತದೇಹವನ್ನು ಸಮೇತ ಕೊಟ್ಟು ಸ್ವೀಕೃತಿ ಪಡೆದಿರುತ್ತಾರೆ.
Lords, there were no eyewitnesses to the accident. Lords, the FIR and the charge sheet, what have said the date, the time of occurrence of the event is at next day at 7:30 AM.
7:30 body was found, that's all.
Yes, my lords. There is no evidence to place on record when the accident actually took place. Lords,
Then the respondent has to speak on what time of the train was proceeded in that line.
Yes, my lords.
No such material.
Lords,
Except, is there any evidence is adduced by the respondent railway authority?
we have only marked the DRM report, my lord.
Where is that DRM report?
Lords, DRM report, my lords.
R1. ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತದೆ DRM report ಅಲ್ಲಿ?
They have denied the case of the petitioner, my lords.
ಏನಂತ
Found
deny?
not to be a bona fide passenger.
Only you are relying upon the DRM report.
DRM removal and also the FIR and the charge sheet, my lords.
FIR ಅಲ್ಲೆಲ್ಲ ಇದೆಯಲ್ಲ, while traveling he fell down ಅಂತೆಲ್ಲ ಇರೋದು. Even final report also says like that. ಇದೆ DRM report?
R1, my lords.
ಅದು R1 ಎಲ್ಲಿದೆ? ಮಾರ್ಕ್ ಆಗಿರ್ಲಿಲ್ಲಲ್ಲ? ಆಗಿದೆಯಾ? ಇದ್ರಲ್ಲಿ ಆಗಿದೆಯಾ?
Entire set is marked.
Entire set is marked. ಎಲ್ಲಿದೆ ಮನೆ?
Starting few pages, my lords.
ಮಾರ್ಕ್ ಆಗಿದೆ.
This is ಎಷ್ಟು along with the white sheets.
ಯಾವ್ದು ಮೇಡಮ್?
There's a third
ಯಾವ್ದು?
page.
ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೀವು ಕೊಟ್ಟಿರೋದು.
Objection ಜೊತೆಯಲ್ಲಿ.
ಇದಾ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಜೊತೆ ಹಾಕಿರೋದು.
DRM report, my lord, has considered all the report is
Conclusion.
marked as
In this case, father and brother of the deceased are self-interested witness and also they are not the eyewitnesses of the incident. During the time of inquest, column number 7, it is mentioned that recovered only is wearing cloths and no valuable things were recovered. So no railway ticket was recovered. Deceased was not in possession of any journey ticket and hence could not be considered as a bona fide passenger. No evidence put forth to prove that the incident occurred due to the fault of the railways. No driver or guard of any train reported or witnessed the incident. Hence the claims of the compensation so and so.
Lord, I seek to place reliance on one.
One second. Let him complete.
Seek to place reliance on one judgment, my lords. Lords, Lordships kindly come to paragraph number 2, my lords.
ಕೊಡ್ರಿ.
Yes, my lords. 2019 12 ACC 391, my lords, 3 judge bench judgment. Paragraph 2, my lords, I'll just read it. The question that arises for our consideration is whether the deceased husband of the petitioner Gafur Saab had purchased a ticket and was attempting to board the train on 6/5/2007 at Davangere when the railway accident took place, whereupon he lost his life. Only if the above query is answered in the affirmative, the petitioner here would be entitled to compensation from the railway authorities. That is the question, my lord, whether he was a passenger. Railway Claims Tribunal, as also the High Court of Karnataka, while adjudicating upon the controversy raised by the petitioners, have arrived at a conclusion that the petitioners could not establish that the deceased husband Gafur Saab had purchased a ticket and was in the process of boarding the train at Davangere railway station when the accident took place. Learned counsel for the petitioner vehemently contended that there was no justification for the courts below to have recorded such a conclusion, inasmuch as it was clearly apparent from the
That is their arguments. Where is the
Yes.
finding?
My lords, paragraph number 6, my lords. We have considered the contentions advanced at the hands of so and so. We are of the view that the issue in hand can be determined on the basis of.
That is with regard to the nature of injury sustained by him.
Yes, my lords. Paragraph number 7, my lords. The aforesaid report also reveals that the body of the deceased had been cut into 2 pieces and lying next to the
That
railway.
is also with regard to the nature of injuries.
My lords, the next sentence, my lord. The above factual position reveals that the body was so and so. This can be inferred from the facts expressed in the inquest reports of the so and so. It is not possible for us to accept that such an accident could have taken place while boarding the train. In addition to the factual position emerging out of perusal of para 7 and 8 extracted above, the report also reveals that besides a pocket diary having been found from the person of the deceased, a few telephone numbers were also found. But importantly, the deceased was not in possession of any other article. This further clears the position adopted by the railway authorities, namely that the deceased Gafur Saab was not in possession of a ticket for boarding the train at Davangere railway station. Paragraph number 10, my lords. A perusal of the FIR leaves no room for any doubt that the deceased was seen coming from the direction of Bangalore, and while crossing the railway track, he having not noticed the oncoming train was overrun by the train. In view of the factual position depicted in the FIR as also the inquest report, we find no justification entertaining a challenge to the orders passed by the Railway Claims Tribunal. Here, therefore, my lord, the only question that ought to be looked into, my lords, whether he was a passenger in the train. In order to establish that ticket has to be produced, which is not done by the appellant.
Yes.
Therefore,
Yes.
my lords,
before, that is, just now I wanted to highlight these 2 aspects in paragraph number 5 in their statement. In the statement, just
Written
now I
statement.
showed. Yes. Under the that is a timing, it's everything is, I do not, there is no other disputes.
Paragraph number 5.
Paragraph number 5, then the last some 6 lines from morning 7:50. Therefore, under the circumstances, applicants having invented a story of colluding with the police created records to appear that incident is occurred. See, it is collusion is with the police and that is a railway police investigation. Then is again the same words.
Railway police final report ಹಾಕಿರೋದು.
ಹೌದು. ಇಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 9 ನಲ್ಲೂ ಅದೇ ಹೇಳ್ತಾರೆ. It is paragraph 9 last 3 lines. By colluding with the police and creating records to suit their needs and they are blaming the police then. My case is throughout the same. Therefore, it is clearly come under the judgment which I have cited.
Doli Rani Saha case.
The judgment's dismissal is incorrect. So requires to be allowed. Paragraph number 18, 19, 20.
the judgments provided by the appellant, my lords, do not apply to the present case. May I distinguish the case, my lord? Doli Rani, my lords, he has relied on paragraph number 13, my lords. Just read out paragraph number 13, my lords. The second sentence, my lords. In Reena Devi. In Reena Devi, two-judge bench of this court considered the question of the party on which the burden of proof will lie in cases where the body of the deceased is found on the railway premise. This court held that the initial burden would be on the claimant, which could be discharged by filing an affidavit of the relevant facts. Once the claimant did so, the burden would then shift on the railways. Then, my lords, at paragraph number 14, my lords. In the present case, the appellant had duly filed an affidavit stating the facts and adverting to the report arising from the investigation conducted by the respondent, which showed that the deceased was traveling on the train and that his death was caused by a fall during the course of his travel. The burden then shifted to the railways, which has not discharged the burden. Therefore, the presumption that the deceased was a bona fide passenger on the train in question was not rebutted. The judgment strongly relies on the case of Reena Devi, my lords. Reena Devi, my lords, in my most respectful submission, does not make such a contention at all. May I read out, my lords, Reena Devi? If your lordships have a copy, my lords, otherwise I have a copy.
Reena Devi case also discussed in paragraph number 18.
Yes, my lords.
In the judgment of Doliram's case.
Yes. Lords, in Reena Devi, what had happened was there was an independent witness to the accident. If your lordships kindly take para number 2, my lords, for a moment, my lords. The last sentence, my lords. He fell down from the train due to rush of passengers and died on the spot. One Kailash Gope, who witnessed the deceased purchasing the ticket and boarding the train, filed an affidavit stating these facts. He was not cross-examined. There was an independent witness witnessing the death of the deceased. In these circumstances, my lord, Reena Devi ought to be looked into. The relevant portion in Reena Devi, my lords, is at paragraph number 29. My lord, this is the para based on which Dolly Rani pronounced its judgment. Para 29, my lords. We thus hold that mere presence of a body on the railway premises will not be conclusive to hold that injured or deceased was a bona fide passenger for which claim for compensation could be claimed. However, mere absence of ticket with such injured or deceased will not negative the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railways, and the issue can be decided on the facts shown or the attending circumstances. Next sentence is important, my lords. This will have to be dealt with from case to case basis on the facts found. What judgments after Reena Devi have assumed, my lords, is that once a party files an affidavit, it will automatically, their burden is discharged. That is not what Reena Devi says, my lord. It says, court, after looking into the entire facts and on a case-by-case basis, can come to the conclusion that initial burden is discharged. In the present case, my lord, initial burden, with the records produced by the appellant, initial burden cannot be assumed to be discharged. And my lords, when Reena Devi says, mere absence of ticket with such injured or deceased will not negative the claim. The word used is negative, my lord. It certainly will not give a positive color to the fact that he had indeed bought the ticket. It merely will not negative his claim. Second, my lords, mere presence of a body will not be conclusive to hold that the deceased was a bona fide passenger. Therefore, my lords, merely because this body was found on the railway tracks is not conclusive of the fact that he was a bona fide passenger in the train. lastly, my lords, in the judgment which I had produced, 2019-12 SEC, the importance was placed, my lords, on the ticket being found with the deceased. Or at least some independent witness showing that the deceased had purchased the ticket, which is not there in the present case. Therefore, my lord, the reliance placed on Reena Devi and subsequently on Dolly Rani, my humble submission misplaced, my lords.
Counsel, you go to the cross-examination of AW1. That is contrary to the evidence of chief evidence. He says at 10:40 PM, I took my deceased son in scooty and dropped him near entrance of the counter, and he stood in the queue, saw him purchasing the ticket and entering inside the railway premises. This is the cross-examination evidence. But according to that is contrary. He says he dropped him and he had purchased the ticket and he handed over the ticket to the son. But here in the cross-examination, he gives different answer. Mistake ಹೆಂಗಾಗ್ತದೆ? In the cross-examination, he gives different version. Before the police also, he gives different version. He had purchased the ticket and he gave the ticket. Everywhere he says, but in the cross-examination, he says different. Accidental fall ray, but he says he only purchased the ticket and handed over the ticket to him. Not new aspect. In the cross-examination, he says, howdu. Maybe that is not in the written statement. Cross-examination, bari written statement ಅಲ್ಲಿ ಇದ್ದಿದ್ದೇ ಬರ್ಬೇಕು ಅಂತಿಲ್ಲ. AW1, different version he gives. He is also not an illiterate. You see his signature. He is not an illiterate. ಆಯ್ತು ಹೋಗ್ಲಿ, ಬಾಡಿನಲ್ಲಿ ಏನ್ ಸಿಕ್ತ್ರಿ? ಬಾಡಿ ಇದ್ ಮಾಡಿದಾಗ ಏನೇನ್ ಸಿಕ್ತಾವ ಅವನ ಹತ್ರ? ಏನೂ ಇಲ್ಲ. Damaged? 5 notes of the 100 denomination and some paper pieces were found, except those no other valuable were found. Even charge sheet also. ಬೇರೂರಿಗೆ ಬಂದು ರೈಲ್ವೆ ಟಿಕೆಟ್ ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನೋಡಿ ಗುರುತಿಸಿರ್ತೇನೆ, ರೈಲ್ವೆ ಟಿಕೆಟ್ ಕೊಡಿಸಿ ಮನೆಗೆ ಹೋದೆನು. ಥ್ರೋಟ್ he says, but cross examination different version. Third, the petitioner, counsel, and also the counsel appearing for the respondent. This miscellaneous first appeal is filed before this court, challenging the rejection of the claim petition filed by the petitioners. The factual matrix of case of the claimants before the railway tribunal that on 21/2/2017 at about 10:30 PM, deceased Ranganatha yaru?
Father of the
DM, the father of the deceased, Ranganatha, dropped him to Birur railway station and provided him a railway ticket at Birur station to go to Davangere and to return, and returned home from the railway station. The deceased travelled in the said train to go to Davangere and accidentally he fell down and sustained injuries. and body was found at kilometer number 211/700.800 upline in between Birur and Naga Wangala railway station. And the next day, that is on 22/2/2017 at about 9 AM, he received the phone call from railway police station that body of male person was found in the railway line. Immediately he rushed to the spot and also identified the body. And also it is the claim that railway ticket was lost and made the claim before the railway tribunal. The respondent appeared and filed a written statement denying that he was not a bona fide passenger and facts leading to the incident in question as narrated doesn't constitute an untoward incident, and the claim does not fall within the ambit of section 123C within bracket 2 within bracket and section 124A of the Railway Act. It is also contended that same is not on account of railway accident. The claimant, in order to substantiate the claim, evidence examined himself as AW1 and also got marked document A1 to 12. And on the other hand, respondent got marked exhibit R1. The railway tribunal, having considered both oral and documentary evidence available on record, comes to the conclusion that he was not a bona fide passenger and hence dismissed the claim petition. Being agreed by the said dismissal order, the present appeal is filed before this court. The main contention urged before this court is that in spite of no evidence was adduced by the respondent, the railway tribunal committed an error in coming to the conclusion that he was not a bona fide passenger. It is contended that a damaged phone handset of the victim was recovered along with some cash, and railway police also, in terms of exhibit A4, opined that death was due to the accident and exhibit R1 is created document by the department in order to escape from the liability. The final report A5 is very clear that he fell down from the running train and he had sustained the injuries. And post-mortem report also clearly discloses the nature of injuries. The counsel, in support of his argument, also would contend that the railway police themselves have investigated the matter and filed a charge sheet, stating that it was an accidental death. And when the respondent have not led any evidence, the railway tribunal ought not to have presumed the same that he was not a bona fide passenger. For contra, the counsel appearing for the respondent files written argument and contend that facts are essential to adjudicate the matter and same has not been pleaded. Essential witnesses are not brought before the court to prove the fact that he traveled in the said train. In order to prove that he was a passenger, they have not produced any material before the railway tribunal. And no details of train journey was given by the father who had been examined as AW1, and he has failed to mention the details of train and number and cost of ticket and time of arrival. And in order to come to a conclusion that the same is necessary, the appellant has not mentioned any of these details in the examination of his chief examination. And document which have been placed also doesn't disclose anything about the same. And also not examined any material witness to prove the factum that he had been traveled in the said train. And even not examined the aunt. The counsel also, in support of his written argument, placed the document number 1, that is affidavit in lieu of evidence of CW1 claimant. And so also placed the statement made before the police by the AW1 as per document number 2. And counsel also brought to notice of this court translated version. And throughout he says that he took him to the railway station and he only bought the ticket and provided railway ticket. And thereafter he returned to home. And mother of the deceased also reiterates the same. The counsel also relied upon the inquest report as document number 3. The counsel also would contend that the DRM report, which is marked as R1, is also very clear that on inquiry and investigation, nothing is found that he was traveled. So, in reply to the arguments, the counsel appearing for the appellant relies upon the judgment of Doli Rani Shah case. And counsel brought to notice of this court in the said judgment, the earlier judgment of Reena Devi case is also discussed. Brought to notice of this court shifting of burden on the railway. Once the affidavit is filed before the court. The counsel also relies upon paragraph number 17, wherein discussed with regard to the deceased fell from the train and nature of injury sustained by him. And merely because he is not having railway ticket is not a ground to discard the claim. In reply to this submission, the counsel appearing for the respondent relies upon the judgment reported in 2019 within bracket 12 Supreme Court cases 391, Kamronisa versus Union of India, and counsel brought to notice of this court paragraph number 10.
2 and 3.
Paragraph number 2,
And
3, 4, and 8, and also paragraph number 10. The apex court not accepted the case of the appellant when the railway tribunal and also the high court rejected the claim, and comes to the conclusion that in view of the factual position defected in the first information report as also the inquest report, we find no justification in entertaining a challenge to the orders passed by the railway claims tribunal and also by the high court while rejecting the claim of the petitioner. The counsel also brought to notice of this court the judgment of Union of India versus Reena Devi reported in 2019 within bracket 3 Supreme Court cases 572. The counsel would contend that in a case of Reena Devi, the co-passenger was examined. And
Independent witness, there was an independent witness who saw him purchase the ticket.
Co-passenger alwa?
Co-passenger anta ಬರ್ದಿಲ್ಲ your honor.
An independent witness was examined for having purchased the ticket by the deceased and boarding the train.
Yes.
He filed an affidavit stating these facts. The counsel referring this judgment would contend that in the case on hand, no such evidence is placed before the court. And even the counsel brought to notice of this court paragraph number 29, wherein discussion was made that mere presence of a body on the railway premises will not be conclusive to hold that injured or deceased was a bona fide passenger, for which claim for compensation could be maintained. However, mere absence of ticket with such injured or deceased will not negative the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railways, and the issue can be decided on the facts shown or the attending circumstances. This will also to be dealt with from case to case on the basis of facts found. Having heard the appellant counsel and also the counsel appearing for the respondent, and also the principles laid down in the judgment relied upon by the appellant counsel as well as the respondent counsel, this court has to examine material on record. And in keeping the contentions, the point that arise for the consideration of this court are whether the railway tribunal has committed an error in coming to the conclusion that deceased was not a bona fide passenger, and whether it requires interference of this court. Having heard the petitioner counsel as well as the counsel for the respondent, and also taking into note of the pleading of the claimant, and it is the specific pleading of the claimant that on 21/2/2017 at about 10:30 p.m., the father of the deceased, Ranganatha, dropped the deceased Manoj Kumar to railway station at Birur to go to the Davangere, and he returned from the railway station to his house. In yesterday morning, he has received the information regarding death of his son, and he went along with his family member and identified the dead body. The claimant, in order to substantiate their case, mainly relies upon the document of A1, that is FIR, wherein also it discloses that date and place of occurrence, that is 6:30 a.m. to 22/2/2017, 7:30 a.m. between Birur Nagavangala railway station, body was found. And the FIR also discloses that the same was intimated. One Srinivasa Rao, key man, gang number 1, about body was laying to station master. The other document is A2, that is the intimation given by the said Srinivasa Rao. The A3 is the postmortem report. And postmortem report is also clear that cause of death is due to shock and hemorrhage due to polytraumatic injuries. The other document is inquest A4, wherein also it is stated that father had dropped the deceased on 21/2/2017 at 10:30 p.m. There was a reference with regard to the deceased was traveled in the train. In the inquest, it is also very clear that dead body was with a cement colored cotton shirt, blue colored jeans pant, blue colored underwear, and found 5 notes of 100 denomination, and some of the paper pieces were found, and no railway ticket was found. It is important to note that final report was filed by the railway police, and the same is marked as A5, wherein also details are mentioned with regard to having purchased the ticket and given it to the son. And the final report discloses that while traveling in the train to Davangere, he accidentally fell down. And there is no any suspicion about the same. And same reason was given by the mother of the deceased. And Mazar was also conducted. And on verification and investigation, it is mentioned in the final report that while traveling, he accidentally fell down and sustained the injuries. And in order to know the cause of death, body was shifted to the Birur hospital. Having perused these materials before the court and also the evidence of AW1, no doubt throughout in the all the records, FIR, inquest, as well as final report, it is very clear that he fell down accidentally from the train while traveling in the train to Davanagere. And main contention of the railway that he was not a bona fide passenger. Only on the ground that no ticket was found in the body except the other articles. It is also important to note that in the cross-examination of AW1, he says he had dropped his son at 10:30 in his scooty near the entrance of the counter, and he stood in the queue, saw him purchasing the ticket. And no doubt there is a contradiction with regard to the purchasing of ticket. And throughout he claims that he only purchased the ticket and handed over the same to the deceased. But the fact that he came and dropped the deceased to the railway station at 10:30 p.m., 10:40 p.m. has not been denied during the cross-examination of AW1. And apart from that, the railway only relies upon the DRM report. And the said report is the self-styled report. And on perusal of the final report, even railway police themselves have conducted the investigation and filed the report stating that he fell down while proceeding to Davanagere, and it was an accidental death, and no doubt about the same. And also report says that the same has been reiterated by the father and mother of the deceased. And also the final report discloses the same, and also PM report discloses nature of injuries sustained by him. Having perused the reasoning of the railway tribunal, it appears that railway tribunal proceeded in an erroneous approach by giving the reasons that the father of the deceased has not given the details of ticket and cost of ticket, and the same is not warranted. Only he had spoken with regard to the dropping his son to the railway station and boarding of the train by himself, by the deceased. But mainly comes to the conclusion that the cost of the ticket is not stated by the father, and so also in the deposition in the court. And the same is not the material, and the material is only whether he had traveled or not, whether he had dropped the son to the Birur railway station or not. And disputing that he had not dropped him to the railway station, nothing is elicited from the mouth of AW1. And making such an observation, the railway tribunal comes to the conclusion that this is quite surprising, since as he only bought the ticket, he would have inquired at the time of purchase of ticket which train would be available for travel to Davanagere. And this observation is erroneous. If no train passes in the said railway station, the railway authority will not issue any such ticket. And it is not the case of the railway authority that train was not traveled. train was not passed through in the said railway station at 10:40 PM in the night. And that is not their case, except relying upon the DRM report. Nothing is placed on record. No doubt, it is evident from the records that the body was found at the distance of 1 to 1.5 kilometers from the site of the incident. That is residence of the deceased. And merely the residence of the deceased is situated near the railway station cannot be a doubt, cannot be a ground to disbelieve the contention of the claimants. And Railway Tribunal comes to an erroneous conclusion that he was not a bona fide passenger. No doubt, the judgment relied upon by the counsel appearing for the appellant Doli Rani Saha case. The apex court also discussed the judgment of Reena Devi case with regard to the burden is concerned. And appellant categorically stated that he himself has dropped the deceased to travel from Biru to Davanagere. And the very contention of the respondent counsel that they have not examined the aunt of the deceased cannot be a ground to disbelieve the case of the appellant. The material all discloses that he did not reach the house of aunt, which is located at Davanagere, but while traveling to Davanagere only, accident was occurred. And once he has filed an affidavit, no doubt burden shifts on the railway, and railway has not discharged the burden. No doubt the counsel appearing for the respondent relied upon two judgments of the apex court in Reena Devi case as well as Kamrunissa's case. No doubt in Kamrunissa's case, the apex court dismissed the claim made by the appellants in accepting the reasoning given by the Railway Tribunal as well as the High Court. And so also in the judgment of Reena Devi case, particularly in paragraph number 29, which brought to the notice of this court, is very clear that merely because body was found in the railway track cannot be a substantive proof that he was a bona fide passenger. And at the same time, the apex court also discussed that, however, mere absence of ticket with such injured or deceased will not negative the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railway, and the issue can be decided on the facts shown or the attending circumstances. In the case on hand, the claimant has been examined is AW1, and throughout from the date of accident, that is after recovery of the dead body, in the FIR, in the inquest, as well as in the final report filed by the railway police themselves, it is very clear that the death was occurred, and that too an accidental fall. And also an affidavit is filed to that effect. And this court already pointed out that railway not disputed the fact that father did not drop him, but mere discrepancy with regard to the purchasing of ticket cannot be a sole ground to discard the evidence of AW1. And from the date of registration of the case, that is FIR as well as inquest as well as final report, all goes against the railway. And also AFI is very clear that railway police only investigated the matter and filed the final report, wherein also they categorically mentioned that it is an accidental death. An untoward accident was taken place while traveling from Biru to Davanagere. When such being the material available on record, the railway ought to have been rebutted the case of the appellant, claimant, and accept self-styled report of DRM report. They cannot contend that no such untoward incident was taken place. And the very contention of the respondent counsel cannot be accepted, and material available on record clearly discloses it is an untoward incident taken place while traveling from Beeru to Davanagere by Davanagere. And the material available on record was not considered in a perspective manner by the railway tribunal, and hence the railway tribunal committed an error in coming to such a conclusion that he was not a bona fide purchaser, only on the ground that he was not having the ticket. Apart from that, he was having other material which were found in the dead body, that is notes as well as some piece of papers. And also it is important to note that when the body was noticed by the keyman and he reported the same to the station master, and mere missing of the ticket cannot be a ground to disbelieve the case of the claimants, and hence it requires interference of the court, and hence I answered the point as affirmative. Affirmative. In view of the discussions made up, I pass the following order. The appeal is allowed. The judgment and the award passed by the railway tribunal dismissing the claim petition is hereby set aside. Incident ಯಾವ yearದು?
2017.
2017. After the amendment or subsequent to the amendment?
After the amendment, it's entitled to.
Like 8 lakhs. The claimant is, the claimants are entitled for an amount of rupees 8 lakhs. With interest. ಎಷ್ಟು ಕೊಟ್ಟಿದಾರ ರೀನಾ ದೇವಿ ಕೇಸಲ್ಲೆಲ್ಲ? 6% with 6% interest. The award amount is payable within 8 weeks from today.
That I have submitted all their account particulars is already submitted along with the main petition. Therefore, without waiting, they can act.
8 weeks ಅಂತ ಕೊಟ್ಟಿದೀವಿ.
ಹೌದು.
ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು
Nowadays, it is through electronically, it will be transferred.
ಆಯ್ತು. The railway tribunal is directed to comply the award amount by electronic mode
Into their respective accounts. With
in favor of the
Committed.
claimants.
Claimants.
ಇಬ್ರದ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಥವಾ
ಇಬ್ರದ್ದು
ಒಬ್ರದ್ದು
ಕೊಟ್ಟಿದ್ದೀವಿ.
in respect of the claimants.
But let the appellant supply a copy, certified copy to the railway tribunal, my lords.
ಏನ್ certified copy?
Of this order, my lord, let him supply to the
Yes,
railway
yes,
tribunal.
that I will submit.
ಆಯ್ತು.
That I will submit.
The appellant counsel is also directed to furnish the copy of this order to the railway tribunal forthwith.
Grateful, my lords.
Next.
46.
46. Huh? ಅದು ಇನ್ನೊಂದ್ ದಿವಸ ನೋಡ್ ಇದಾರ ಅವರು? ಅದರ್ ಸೈಡ್ ಇದಾರ?
I appear, my lords, on the last.
ಆಯ್ತು, ಅದು ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಬಿಡಿ, ಪಾರ್ಟ್ ಆಡಲ್.
Lords, on the last occasion, on a very limited point, my lords had heard me and adjourned the matter.
Yes, you only took time
Yes.
to clarify.
To clarify, my lords,
ಆಯ್ತು
I'll come
ಆಯ್ತು
back.
ಹೇಳಿ. ಇದ್ರಲ್ಲೇ ಕೊಡಿ, ಅದು ನೋಟ್ಸ್ ಇದೆ.
54, my lords.
54.
With my lord's kind permission, may just file, my lords, a government record.
ಅದೇನ ಟ್ರೈನ್ ಟೈಮಿಂಗ್ಸ್ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಿ ನೀವು, ಹೌದಾ?
That particular aspect, my lords, on that point, my lords, so please to direct me to secure a government record which shows, my lords, that the train had started from Bengaluru at 4:30, my lords.
What time?
At 4:30, my lords, 16:30 hours. My lords, I've just produced for my lords' kind consideration an extract, my lords, of the railway timetable, my lords, of the year 2011. 2011, the relevant portion extract of the railway timetable, my lords. Lords may kindly see the first column, my lords, the first row.
ನೀವೇನಿದ್ರು ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಹಾಕ್ಬೇಕು ಇದನ್ನ. ನಾನು ವೆದರ್ ಐ ಕ್ಯಾನ್ ರೆಫರ್ ದಿಸ್?
Lords, my request is only this.
Unless you produce the same before the trial court.
Lords, my request is this, my lords, under 107 1D, my lords. I knew this point, my lords, would burden me. But my lords, under 107 1D, my lords, the CPC, my lords, shoulders are the broadest. My only request, my lords, is that this document, it's a government record. It's not particular, my lords, to this case.
It is an extract of a timetable of for a year for all the trains, my lords, not particular, my lords, to this train.
On that day, he traveled from?
He says, my lords, may just complete, my learned friend, may kindly permit me. May just complete, my lords. He said the body, my lords, has admittedly, it is their case that the body was found at 3 o'clock between Gollahalli and Doddabele, my lords. My lords may see the first row, Bangalore City Junction, and my lords may see the third last column, train number 16201, which is this particular train, my lords. Their case is that it is 16201. Lords, it leaves at 16.
I clarify here itself that aspect. That train number was inserted by the department. It is not by the claimants. Claimants just say they have traveled from here to Bangalore. Intercity and intercity. Between the city, they have several trains are passing, proceeding from Bangalore to Shimoga. They have traveled in the afternoon. So this intercity ಇದು ತಾಲ್ಗುಪ್ಪಕ್ಕೆ ಹೋಗೋದು ಶಿವಮೊಗ್ಗ ಮೇಲೆ ಹೋಗುತ್ತೆ, ಇಲ್ಲಿಂದ ಶಿವಮೊಗ್ಗ ಬೆಂಗಳೂರು ಹೋಗೋದು ಶಿವಮೊಗ್ಗ ಹೋಗುತ್ತೆ. ಅವ್ರಿಗೆ ಇಂಟರ್ಸಿಟಿನೇ ಎವ್ರಿಥಿಂಗ್.
ಹೇಳಿ ನಮಗೆ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ ಅದ್ರ ಮೇಲೆ.
Lords, that is not their case before my lords in the MFA. That is my only submission. My lords, it is part of the judgment, my lords.
If any material are there, you can produce additional evidence also, then we'll consider and remand the matter.
Deeply obliged, my lords. Deeply obliged, my lords. My lords, my limited point is just, my lords may kindly peruse the timetable.
Want to rely upon these documents, then you have to produce as additional evidence before the court. Then matter will be remanded to the railway tribunal to consider the matter afresh by giving an opportunity to both.
Lords, may make a request. Lords, may it be for this limited point, because otherwise, my lords, it would lead to a retrial. For this limited point, my lords, of considering as to how this particular evidence, my lords, was not on record the last time over. For that limited purpose, my lords, I concede, my lords, but if for my lord's benevolence under section 107 1D, my lords, if we consider,
Lower court records.
if not for that provision, my lords, I understand that I find myself in trouble.
Go to the records, then we'll see thereafter.
Obliged, my lords, obliged.
Cross examination ಏನಾರು elicit ಮಾಡಿಸಿದಿರಾ?
Lords, in the cross examination,
With regard to this timings is concerned?
Lords, what happens is, she says that she does not know. Most of the answers, my lords, are I don't know. She says, my lords, the brother of the deceased, my lords, who is said to have been traveling with him,
was along with him.
refused to get himself examined. He does not come before the tribunal, my lords. He does not lead evidence. Neither his ticket is given. He says, my lords, his statement says that at the time of the inquest he was there. His ticket is not on record. The disease ticket is not on record. What is found, my lords, as extracted, my lords, in the DRM report, which my lords
both left to Shivamogga.
and he says it goes to Shimoga, and my lords may kindly see, the deposition, my lords, of AW1 dated 3/1/17. Lords, the 7th, 8th line, they say that 16201 is nowhere on the record. That's not the case, my lords. Lords may kindly see from the middle of the line, may read, my lords. It says the witness also denies the suggestion that her deceased husband had traveled by any train. Witness also denies the suggestion that her deceased husband at no point in time had traveled with his brother Francis by train 16201. So she says, she's the only witness, my lords, of the claimant before my lords. And she says, my lords, in her statement, she denies the suggestion that he did not travel, which means she affirms it. And my lords, my learned friend says before my lords that we never said 16201, it is inserted by the other side. That's not the case, my lords. In their statement itself, they affirm that the deceased had traveled with his brother in 16201. And my lords, the timetable which I've now produced before my lords very clearly goes on to show that train number 16201 leaves from the source station 1.5 hours after the body was found. It, my lord, can never be a possibility. Even, my lords, testing it on preponderance of probabilities, giving them, my lords, every benefit of the doubt of the judgments that they place before my lords. My respectful submission before my lords is that there is not even an iota of chance this is possible, because the statement of the witness is that they are by 16201. The government record produced now before my lords shows that the train leaves.
Who gave the death intimation?
Death intimation was a key man, my lords.
Keymen had given the death intimation at 3 p.m. And that forms a part, my lords, of the DRM report. My lords, importantly, the DRM report is marked by consent. That forms a part of the order. Para 5 of the order, the tribunal says that the DRM report, my lords, is marked by consent. The statement of their witness, my lords, says that he traveled by 16201. That train, my lords, was not even near.
According to you, as per this document,
Intercity, same train number, my lords.
at what time it,
My lords, may kindly see, may just point out, my lords. I'll just point out 2-3 aspects for my lords' kind consideration. My lords, it may put quietus to the issue. My lords may kindly consider the first column, Bangalore City Junction.
16201.
16201 leaves, my lords, at 16:30. This is an annual timetable, my lords. For the whole year, this is the timetable. My lords may then kindly see below that after Malleshwaram, Yeshwantpur, Chikkabanavara, Soledevanhalli, my lords may see Gollahalli. Their case is that the body was found, my lords, between Gollahalli and 2 stations later, Doddabele. My lords, this train goes to Gollahalli at 17:01.
17 hours.
Which is 2 hours after the body was found. And it goes to Doddabele at 17:09. And in between this small stretch, my lords, the body is found, admittedly, my lords, at 3 p.m. and reported. And they say, my lords, in their cross-examination, that it is this train. This train, my lords, at that point in time hadn't even left from Bengaluru city. It left from Bengaluru city only 1.5 hours later. Therefore, my lords, affording them, my lords, every benefit of the doubt, every opportunity and every presumption, my lords, that the law inheres to their favor, it is inherently impossible, my lords, that this particular train could have, this person could have traveled in this train at 3 o'clock. My lords, on the last occasion, my lords, had also canvassed before my lords the view that it could have inured to their benefit, my lords, perhaps if it was later. If the train had to leave at 16:30, due to some delay left at 1700, and the person, my lords, had died, let us say 2 hours after that, my lords, which is not in keeping with this timetable. That, my lords, I understand. If their case, my lords, were to be accepted as a whole narrative before my lords, it would have to mean that all of the passengers in this particular train were left and nobody was taken with them, and the train left 1.5 hours before time. That, my lords, my respective submission, it points towards the fact that this is a case, my lords, of suspicious death. And that, my lords, forms a body of the order as well. And, my lords, to supplement that stance, the very own brother of the deceased person, my lords, who was traveling with him, who was there, my lords, at the time of the inquest,
was not examined.
he refused to place himself. Opportunity was given, he says he will not come. That's recorded, my lords, in the order. So in such a case, my lords, where there is not even if a 0.1% chance is there, my lords, I appear for an instrumentality of the state, my lords. I understand that I must not be hard and fast on rules, but at the same time, my lords, there is a bound
Incident on what date?
19/7/2011, my lords.
And on the very same day, the statement was recorded.
Statement was recorded.
Of the deceased also.
Deceased, only body was found, my lords, of the brother.
Brother of the deceased.
Brother of the deceased.
19/7/2011.
19/7/2011.
But he also categorically says intercity rail.
ಅಷ್ಟೇ ನಂಬರ್ ಹೇಳೋದಿಲ್ಲ ಅಲ್ಲಿ.
Number ಹೇಳಿಲ್ಲ, but intercity ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಅಲ್ಲ, intercity train going from this city to the Shivamogga. Whatever goes in between intercity. ಅದು next
Was there any train in that road, in that lane?
Yes. Next.
Any train earlier to 3 o'clock?
Yes. It 1:30 ಇಲ್ಲಿಂದ ಹೊರಡೋದಿದೆ. ಅವನು ಹೇಳ್ತಾನೆ 1:45 ನಾವು ಇಲ್ಲಿಂದ ಬಿಟ್ಟಿದ್ದು ಅಂತಲೂ ಹೇಳ್ತಾನೆ.
Lords,
it is a statement, it has come.
From 11 o'clock in the morning to 7 o'clock in the night, my lords, those 2 stations, there are trains passing by. My lords, intercity train is this one. And my lords, others it says passengers, so on and so forth. But my respectful submission, my lords, in the cross.
Now, what time the train passes in that line? Was there any
Earlier train.
Earlier to the 3 o'clock?
Yes, there is.
Body was found at the distance of 27 kilometers.
27 kilometers to 37 kilometers, somewhere in that stretch, my lords.
ಬೇರೆ ಯಾವ್ದಿದೆ the train ಇಲ್ಲಿ?
There is that another train starts around 1:30 from Bangalore.
1:30 ಇದೆಯಾ?
ಹೌದು.
ಏನಿದೆ ಅದು?
ಅದ್ರಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ ನಾನು 1:45 ಬಿಟ್ಟಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. ಅವನ
ಯಾರು?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಫ್ರಾನ್ಸಿಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಅದೇ why you have not examined the brother of the deceased? That creates doubt. When the brother passed away
Yes.
in the railway accident, and also brother was there along with him.
That is one.
Why he has not
I've
been
explained,
examined?
because he did not tendered himself. He did not come, though he has.
Why ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
He has not come.
He was along with him.
Yes.
No, then. But his statement was recorded on the very same day.
Yeah, true. He was along with the dead body. At his instance, dead body was
Whether he had
transported
intimated the
to
family
MS
members?
Ramaya.
Whether he had intimated the family members immediately?
Yes.
My lords, that is not also.
That first claimant has proceeded.
First claimant are,
Our wife of this deceased.
what she says in his evidence, in her evidence.
She came to know about the incident around 7 PM. She stated that she has not gone to the.
7 PM.
4 hours later.
But 3 hours.
She has gone to the hospital.
Along with the, ಅದೇನಾರು ಇದೆಯಾ ಆಸ್ಪತ್ರೆಗೆ ಹೋದ ಬಗ್ಗೆ?
ಅದು ಅಲ್ಲಿ inquest report ನಲ್ಲೇ ಇರೋದು.
Inquest ಅಲ್ಲಿ ಇದೆಯಾ?
ಇದೆ.
ಏನಂತ?
She.
At about 7 PM, I came to know about the incident.
After that, she says, my lords, may I read, my lords. She says, I did not go to the incident spot. My brother-in-law was in the spot. The train was stopped after the incident. I do not know the whereabouts of my brother-in-law. Hence, it is difficult for me to produce him before this court. I did not inquire to the other details. I did not inquire as to how the incident happened.
ಆಯ್ತು ಮಾಡೇ ಮಾಡ್ತಾರೆ, ಅದೇ ಹೇಗಾಗ್ತದೆ? She was under shock ಅಲ್ವಾ?
And my lords, she says, the next line, she says, I do not know the name of the hospital where the body was transported.
Inquest ಎಲ್ಲಿದೆ ರೀ? A3.
A125. So statement, along with the statement, inquest, and as well as FIR. I don't have the copy here.
Even inquest ಅಲ್ಲೂ ಟ್ರೈನ್ ನಂಬರ್ ಹಾಕಿದಾರಲ್ರಿ?
That is my point, that very statement of.
16201. Intercity. ಆಯ್ತು, ಟ್ರೈನ್ ಸ್ಟಾಪ್ ಎಲ್ಲ ಮಾಡಿದಾರಲ್ಲ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ದಿ ಇನ್ಸಿಡೆಂಟ್.
Lords, that is what they.
ಚೈನ್ ಎಳೆದು ಸ್ಟಾಪ್ ಮಾಡಿದ್ವಿ ಅಂತೆಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾನಲ್ರಿ ಅವನು. Immediately after the incident, chain was pulled and stopped the train also. That is what his statement on the very same day of the incident.
That is rebutted, my lords, in the evidence to say that if a chain of a train is pulled, my lords, and a train is stopped anywhere in the journey, immediately, my lord, that information.
ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು, ಹೇಳ್ಬೇಕು, ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕು ಎವಿಡೆನ್ಸ್.
A3 document A3. Please, the fellows have written. Nowhere in the statement of other witnesses.
A3 ಹೇಳಿದ್ದು, ಏನು ಹೇಳಿ?
ಅದಲ್ಲಿ inquest ಅಲ್ಲಿ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಆಗಿದ್ದದು 6 that train number.
ಇದೆಯಲ್ಲ ಇದರಲ್ಲಿ.
ಹೌದು, ಅಲ್ಲಿ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಆಗಿದ್ದು. ಇವರ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇಂಥ ಟ್ರೈನ್ ನಲ್ಲಿ ಅಂತ ಹೇಳಿಲ್ಲ. ಅವ್ರು ಇಂಟ್ರೆಸ್ಟ್ ಒಂದು ಸೀಟ್ ಬದಲಿ ಟ್ರೈನ್ಗೆ ಹೋಗಿದ್ದು ಶಿವಮೊಗ್ಗಕ್ಕೆ ಹೋಗೋದಕ್ಕೆ ಅಂತ ಹೇಳಿ. ನಾವು ಅಲ್ಲಿ ಒಟ್ಟಿಗೆ ಟ್ರೈನ್ ಹೋಗಿದ್ದು 1:45ಕ್ಕೆ.
ಇದು ಅವತ್ತಿನ ದಿವಸದ್ದೇನೆ ಅಂದೆ.
An inquest is done in the presence of the brother, my lords.
9/7.
Timing
19/7, my lords.
9/7 ಅಂತಿದೆ.
ಸುಮಾರು 1:40 PM ಗೆ
1:40 ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಬಂದ್ವಿ ಅಂತ. ಹೌದು.
ಇಂಟರ್ಸಿಟಿ ರೈಲು ಗಾಡಿಯಲ್ಲಿ ಪ್ರಯಾಣಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದೆವು
ಅಂತ ಅವನ ಬ್ರದರ್ ಹೇಳಿರೋದು. ಹೌದು.
ಹೇಳಲಿಲ್ಲ.
He
has not stated any number.
Train number.
ವಿಚ್ ಟ್ರೈನ್ ಇಂಟರ್ಸಿಟಿನ ಇನ್ನೊಂದು ಟ್ರೈನ್ ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತು?
ಆಯ್ತು, ಇನ್ಕ್ವೆಸ್ಟ್ ಆಗಿದ್ದೆ ಅವಾಗ.
ಅದೇ ಸೇಮ್ ಡೇಟ್.
ಮತ್ತೆ ಅದ್ರಲ್ಲಿ ನಂಬರ್ ಬಂದಿದೆಯಲ್ಲ ಅಂತ.
ಅದರಲ್ಲಿ ಬಂದಿದ್ದು ಅವರು ರೈಲ್ವೆ ಅವರು ಬರ್ದಿದ್ರಿಂದ ಅದನ್ನ ನಂಬರ್ ಹಾಕಿದ್ದು. ಅವರ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇದೆ ಅದು. ಇದು ಅವು ಇಂಟರ್ಸಿಟಿ ಅಂತ ಎಲ್ರು ಹೇಳಿದ್ರಿಂದ ಬರ್ದಿದ್ದೇವೆ ಅಂತ ಹೇಳಿ.
ಆಯ್ತು, ದಟ್ಸ್ ಆಲ್. ಆಯ್ತಾ
ಅಷ್ಟೇ
ಇಬ್ರದು.
That is the clarification I wanted to make in this.
Told. Heard the appellant counsel. Also the counsel appearing to the respondent. The present miscellaneous appeal is filed. Others need not wait. Others need not wait. The claim petition. Told this miscellaneous first appeal is filed against the dismissal of claim petition filed by the claimants before the railway tribunal. Next para. The factual matters of case of the claimants before the railway tribunal that on 21/2/2017 at about 10:30 PM. ಇದಲ್ಲ ಇದು ಬೇರೆ ಮೇಡಮ್ ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ರಲ್ರಿ 7159 ಇದು ಕೊಡಿ ಇನ್ನೊಂದು. ಅದನ್ನ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಕೊಟ್ಟಿದ್ರು ನೋಟ್ಸಿಗೆ ಮಾತ್ರ ಕೊಡಿ, ನೋಟ್ಸ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ. The factual matters of the case of the claimants that on 19/7/2011, when the deceased was traveling from Bangalore to Shivamogga in the train, along with the brother Francis, in order to return back to their native place, that is Shivamogga. Both of them have purchased a ticket and boarded the general compartment of train. When the train was on the run between Gollahalli and Doddabale railway station, near RKM number 1032/100.200, the deceased is alleged to have accidentally fallen down from the running train due to jolt and jerk. He sustained head injury and died on the spot. His brother Francis, who was traveling with him, saw him falling and shouted, and other co-passengers caused the train to stop. On alighting from the train, which stopped at a distance of about 100 meters, his brother saw him dead body and hence made the claim before the railway tribunal. The respondent appeared and filed the written statement denying that he was not a bona fide passenger at the relevant time of the deceased incident. It is a case of suspicious death and not an untoward incident. It is also contended that deceased became a victim of his own criminal act and careless attitude. The very fact is that train number 16201 leaves Bangalore railway station at 4:30 PM and passes the spot of the alleged incident much after 4:30 PM, whereas the body was found lying at kilometer number 32/100.200 between Gollahalli and Doddabale on 19/7/2011 at 15 hours. And hence it is very clear that the deceased was not travelled in the said train bearing number 16201 and hence not entitled for any compensation. The railway tribunal framed the 4 issues, and first applicant, who is the wife of the deceased, was examined as AW1. Exhibit A1 to 11 were marked. Railway did not adduce any oral evidence but marked DRM's report as R1. The railway tribunal, after perusing both oral and documentary evidence while answering issue number 1 and 2, taken note of death was due to accidental fall from the moving train, which was mentioned in the 173 report. But body was dragged for 100 feet from the spot and the train was stopped thereafter. The railway tribunal comes to the conclusion that the very claim made by the claimants is suspicious. But no doubt that the body was found lying near the track between the upline and the downline of Gollahalli and Doddabale railway station. On close scrutiny of the document, it is seen that Keyman reported that he saw the body lying by the side of the track, whereas as per the deposition of AW1, brother of the deceased was traveling along with him, whose statement was also recorded and produced by the applicants marked as Exhibit A4. In the said statement, Francis, brother of the deceased has stated that he had purchased the ticket for himself and for the deceased as well, and had handed over the ticket to the deceased. He has also stated that they travelled by train number 16201, Intercity Express, and the deceased had an accidental fall from the train. The tribunal, taking into note of the same, the said Francis was an eyewitness to the incident is none other than the younger brother of the deceased. The reasons for not getting him examined as witness in this case by the applicant is quite baffling, and no explanation on the part of the claimant for non-examination and withholding the witness from being examined before the tribunal. And there was no any information is available on record to show that train was stopped after the alleged incident. The police had drawn the inquest at the spot in presence of Francis. According to AW1, the statement of Francis marked as A4. Francis has purchased the ticket. If the inquest was done almost immediately and Francis was present at that time, how was the ticket not recovered from the body of the person of the deceased as well as the brother? And it creates the doubt, and hence comes to the conclusion that the deceased was not a bona fide passenger, and no such untoward incident was taken place and dismissed the claim. The counsel appearing for the appellant would vehemently contend that the railway tribunal has committed an error in rejecting the claim petition and failed to appreciate both the documentary evidence available on record and also the oral evidence. It is contended that it was not specified the train number which can be seen from the marked statement Exhibit A4. It was also produced by the respondents that the induction of the train number was by the respondents. In the final report, it was concluded that death of the victim was due to accidental fall from the moving train. And in spite of it, the tribunal committed an error in coming to the conclusion that he was not a bona fide passenger, and the very approach of the tribunal is erroneous. For contra, counsel appearing for the respondent would vehemently contend that when the train number is specifically mentioned and the said train departures the Bangalore only at 4:30 p.m. And hence it is very clear that either the deceased or his brother traveled in the said train and only colluding with the police created the documents and made the claim. The counsel would submit that when the train departures at 4:30, question of laying the body at 3 o'clock and recovering the same and conducting the inquest prior to the departure of the train, is very clear that a fraudulent claim is made before the tribunal and the same has been noticed by the railway tribunal, and also made an observation that even if the brother of the deceased was traveled along with the deceased, ought to have been examined him and not examined him. And if he has been examined, real truth would have come out. And he was not examined with an intention to make the wrongful claim. The tribunal also assigned the reasons while rejecting the claim, and it does not require any interference. Having heard the appellant counsel and also the counsel appearing for the respondent, and also the grounds which have been urged in the appeal as well as the reasons assigned in the impugned order, the point that would arise for the consideration of this court are whether the railway tribunal committed an error in coming to the conclusion that he was not a bona fide passenger and not traveled in the train, and the same is not an account of death of untoward incident. Next, what order? Having heard the respective counsel and also on perusal of material available on record, the main case of the claimants that on 19/7/2011, deceased Raja traveled along with his brother Francis, and he accidentally fell down and sustained injury and succumbed to the injuries. Between Gollahalli and Doddabele, that is at 15 hours. On the other hand, it is a contention of the respondent that the intercity train starts at Bangalore at 4:30 p.m. That is train bearing number 16201 and passes the spot of the alleged incident at 7 p.m. and not at 3 p.m. as claimed by the claimants, and the very claim is doubtful. No doubt the claimant wife has been examined as AW1 before the railway tribunal, and the AW1 is only a hearsay witness, speaks about the incident only on the documents as well as oral evidence. In the cross-examination of AW1, she also categorically says that on the date of incident, her husband, along with his brother, gone for painting work, and both of them left Shivamogga. At about 7 p.m., she came to know about the incident. She did not go to the incident spot, but her brother-in-law was present, was at the spot. The train was stopped after the incident. And she also did not inquire as to how the incident had occurred. And also she do not remember the date on which the statement of her brother-in-law was recorded by the police. But she says she remembered that his statement was recorded. The witness denies the suggestion that her husband at no point of time had traveled with his brother Francis by train number 16201. and also denies the suggestion of colluding with the police, the said claim was made. It is also important to note that the railway has not examined any of the witnesses except marking of R1 DRM report. On perusal of A1 FIR, it is clear that the incident was taken place at the distance of 27 kilometers from Yeshwantpur railway station. And the information was received at 0.5 hours. And information was also sent on the very same day at 15:30 hours. It is also important to note that keyman has sent the information as per A2, and the same was received at 0.5 hours, and FIR was also registered. The inquest was also conducted as per A3, and no doubt the train number is mentioned in the inquest as 16201, Bangalore city to Hubli, intercity rail. The brother statement, the brother of the deceased statement was also recorded as per A4, wherein he categorically says that both of them went to railway station at 1:40 PM and traveling in the train. And rightly pointed out by the counsel appearing for the appellant that nowhere the train number is mentioned in the statement of the brother of the deceased, which was recorded. And so also the A5 is the statement of keyman of the railway. He also doesn't disclose us anything about and he also says that he fell down accidentally from the train number 16201. And also he categorically says that the brother of the deceased, Francis, only gave the name of the deceased as Raja, and both of them were traveling in the said train, and accidentally he fell down. The other statement is A6 is the wife and not the material statement. However, taking into note of A7, post-mortem report is very clear that cause of death is due to multiple injuries sustained. It is important to note that when the very key man of the railway department has intimated the death immediately, and when the claimant as well as the brother of the deceased who was traveling in the train and categorically stated that at 1:40 they left the Bangalore to go to Shivamogga, and A4 and A5 is marked, and also the key man also given the details about that Francis only gave the information that both of them were traveling in the train, and merely because the train number is mentioned as 16201, and the same is not at the statement of brother of the deceased, but the same is at the instance of the key man and also the case diary, the same is mentioned. Who gave the details of that trail number 16201? Nothing is placed on record. And if really the train number is 16201, it would have been forthcoming in the statement of the brother of the deceased who was traveling along with the deceased. It is also important to note that the said brother has not been examined before the railway tribunal, but during the course of cross-examination, the statement of brother of the deceased, that is A4, was not disputed in the cross-examination of AW1, and except relying upon the DRM statement by the railway, not placed any cogent evidence before the tribunal with regard to the fact that the train number 16201 was involved in this incident. And hence the very contention of the respondent counsel that train departures at 16:30, that is train number 16201, cannot be accepted unless a rebuttal evidence is placed before the court that the deceased traveled, the deceased not traveled in that train, as well as timings is concerned, no cogent evidence is placed. And when such being the case, when the FIR was registered at the instance of Keyman, who gave the information to the station master, and immediately after the incident also, FIR was registered at 3.05 hours, that is 15.05 hours, and there was no any delay in registering the case and conducting the inquest. And when such being the case, the very contention of the respondent counsel cannot be accepted, and the railway tribunal also failed to consider the document of A1 as well as statement of A4 and A5. And A5 statement is none other than the statement of key man who gave the information to the concerned police immediately after the incident. And his statement also very clear that the brother of the deceased only gave all the information to him. And hence it is very clear that he was very much present at the time of the incident. And the very contention that the brother of the deceased was not traveled along with the deceased also cannot be accepted. And the statement of A5 is very clear, who is also the employee of the railway department, and railway also conducted the investigation and filed the final report. Early the final report adu? Final report mark agilva? Mark agilla, hange reference. And final report was not marked. However, the tribunal.
R1 last page.
The tribunal also, while passing an order, taken note of reference of the final report in ಎಲ್ಲ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಬಗ್ಗೆ ಡಿಸ್ಕಸ್ ಮಾಡಿದಾರ್ರಿ. ನಾಟ್ ಮಾರ್ಕ್ಡ್ ಬಟ್ ರೆಫರೆನ್ಸ್ ವಾಸ್ ಮೇಡ್. ಅದೆಲ್ಲ ನೀವು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿರಿ ಮನೆ ಎಲ್ಲಿದೆ ಹೇಳಿ.
Lords, and
I also saw the same.
One more aspect, Lords, the key man.
Second one.
Unmarked, page number, para number 11 ನಲ್ಲಿ last portion, just above 12th para. Under section 173.
Railway tribunal discussed the same. Filing of final report in paragraph number 11. Both with regard to the postmortem report and also the investigation that police have filed the final report before the executive magistrate Nelmangla under section 173 of Code of Criminal Procedure, wherein also it is concluded that the death was due to accidental fall from moving train. And even though discussed the same, but not considered the same while assigning the reasons. And final report also very clear that an untoward incident was taken place and he fell down from moving train.
That's factually just one aspect, Malad. The statement of the keyman is before me. I'm just, he has never mentioned the train number, Malad. He's never said 16201 in his statement. It's just a one para statement, Malad. Malad, this says, I am stating the fact that I'm working as keyman in gang number 1 of YP.
A5. ನೀವೇನೋ ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್ ಹೇಳಿರ್ಬೇಕು.
No, Malad, this is a signed statement.
ಮೃತನ ತಮ್ಮನ ಮಾಹಿತಿಯಿಂದ ಹಾಗೂ ಸೇರಿದ ಜನರು ಮಾತನಾಡಿಕೊಳ್ಳುವುದನ್ನು ಗಮನಿಸಲಾಗಿ ಈತ ನಂಬರ್ 16201 ರೈಲು ಗಾಡಿಯಿಂದ ಆಕಸ್ಮಿಕವಾಗಿ ಬಿದ್ದು ಮೃತಪಟ್ಟಿರುವಂತೆ ಕಂಡು ಬಂದಿದೆ.
Malad, along with
statement.
the same day, the statement which was recorded, Malad, on the statement which was recorded on that day, which is marked, Malad, along with the DRM report by consent. There he does not say anything about a train number.
But A5 ಇದೆ ರೀ ಇಲ್ಲಿ ಅದನ್ನೇ ನಾನು ರೆಫರೆನ್ಸ್ ಮಾಡಿದ್ದು ನಾನು.
Plus, but in R1 he says something else.
ಅದು ಮಾರ್ಕೆ ಮಾಡಿಲ್ಲ ನೀವು ನಾವೇನ್ ಮಾಡೋಣ?
His R1 is
not ಮಾರ್ಕ್ ಬಟ್ ಅದನ್ನ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿಲ್ಲಲ್ಲ, ನೀವು ಕ್ರಾಸು ಮಾಡಿಲ್ಲ, ಎಂತದ್ದು ಇಲ್ಲ. ಏನಾಯ್ತು ಮೇಡಮ್ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್? Having perused all these materials, it is very clear that immediately after the incident was reported to the police, and police have also registered the case and thereafter conducted the inquest, and also the final report was also filed by the police. Railway police yaro? Railway police. After the investigation under section 173 of the CRPC, and when such being the case and the same has not been reported by the railway by adducing any evidence, and the railway tribunal accepted the contention of the railway without any material, that too accepting the R1 DRM's report, which is the self report of the railway, and nothing on record rebutting the very investigation conducted by the railway police, and railway police only filed the report, and only suggestion was made that with collusion with the railway police only case has been registered, and in order to comes to such a conclusion that with the collusion only claim was made, nothing on record to comes to such a conclusion, and the railway tribunal not consider the material on record in a proper perspective, and committed an error in dismissing the claim petition. Hence, I answered the point as affirmative. In view of the discussions made up, I pass the following order. Appeal is allowed, impugned. Order passed by the railway tribunal is set aside, and consequently the petition filed by the claimants are allowed. ಯಾವ ವರ್ಷದ ಇದು
11 months.
11 ಆದ್ರೆ 4 lakhs. Maximum interest ಎಲ್ಲ ಸೇರಿ 8 lakhs. ಅಷ್ಟೇ. ಏನಾಯ್ತು ಮೇಡಮ್? ನಿನ್ನೆ ಯಾವ್ದು ಮಾಡಿದ್ದಲ್ಲ ಸೇಮ್ ಆರ್ಡರ್. Operative portion. The claim, the incident was taken place in 2011, and hence the claimants are entitled for an amount of rupees 4 lakh, and along with interest, the maximum amount is only rupees 8 lakhs. ಬೇರೆದೆಲ್ಲ ಡೇಟ್ ಕೊಡಿ, ಯಾವ್ದಾವ್ದು ನೋಡಿ.
With your lordship's kind permission.
Deeply obliged.
Item number 49, my lord. Item number 49. 49, my lord.
46. ಆಯ್ತು ತಗೊಳ್ಳೋದ್ರಲ್ಲಿ ಹರ್ಡ್ ದಿ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಹಾಕಿ ಯಾವತ್ ಮಾಡ್ತೀರಾ?
21ನೇ ತಾರೀಕು.
21 ನೋ ಸಿಟ್ಟಿಂಗ್, 22 22nd. 22nd. ಆಯ್ತು 23 ಆಗುತ್ತಾ? 23 ಆಯ್ತು.
Item number 49 in the list, my lord.
48 MR ಹಿರೇಮಠದ್
48 this matter on ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಏನೇನೇ ಯಾವಾಗಲೂ ಇತ್ತಲ್ಲ ಇದು ಇಮೇಜ್ ಹಿರೇಮಠದ್ ಚಂದ್ರಚೂಡು. ಆಯ್ತು ಹಾಕ್ಬಿಡಿ ಯಾವ್ದಾರು ಡೇಟ್ 30/10 ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. 49 ಅವ್ರೇನೋ
49 it may kindly posted on 7th November, my lord.
7th ಕೊಟ್ಟಿದೀವಿ. ಆಯ್ತು 7
Obliged, highly obliged.
ಅರ್ಜೆಂಟ್.
Tanveer Pasha.
51 ತನ್ವೀರ್ ಪಾಷಾ 29/10 ಅಂತ ಕೊಟ್ಟಿದೀವಲ್ರಿ ಡೇಟ್. ಅವಾಗಲೇ ಬೆಳಗ್ಗೆ ಯಾರು ಕೇಳಿದ್ರಲ್ಲ ಅದಲ್ವಾ?
50 ಕೊಟ್ಟಿರೋದು ಸರ್.
50 50
ಬಸವರಾಜ್
50 ಕೊಟ್ವಾ 29/10 ಆಯ್ತು. 51 ಯಾವಾಗ? ತನ್ವೀರ್ ಪಾಷಾ ಅದು ಕೊಡಿ 30.
52 ಗೀತಾ ದೇವಿ.
ಗೀತಾ ದೇವಿ ಅದು ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 4/11 30 29 ಜಾಸ್ತಿ ಹಾಕಿದ್ರಿ ಅನ್ಸುತ್ತೆ.
53
ಹ್ಮ್
ಪ್ರವೀಣ್ ಕುಮಾರ್ ರಾಯ್ಕೋಟೆ.
ಅದು ಅಷ್ಟೇ 4/11.
54 55 ಆಗಿದೆ ಸರ್. 56
2006 29/10.
57 Anton. 58 for respondent, my lord.
29/10 29/10.
59
ಆಯ್ತು 4/11.
60
ಇದು ಅಷ್ಟೇ 4/11 2013. 61 4/11 ಅಷ್ಟೇ ಅಲ್ಲ? 48 ಆಯ್ತಲ್ರಿ ಈಗ ತಾನೇ ಕೊಟ್ಟವಲ್ಲ ಡೇಟು. 48 30/10 ಹಿರೇಮಠದ್ದು ಚಂದ್ರಚೂಡ್. ಎಷ್ಟಾಯ್ತು ಮೇಡಮ್ ಇವತ್ತು? ಡಬಲ್ ಡಿಜಿಟ್ ಬಂದ್ವಾ?
61 date. 61. Sir, 61 ಸ್ವಲ್ಪ ಫೈನಲಿಂಗ್ ಇದೆ ಸರ್. ಅರ್ಜೆಂಟ್ ಇಲ್ಲ, ಅನ್ನ ಪಾರ್ಟಿ ಅರ್ಜೆಂಟ್ ಇದೆ.
ನಿಮ್ ಲಾಯರ್ ಇದಾರ ಇಲ್ಲಪ್ಪ? ಯಾರು ಮತ್ ಲಾಯರ್ ಎಲ್ಲಿದ್ದಾರೆ? 60 ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್ ಎಲ್ಲಿದಾರಪ್ಪ ನಿಮ್ ಲಾಯರು?
ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್
ಮತ್ತೆ
61 ನೀವ್ ಯಾರಿಗೆ ರೆಸ್ಪಾಂಡ್?
ಲಾಯರ್ ಯಾರ್ರಿ?
ಕಲ್ಯಾಣ ಅಂತ ಮತ್ತೆ ರಾಜೇಂದ್ರ ದೇಸಾಯಿ ಅಂತ.
ಕಲ್ಯಾಣ್ ಇದೆಯಪ್ಪ, ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್ ಅಂತ ಇದೆ. ನೀವ್ ಯಾರಪ್ಪ ಇದ್ರಲ್ಲಿ ಅಪಲೆಂಟ್ಸ್? ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. ಎಲ್ಲಿ ನಿಮ್ ಲಾಯರ್ ಎಲ್ಲಿ? ನಾವೀಗ ಹೇಳಿದ್ವಲ್ಲ ಇರೋದು ಬೇಡ ಅಂತ. ಇವತ್ತ ಡೇಟ್ ಕೊಟ್ಟಿದೀವಪ್ಪ 4/11 4ನೇ ತಾರೀಕು. ಅರ್ಜೆಂಟ್ ಇದೆ ಅದಕ್ಕೇನೆ ಕೊಟ್ಟಿರೋದು 4/11. ಇಬ್ರು ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು ಇರ್ಲಿಲ್ಲನ್ರಿ? ಆಯ್ತು ಹಾಕಿರಿ ಯಾವತಾರ ಬೇರೆ ಡೇಟ್ ಆಧಾರ ಒಂದು ಹಾಕಿ. 25 24 ಆಯ್ತಮ್ಮ. 24ನೇ ತಾರೀಕು 24ನೇ ತಾರೀಕು ಮುಂದಿನ ತಿಂಗಳು. ಸಾರಿ ಮುಂದಿನ ವಾರ.
ಇಪ್ಪತ್ತೆರಡರದ್ದು ಯಾವ್ದು ಇಲ್ಲ. ಹಾಕಿದ್ವಿ ಇಸ್ಕೊಳ್ಳೋದು. ಅದನ್ನೇ ಇಸ್ಕೊಂಡು ನನ್ಗೆ ಬೈತಾರೆ. ರಾಮ ಇದನ್ನೇ ಇಸ್ಕೊಂಡ್ರದು ನೋಟ್ಸ್ ಬೇಕು ಅಂತ. ಆಮೇಲೆ ಇದನ್ ಕೊಡ್ಲಿಲ್ಲ. ಏನ್ರಿ ಹಿಂಗ್ ಕೊಡ್ತೀರಾ ಅಂತ ಕೆಟ್ಟ